Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today. It is Friday, August 7th, 2026, and we have a fantastic birthday to celebrate today. Our own mod, fantastic part of our crew, Green Eyed Cat, is having a birthday. She turns 21 today, so make sure everybody welcomes her in and says happy birthday to Green Eyed Cat. She has been a mod with us for quite a while now, has been a supporter of the channel for quite a while, so a very, very special shout out birthday to Green Eyed Cat. And with that, we are going to be continuing our coverage of Courtney Clenney. We are anticipating her plea hearing to be on Monday. So we are going to be looking back at all the hearings that have led up to her plea. So with that, get comfortable, settle in, and let's get started.
I was there when the fire started, 'cause I was the one who lit the match. And mind blown, mind fucked, I'm mining through the wreckage of what used to be my stuff, and now it's myself. I got $1 billion heart on $1 stone platter. I shouldn't blow my brains out here, just clean the place and that shit to splatter. I got $1 billion mind and a pocket full of butter. I wish I knew way to tell you I'm a liar. 'Cause you only live once, then you only live twice. The devil gives me back rubs and his hands are cold as ice, making sweet love to a mermaid on a rocking paradise. Every now and then, you just gotta roll it out. Oh my God, what have I done? In a minefield, wearing sneakers firefighters can't afford. I got $1 billion heart on $1 stone platter. I shouldn't blow my brains out here, just clean the place and that shit splatter. I got $1 billion mind, but my soul is in the closet. And you can mushroom cloud the world, but don't you dare reach for my wallet. 'Cause you only live once, then you only live twice. The devil gives me back rubs and his hands are cold as ice, making sweet love to a mermaid on a rocking paradise.
All right, welcome in, everybody. Welcome in. How's everybody doing today? It is Friday. It is Friday. It is Green Eyed Cat's birthday. We're going to have fun today. We are going to have fun celebrating Green Eyed Cat's birthday today. So if you haven't said happy birthday to Green Eyed Cat, please, please, please take a moment and do so. And let me welcome in everybody. How's everybody doing today? August 7th, 2026. We have Kaylee, hello, and Camilla, welcome in. William, good to see you. Good vibes, and Shirley Roth, hitting the like button as you're coming in. Snap, Fanny, good morning to you both. Elaine, good to see you. Good vibes, happy Friday. Hey, Shannon, good to see you. Kimbers and Granny Debbie coming in. Tammy and KS. Good morning. We made it to Friday. Yes, we did. Camilla, good morning to you. Welcome in. Hey, Debbie. Jeff, great to see you. Good afternoon to you. Court Watcher Denisha, good morning. Let's see. We have got Chris Wallace. Good morning. Sweltering 110. Wow, that is pretty hot. Hey, Kimbers, how are you doing? Let's see. Let me scroll up here where we went live. That's when everybody comes in. Hey, Treasure Hog, great to see you. Sherry, good morning to you. Mal, good morning. And Ladybug's mom, good Friday morning to you. It is Pizza Friday, too. Don't forget. Willow Johnson, great to see you. Good morning to you. Hey, William, welcome in. There's Green Eyed Cat saying hello. All right, let's see here. Carly Angel, good morning to you. Hope you have a wonderful day as well. Horse Welfare, hello, welcome in. Great to have you back. Hey, Hell Rider. TGIF to you as well. Just Girl Baking. Bama Green Eyes. Welcome in, both of you. Snap. Good morning. Great to see you. Mal, you've been 35 for a handful of years. I thought that you were 21, Green Eye Cat. That was my impression. Hey, James. Good evening from Thailand. Welcome in. Thank you for joining us. Bama Green Eyes. Hey, Renee. Sorry about your shoulder. Oof. Yeah. That just stinks. I've been there. I had a frozen shoulder for a couple, 2 or 3 days, 4 days. Ugh, just miserable. Absolutely miserable. I feel for you. So hopefully you'll heal up soon. Jen, hello to you. Great to see you, Mama C. Good morning. Cindy Davidson, welcome in. Izzy Real, good morning and happy Friday to you. Hey, Sherry and Christine, both of you, welcome in. Hey, Adrielle. I should say Andrielle, sorry about that. Lisa, good morning to you. All right. I think we've got everybody here. Green-eyed Cat, aw, you don't have to give us money. Thank you, everybody. It's been a year of changing milestones. Wouldn't want to be anywhere else this morning. Love you all. Thank you so much for that. And happy, happy, happy birthday. Happiest of days. May you dance like no one is watching. May your days be filled with love, laughter, and music. I hope you have a fantastic day, Green-eyed Cat. Jen, howdy y'all. Hope everyone's having a great Friday. All right, just to go baking morning, waving to all the peeps. All right, excuse me for that. Got a little frog in the old throat today. All right, so we are waiting for Monday to come around. Today is Friday. So we are waiting for Monday, and Courtney's plea hearing is set for Monday morning. And the details of her plea were not released yet. So we're going to find out on Monday. And I'm expecting it to be kind of like a mini trial, right? So it's going to be, I don't think it's going to be more than, well, we're going to have victim impact statements for sure. We should have some testimony because how can you sentence somebody or accept somebody's plea if you don't hear testimony? So I'm assuming there's going to be at least a little bit of testimony from, law enforcement, maybe a first responder, perhaps the medical examiner. And then we'll probably have victim impact statements. I'm sure Christian's family is going to talk. I would expect Courtney's family to talk as well. So it should be an interesting day. The family is on board. The family is on board with this. It is in our description. If you have not read our description yet, check out our description. I'll read it. But if you haven't heard it yet, the family attorney said, on behalf of the Obumseli family, I am pleased to announce that Defendant Courtney Clenney, the state, and the Obumseli family have reached a resolution that would avoid an unnecessary trial. The resolution will be made public at a sentencing hearing on August 10th at 10 a.m. Pleading guilty and accepting full responsibility will begin the process of bringing closure to a very tragic, life-changing event for the Obumseli family. So they seem to be on board with this. I mean, according to that statement. So I'm really interested to see what happens. Camilla, thank you for the, that's awesome, the party blowers. That's a good one. Susan, great to see you. Hey, Grampy, welcome in. Bing and Billy, good morning and good Friday to you as well. All right, so with that, if you were not with us yesterday, I think most of you were, but if you were not with us yesterday, Christian Obumseli, he is the victim here. He was 27 when he passed away. Courtney Clenney is the defendant. She was a bodybuilder. She was a model. And then she most recently got more famous through her OnlyFans and Instagram, TikTok. And she made, I think it was 1.3 million. I think that was it. She made like 900,000 one year. Do I have that still? Yeah. So in 2020, she made 966,000. And then in 2021, she made over 1.8 million. So all told, she earned like $3 million in those 2 years. And then of course this happened in April of 2022. she claims Christian was rushing her. They were arguing. He got back I think he picked up some sandwiches. I think it was Subway, but I'm not sure. But he picked up some sandwiches and they got in an argument, which they do. They got in many, many arguments. Police were called many, many times on them. And when I say many, many, I mean at least 3 that we know of, perhaps even more, but 3 that we know of. And she claims that he rushed her. She grabbed a knife from the kitchen block, and she says she threw it at him about 10 feet. And it strikes him in the chest, and he doesn't pass away immediately. So she calls her mom. This is the weird part. She calls her mom, and then calls her mom twice, and then calls 911 after neighbors reported a loud noise, and they called security, and security called 911 before Courtney did. So she's heard on 911. He's in the background saying, "I can't feel my arm." And eventually he does pass away about an hour later while she's being interrogated by the police. So, all right. So that's the backdrop. In case you guys were not with us yesterday, that's the backdrop. So today, like yesterday, we did her interrogation. Well, it was really her interview, because then she gets arrested in Hawaii a couple months later. She went to a rehab. So yesterday we ended with a couple hearings. One was evidentiary, trying to bring in her cell phone and explicit content, pornographic even, and then there was her bail ultimately was denied. So that's kind of where we left off yesterday. So now today we're going, and that was all 2022. I couldn't find anything for 2023. I'm sure there was a hearing, but I just couldn't find anything. So we're going to pick up 2024. This is going to be from February 1st, a hearing. And this is, the title of this was, she gets hit with a new felony charge. So I'm not quite sure what that is, but let's check it out. Let me just post this here so we all know what it is that we're watching. All right, let us get us over here. All right, so this is a hearing from February 1st of 2024. All right, so let's get to it.
So we have 2 matters in front of us today, essentially 2 matters. One involves a motion to compel discovery, and the other involves a petition for order to show cause, as well as several replies back and forth.
And Your Honor, just for some housekeeping issues, if Your Honor wouldn't mind.
Sure.
At this time, in case F22-14137, the state is filing an amended information. The defendant is still charged with second-degree murder with a weapon. We're adding another count of interception of wire, oral, or electronic communications, a third-degree felony.
Can we see it? We've never
been notified of it. We've never seen it, which seems to be typical these days.
All right, no, we're not going to have any of that here. If we're going to do any of the inappropriate comments or grandstanding, we're going to hold off on the hearing today.
Your Honor, while they look at that also, the state is also filing discovery with the court and handing over to defense a copy of the filing, as well as it's the warrants, Judge, that created the new case.
All right, Mr. Creto, you did your read just now, right?
Yeah, I did, Judge.
Okay, so we're going to keep it purely professional, and that includes everybody in the courtroom. So if it's not kept professional, then we're going to shut the hearing down today, and we'll do it on another day when it can be professional. Okay?
Understood, Judge.
Thank you. So no throwaway comments. Right.
With
You are
that,
in.
Judge, on behalf of Ms. Clenney, we're enter a plea not guilty, demand discovery, and request trial by jury.
Thank you.
And Your Honor, with that being said, we do have an information for the new case. If we can address it at the very end, or we can do it right now, it's up to Your Honor.
You can go ahead and address it right now.
All right. So, in case F242015, the state is filing a consolidated information, consolidating F242016, F242169. It is making Defendant A, Kim Dwayne Clenney, Defendant B, Deborah Clenney, Defendant C, Courtney Clenney. We're charging 1 count of offenses against computer users, third-degree felony for all 3 defendants. We have provided a copy to defense.
On behalf of Ms. Courtney Clenney, we have not guilty demand discovery and act of case we set aside.
Okay. And then for Ms. Deborah Clenney and Mr. Kim Clenney, who's representing them?
Your Honor, Kim Clenney and Deborah.
So Kim and Deborah are her parents. So this is them taking, I think it was Christian's computer, if I'm not mistaken. I think it was Christian's computer. If not, well, anyway, we'll continue to listen. But Kim is her father. He was in IT or is in IT. Deborah was managing Courtney's modeling career and then OnlyFans career. So that's when you hear Kim and Deborah, that's her parents.
Clenney were arrested.
Ms. Deborah Clenney and Mr. Kim Clenney, who's representing them?
Your Honor, Kim Clenney and Deborah Clenney were arrested day before yesterday in Austin, Texas. They were subsequently released. They will be appearing in Miami at some point to self-surrender at TGK. There is a $5,000 bond, so those bonds will be paid and they should be released, is the messages I'm receiving. But as of yet, we do not have counsel for them. Due to the nature and circumstances of what the state's allegations are, I don't think that myself or Ms. Puglisi can represent them. So we will get them counsel.
Does Your Honor want to set an arraignment date so that...
Well, I think that we need to set it for them to have attorneys and for us to make sure that they are represented. So I'm going to go ahead and set this as I would another case and set it for 2 weeks for court-rate attorney for them to come in with counsel. They don't have to be here as long as the counsel's filed a notice of appearance. That's fine. We'll do it the same as we would any other case. So 2 weeks for F-24
2015 A, B, and C.
A, B, and C. Yeah. 216 for court-rate attorney.
And you want the C to travel along with them, Judge, even though it was arraigned?
An arraignment will be scheduled that same day?
Yes. All right. So then let's go back to Ms. Clenney's case. For the motion, we're going to start with a motion to compel discovery, because I think that that's going to be potentially more straightforward, but we shall see. All right, so this is the state's motion to compel reciprocal discovery based on some things that have been turned over, some things that have not been turned over. So let's discuss what you are seeking at this point.
Judge, the rules of discovery are clear that the defendants have an obligation to, just like the state does, to affirmatively provide discovery within 15 days. There are, among those witness lists, reports, statements that are made by those listed witnesses. Some discovery since the state's initial filing in December has been provided. We received a video that we were requesting for over 30 days. That video was removed, had audio removed. There's clear communications in the video. Those are statements of those people. We are entitled to that. The defense, for example, yesterday amended discovery listing witnesses. That's perfectly fine. I provided the court a copy via email. So again, they just have to provide a list 15 days upon these witnesses becoming witnesses, assuming. So that also is contingent with statements, contracts, agreements. It's anything that would be in theory discoverable. So for example, if they retained an expert, a point of contention might be this person's retainer. This person, you pay someone $1 million, they might say whatever you want. The state has not received any retainer agreements, any kind of contract.
Zero throwaway comments. Okay, I understand what you're asking about discovery as far as experts, but
I was using an example, Judge, of a hyperbolic figure. My point is, and then that wasn't meant as a throwaway comment. It is a question of credibility what a witness might be paid, and the state is entitled to that discovery. To date, we have not received that. Similarly to the witnesses that were listed yesterday, the state did not receive any statements that might or might not have been made by these persons. Additionally, And pertinent to the collateral case is Mr. Clenney was listed by both the state and the defense, and the communications in writing by Mr. Clenney with the defendant's counsel are all discovery and need to be provided. So notwithstanding the fact that the state received some of those communications via a warrant to Ms. Deborah Clenney, those communications, all of them, are discovery to the state.
Is that in your motion to compel?
No, Judge. The point is that some of this became sensitive investigative issues once it was discovered by the state in December. So some of the matters I just could not approach because, frankly, I referred it to my immediate police because I'm not an arresting authority and I'm not an investigator, I'm just a prosecutor. So some of these matters I just could not disclose or pursue because then it would hinder that investigation. So, but it's just a basic obligation under the rules. There's no obligation for a defense attorney to invoke discovery. If they do, then they have to comply with it.
All right, so what is it that you believe that is outstanding that you are specifically asking for this time? I know that there were, it looks like the videos pertain to potential expert witnesses that I think at least one or two of whom have been listed. Yes, at some point the state is entitled to discovery regarding those expert witnesses if they've, drafted reports. They are entitled to their retainer agreement. But what is it that you believe at this point specifically that you are requesting that is in your motion to compel?
Yes, Judge. The state is requesting the names and addresses of all witnesses that the defendant has, quote, uncovered, because that's the words used by counsel. I'm not making a throwaway. That were present for any of these recordings, a list of the individuals that were present for the recordings that were made and provided. Specifically, there's several set of videos, but the studio video, for lack of a better term, one where there were 5 different takes, and there was a secondary video that looked to be outside. I don't know if that was only the defense's expert or other persons there recording it. Those people are pertinent for any discovery. The audio of the videos that were already provided. Anyone that was involved in the editing of those recordings as well. Particularly some videos were in slow motion. I don't know if that was a subsequent edit or anything else. That's obviously pertinent discovery. And then actually in the last line of our reply, I put statements and reports of any of the witnesses by the defense that exist in their care, custody, and control. That, and the state would just piggyback since they amended the discovery yesterday with some witnesses, whoever those witnesses are, if there are statements of those people.
All right, so there were some pretty big moments there. Her parents getting arrested, so I've got that. I have their body cam, and then I have a news report. They're trying to compel, state's trying to compel the defense to give over addresses of witnesses that they've quote unquote uncovered. Mr. Perito there was like saying, well, this seems to be happening a lot with the state. And he kind of got admonished. He got a little smack down there by the judge. So interesting. All right, so let's get to them being arrested, because we just heard that they got arrested. Let's investigate that.
Now at 5:30. Now at 5:30, the parents of OnlyFans model Courtney Clenney are facing charges tonight. It's connected to the investigation into her boyfriend's killing.
Now, we just learned minutes ago that Clenney's mother bonded out of jail. However, her father tonight remains in custody.
It is the latest twist in a story that has made international headlines. CBS News Miami's Anna McAllister has the new details and what they could mean for the case against Courtney Clenney.
According to the affidavit, Clenney's parents, Kim and Deborah, are accused of holding on to and accessing the laptop of Clenney's deceased boyfriend, Christian Obumseli. So what does this mean for the case? Well, I spoke to a local legal expert who weighs in. It's a criminal case that's turned into a family affair. Tuesday, Kim and Deborah Clenney were booked into the Travis County Jail in Texas. as their daughter Courtney sits in jail in Miami on murder charges.
We believe is incriminating evidence, and it goes to the cover-up, which my family has always believed.
Courtney, a former OnlyFans model, is accused of stabbing her boyfriend Christian Obumseli to death in their Miami apartment in 2022. Now, prosecutors say her parents accessed and took Obumseli's personal laptop from the crime scene.
Clearly, what they did was illegal. Clearly, the state attorney's office was correct in filing charges.
According to the affidavit, the Clenneys accessed or caused to be accessed the victim's laptop with knowledge that such access was unauthorized. So what does this mean for the case?
If law enforcement determines that there was some effort to either delete or try to alter or to do something with the contents that is contained within that laptop, then not only would you see the state attorney's office for Miami-Dade hold firm on the third-degree felony, there could potentially be additional charges filed.
An attorney for the Clenneys provided us with this statement that reads in part, "We believe the Clenney family has been targeted with some trumped-up charges to discredit them in the press and make their lives miserable. It stinks of a power play by the prosecutors to control the narrative." This Thursday, the state is seeking a gag order in the case. Now they've gone after Courtney's mom and dad in such a way that requires them to spend considerable time in jail without bond. If Kim and Deborah Clenney are found guilty, they could face up to 5 years in state prison. Reporting in Miami, Adam McAllister, CBS News, Miami.
Right, so it doesn't end there because the state prosecutor, Khalil, Cudnane, sorry, I'm sure I'm butchering your name, sorry. During the investigation in a separate computer crime charges against the Clenneys, prosecutors accessed a shared iCloud account. So it gets, again, this trial has like everything, or this case has everything. So the Clenneys are taking Christian's computer, trying to hack into it or they're trying to delete, incriminating evidence. Who knows? We don't know. But why were they trying to get into Christian's computer? Oh, they said it was shared. The defense argued that the account contained attorney-client privilege communication, including a Team Courtney group chat and documents outlining defense strategies. So ultimately, Mr. Quinnen there would have been brought as a witness into this case. So he's the prosecutor, but then he would have been brought in as a witness. So he was removed. And then, of course, the defense is like, oh, the entire, state's attorney office is tainted. Throw him off the case. But that did not happen. So it's, again, this trial or this case has just a little bit of everything. All right, so now let's get to their arrest. Let us get to their arrest. And I saw some of you saying they were treated with kid gloves. Now this is in
You don't have a weapon on you.
This is in Austin, and let's see how police treat them. Now they're not like being arrested for like being violent or shooting somebody or stabbing somebody. This is I guess white collar crime you would consider it if they're being accused of stealing a laptop. So were they treated a specific way? Well, let's see how they were treated.
I know you got your CHL, so. Oh, yeah. No weapon on you?
No, it's okay. Miss Clenney? Ben Ryan, I'm with the Travis County Sheriff's Office. We have a couple of detectives that are up the road. They're going to come down here and talk to you and your wife. Is your wife home today?
Yes.
Okay, not a problem. And then they'll kind of explain a little bit about what's going on. I mean, obviously, I think it's related to your daughter's case in Florida, but that's about all we really understand. There are warrants for you and your wife's arrest.
What?
I know. I'm going to let them explain that to you real quick, and so we can kind of get behind all that. And then we're going to try to make this as easy on you as possible, right? I mean, while they have warrants for your arrest, y'all aren't criminals. We're going to try to work through this as, low-key as possible today. They're going to explain that to you. I don't really have I don't know enough about the case to understand how this all works together. But they'll be here in a few minutes, and so...
Can I call our attorney?
In a moment, if that's what you'd like to do. And I understand that.
Right.
Is your phone in the truck?
Yeah.
Do you want to You want me to go talk to your wife first, or what do you want? What do you want to do? How do you want to handle that as far as that?
Back up in here and let me go tell her.
Okay. If you let me hold on to your phone, I don't want you to making any phone calls. We can let you put your truck up. I think that's reasonable. Or actually, I don't have the choice on that. Let me hold off. If it was my case, that's exactly what I'd let you do. Let me let them get here.
Well, I'm not going to talk to a detective.
I think that's fine. I mean, I don't have any. I don't have a dog in that hunt.
I can't imagine why there's a warrant for our arrest.
We get it. We're from Texas. We're from Austin here. This isn't our case. They'll talk with you about it.
That's
I completely understand. And before any questioning about anything pertaining to the case, you'll have your opportunity to speak with whoever you want.
Right.
Nobody's asking you anything, any specifics right now anyway. We're just visiting with you.
Yeah, I'm just trying to let you know that this is what's happening today. And by all means, we'll get your truck put up. We'll get the house locked up. Whatever we need to do in order to kind of.
Deborah's in the house.
Us in today?
Yes. So I know it's hard to wrap your head around.
This is insanity.
Yeah.
This whole thing is bullshit.
I have an opinion on that. I don't get to have an opinion on that, right? Professionally, they've ran this through the, they have a legal warrant for your arrest. We're helping facilitate that because you are here in our jurisdiction, but we were trying to do that as low-key as possible. At which point, when they get here, maybe we'll move into the house. We'll do whatever to kind of keep it.
What's in the house?
I don't think there's anything in the house.
That would warrant to search the house?
There is not a warrant to search the house currently.
There's 2 dogs in there. So.
Oh yeah, no. So I'll let them explain. I don't know enough about the case. I think when they explain it to you, you'll know what they're talking about.
Right.
And then the question of what your involvement in all that is, that I think you're on the right track. So anyway, that's just what this is. It's unpleasant. It's unfortunate, but we're just kind of
insanity.
We're at the mercy of that currently. So let's make sure they weren't far. Okay, yeah, they're on their way. We just had them parked a little further away. Yeah,
they're detectives from here.
They are not. They're detectives from Miami. So that's how come their understanding of they have a better understanding of the case than we do. Yeah,
I want you to watch her face.
Oh, she's going to be just as shocked as you are when they tell you.
I'm shocked.
Yes. You want to go down here and we can just sit with her?
Can I pull the car back in?
Let's hold off on that. I will probably let you pull the car in, or I'll get you to give me permission to pull the car back in, whatever that looks like here at the end. But if you want, we can just go sit on the porch. I'm trying to be reasonable, but at the same time, I want to make sure that.
You believe that? What the hell? Okay. I have to cancel the Ashley. I'm supposed to be here in 30 minutes.
Okay.
Oh, yeah.
Okay, Deborah.
So,
no, I'm not okay.
I know.
Nobody's going to hurt you. I understand. I mean, you're physically okay.
This whole deal is fucking bullshit.
We certainly understand.
We have nothing to do with the case. I believe me.
She was persecuted by that motherfucker, and she's getting persecuted now, and now we're getting persecuted.
You're going to have your opportunity. She has a court date this week, doesn't she?
Right.
Yeah. So she'll have. Believe me, we're both parents. We understand.
I'm not talking to that detective guy called Frank.
That's
you're right. You know
completely understandable.
Do we need to tell Morgan
why we would be getting arrested?
So, all right, we'll cross those bridges after you talk to them.
It's like a 3-ring circus.
I know. I'm sorry for y'all's inconveniences here. This is
okay. We'll just hold on to that. We'll get it back to you in just.
As long as y'all stay calm, we don't need to handcuff anybody or anything like that right this moment. So we'll let this conversation go. But I know that your temper, I understand it. But we'll respect that, right? So right now we don't want to detain anybody with the handcuffs, even though there are felony warrants. We certainly, I know.
What the hell?
They're going to explain it to you.
And you'll have your opportunity to speak with whoever you want.
And then, yeah, absolutely. However that looks, right?
Okay.
I mean, we're just going to go through.
Let me ask you this: will we really? Because I don't have our attorney's number memorized.
I'm going to call him.
I was going to say, I'm going to get a. So worst case scenario, I will get a phone number for your attorney. You can give it to me.
May I go press?
We'll figure all that.
Just hang on one second.
Let them do their part, and then we'll facilitate the second end of this.
Good morning,
gentlemen. This is Mr. Clean.
How you doing?
And his wife.
Dr. Perez from Miami-Dade Police. How you doing today?
I know you.
Good. I got you real quick.
Yes. 1 second. Let me just let him.
And you just, what was it that you just did?
All right, so he's asked to call his attorney. Okay. We just said that he'd be afforded that right after he spoke to y'all. If that's what he wanted to do, we've explained to them that there is a warrant for their arrest, and that you guys are the ones that could be able to kind of explain what any of that's about. And so that's both of their phones, his phone's in the truck, and her phone's in her hand. So that should be easy peasy. Okay.
Yeah, just let him know. He invoked already? He invoked already?
All he asked is if he could call his attorney, and then my guess is he will if you ask him about it, but that's the conversation you can ask. We told him we're not asking him any questions. He doesn't have to, that's something between y'all that he can discuss. And then, of course, they have all the, logistics of dogs and all that kind of stuff, which we'll work out after. I told him as long as they stay calm, we won't need to handcuff him. However, he is, upset that this is occurring. He does aware that they are being arrested today. So if he gets rowdy, then we'll go ahead and cuff him up. But I'm not expecting that at this point. If you guys, okay. All right. I just was telling them the exact same thing, is that no warrant for the house or anything like that. As long as
I'm gonna confirm on the
as long as you stay calm, we're not going to handcuff you or anything crazy like that. We'll give you an opportunity to call and take care of dog sitters, whatever other. We'll figure all those logistics out to make this as it's inconvenient, no matter how you slice it, as least intrusive as we can. So anyway, I'll let Jim talk to you, and then you guys might have questions about what this is.
Fine. Okay. So as Detective Wright, you already spoke to, I think you've been informed that you guys have a couple of arrest warrants issued out of the state of Florida. Okay, so you will be booked today under those arrest warrants. Okay, we are conducting an investigation out of the state of Florida. I'm sure you guys have a couple of questions for us, as we would have a couple of questions for you. If you would want to, we'd be happy to talk to you. If not, you do have the right to an attorney.
Well, what are the warrants for?
What are the warrants for?
But what is the charge?
The charge is, it's called A1506 out of the state of Florida. It's unauthorized computer access. Okay, so it's basically a hacking charge out of the state of Florida. It's a computer crime.
A computer crime?
Whose computer?
Again, those are details of the case that we'd be happy to discuss if it gets down to that.
This is insanity.
But it is involving a computer as well as other property. There's a subset of property that has come up.
Okay, we want to thank Morgan & Morgan for sponsoring this body cam video. I mean, I think it's pretty clear from the
all right. You said we have the phones, right?
Oh, yep.
Okay. All right, perfect. All right, so would you like to discuss this a little further?
No, I'm not going to talk to you about anything. Talk to our attorney.
I asked him, may I go put some shoes on?
So we'll handle that here in a second. Yes, we are going to get you shoes. We'll figure out if the dogs have food and water. We're going to take care of all those things, right? Yes, you're being arrested, but this isn't a violent offense.
This is the same charge on her?
Yes, sir.
It is the same charge.
That's insanity.
I know. So, yeah, I mean, I don't...
Whose computer are we supposed to have hacked with somebody's account?
I'm sorry?
Whose computer are we supposed to have hacked?
So basically it's unauthorized access to an electronic device, right? So
who's the electronic device?
Well, when you get booked, you talk to the judge, they'll give you a copy of the arrest warrant and you'll see all the details.
Okay.
I'm
not talking to these guys.
Then that's the ultimate answer, right? So if you were talking to them, then they'd probably give you more information. But if you're not, then we just get you booked in and what have you. Okay, so
I'm going to see about a patrolman.
Yes, thank you. Oh, I have a phone number for the one.
I'll take care of it.
Okay. Okay. So just be patient. Just have a seat. We're going to have somebody that'll transport you guys. We're going to figure out your shoe situation. We'll make all that happen.
My truck and my phone, and you come in with us to do what we need to do.
That's the idea. And so I don't know that I'll let you drive your truck just under the circumstances. If you would like, I can drive your truck in.
May I
this is your phone. No, they are going to be seizing your phones, both of your phones as part of
I
this.
can't tell her.
And actually, if you want to place that in.
Are you kidding me?
Yeah, you already took mine. Didn't you take yours?
No, his is in his truck, but it will be seized as well. before they run off with your phones, if there's some phone numbers or stuff like your attorney phone number, whatever, we can probably work out getting that. I've got a piece of paper and a pen. We can write those numbers down so you can make that call from the jail. I know it's.
Are there any phone numbers that you do need? So we can
Yeah, I
facilitate
need the
that?
attorney's phone numbers.
Okay, and they're in here.
And my business
There's
is
a
run
number
my
online
business
I
is run up
need
Is it
there.
all right if I get your phones? We get the phone
I
number.
need a number online.
You're gonna seize it?
We're seizing your phone, so I'm just getting to get it out of your truck.
I need to call the attorney on that phone.
Okay.
Because you won't probably answer about that phone call. There's a lot of phone numbers I need up there. I've run my business up that phone.
All right, since I'll let you hold the phone and then I'll write down, you can say names or not, or you can write down. Do you want to borrow my notepad?
Can I not just look at the phone?
I don't think he'll, well, that's his decision. If he wants to let you handle it, that's fine.
So what we can do is let you unlock it, and then I'll get the phones for you.
I'm not unlocking the shit for you.
Okay.
Is her phone locked? Is your phone locked?
Yeah, her phone is locked.
Then.
See, right there is why they should be handcuffed. I'm not locking any shit for you. They should be handcuffed because this guy is starting to spiral out of control. You don't know what he's going to do. That's why if you're arrested, you should be handcuffed. Because even though this is white collar crime and it's not a non-violent crime, he's starting to spiral out of control. He's swearing at the officer. That could be considered resisting arrest. We've seen that many times in the body cams. Grampy, you can attest to this. We watch the body cam of police all the time, and as soon as somebody starts swearing at you and getting in your face, you're resisting arrest. So that's why you always handcuff somebody. Always handcuff somebody because you just never know what's going to happen. So, my 2 cents.
So we need to look Frank's phone number up.
Okay.
I'm not gonna let crap for him.
Then we can figure that out.
I have no idea.
Yeah.
All right, let's talk about shoes for you, jacket, anything like that. Where would that be? We'll probably let you go in to get it. I'm just asking so I can get to decide, risk versus reward.
And I'd like to change a shirt.
No, please
I'm gonna leave you where you are. You're sufficient. I know it's not great, but it is sufficient
We're gonna
for.
coordinate that now. We'll facilitate that. You can't text her from this phone right now, okay? But we will facilitate.
You have a phone number for her? Okay.
I'm a fucking hacker. Like your fucking president.
Definitely not. I will not be here, sir. Honestly, that was the case.
Well, I'm leaving this stuff. What do you need from me?
If you just want to take your driver's license, that'll make it the easiest. And then we'll set the rest of it either in your truck or in the house, whatever works best for
Put
you.
my truck in, lock the house.
I will do that if you don't mind me doing so. I won't search your truck. I will just move it in or whatever. There's nothing. We'll talk about it in a minute. I can't believe that. I think the only thing that they are going to run warrants on is the 2 phones. So, and actually, the way it works in the state of Texas is I'll actually end up writing a paper for the 2 phones that allows it to be transferred out of state. But the district attorney's office has already been apprised of all of this and has already said that that's fine. So they actually authorized if we would need to search the house. I did not want that to be the case. Otherwise, we would have just knocked on your door this morning. We wanted to wait till you left because we're trying to avoid making this into bigger than it is.
Oh, you're waiting till I left?
Yeah, we were just waiting for you to leave. We actually, we thought that you left town or left the house around the same time yesterday, so we thought maybe that you'd be leaving again today. Anyway, neither here nor there. It's just a ongoing just problem from the whole I guess from even beginning, all related to your daughter's event, which is, I'm a homicide detective, so I asked a lot of questions about that event, just trying to wrap my head around it or whatever. And, I'm 50-50 at not seeing the crime scene and hearing all the evidence. I don't really know where I stand on that. I know the court of public opinion is out there. And then we've seen, I've been doing this 28 years, so I've seen a lot.
I mean, the defense doesn't say a whole lot.
Yeah.
Now you're convicted in the public opinion. A lot of people put out crap.
I think this has to do with something that belongs to him, is the computer or the whatever, laptop, iPad, I don't know what it is, something related to that. But it's something that I think it's something her attorneys were kind of working with y'all on.
Her attorneys?
Her attorneys is my guess. I don't know everybody's names involved.
I'm not aware of that.
Yeah. So ultimately, that's just my understanding, is that it was something to do with that. There's some device out there that y'all helped access that's not y'all's, and that's what this all stemmed for. Now, it is a felony offense in Florida. It's a misdemeanor here in Texas for the same crime, so that's why we're kind of afforded a little more leniency, whether we don't just slapping cuffs and putting you in the car and saying tough luck, right? We certainly are trying to be it's not our case. Matter of fact, I actually spoke with the detectives, and I was like, so if this was us, we probably wouldn't be arresting. Maybe we would just come and seize the phones and explain what the situation was. But their state attorney is the one that's...
Yeah, she's a fucking cunt.
Is that what the problem is? So...
She's the language. They're all correct.
Listen, I understand your frustration. System's never great.
Self-defense week 1 and 4 weeks.
I'm sorry.
Go ahead.
No, if you guys are in the middle of something.
He's venting, which I can appreciate.
I get it. How about I take her inside and get her shoes, and I'm going to have to escort her. Sorry, I need to.
That's fine. Am I going to be able to go use the bathroom? And no. I guess put this in the bathroom and make sure.
It's going to take us a few minutes to go anyway. If you just want to have a seat, and then I'll take her in there and let her.
You can stay standing if you'd like. It's not a big deal.
It's going to be a minute before we can go, so I'm sure we can.
I was going to say, think about dog water, whatever. The bond's only $5,000. Well, when he comes back, then we'll coordinate that. So I can't leave you unattended. I could handcuff you and put it here, but that sounds. We're trying to wait to the very last moment for that, right? So we don't create more drama for neighbors or anybody else, right? But yes, so there's a $5,000 bond, so it's very low bond. It is an extraditable warrant, meaning if y'all didn't bond out, they would take you to Florida. But $5,000 bond, I would hope that you would be able to, the two of y'all would be able to bond out relatively quickly. It's not gonna solve the whole this is what's happening thing, but for what that's worth.
What was your name again?
Ben Wright. And I'm with the Travis County Sheriff's Office. We got our supervisors got contacted by Miami-Dade Police Department saying they had these felony warrants. Detective Helleroot, or Deputy Helleroot, is actually a member of the United States Marshals Task Force. So I elicited his assistance today versus having patrol cars and everybody else in your cul-de-sac. Not that this isn't a little weird as it is, but as soon as Deputy Helleroot comes back out here, I'll pull your truck in and that'll look a little less weird.
Am I going to need a credit card? Or a bank card?
I don't know how that works, I'll be honest. I mean, if you have an attorney, then your attorney would probably handle that for you, like getting your bond and stuff set. But I don't know if you've got a credit card that you might want to just put because ultimately, I don't know if you're familiar with the bail and bond system or whatever, but if you put up the let's say for you and your wife, $10,000 worth of bond, and then you show up at whatever court date is assigned, well, you get your money back. If you go through a bail bonds company or whatever, they're going to charge you 10, 15%, and you just never see that money again, right? So it depends on where you are financially. If you have that money, then I would recommend, maybe put it on a credit card or whatever. Ultimately, as you go to court down the road, you'll get that money back. But those are your decisions. If you do want to do that, just think about it. I can have them grab, I can call him right now and just say, hey, grab a credit card to throw in your pocket as well. It doesn't hurt anything. to have it. You might need an Uber on the way home. I don't even know what that'll all look like, right?
It's out of phone.
Huh?
It's out of phone.
Well, they'll give you, well, yeah, okay.
I mean,
well, listen, it's a pain.
From one account to another, but I'm not opening the phone for anybody.
I'm not mad at you about that at all.
Not that I have anything to hide, but I'm just not going to give them the fucking satisfaction. Sorry about the language, but
that's okay.
Listen, all insanity. Is all
you have rights,
all about money.
We exercise our rights if it was us in the same boat, so I'm not mad at you at all.
That woman shouldn't be going anywhere. But this is how they play dirty. I'm telling you.
Yeah.
This is just the whole damn deal.
I am so sorry that you guys are going through it. It's stressful enough to have a child in the situation that your daughter's in, and then just to add this on top of it is unfortunate. And I just don't have any control over that.
I understand. You're just doing your job. But I appreciate you being here. But see. You want me to take the carpet out?
Yeah.
Thank you. That's kind of what I want to pull. And I knew they'd be coming.
Yeah. Well, we'll get that taken care of for you if nothing else. I know. It's just, you may leave whatever you want. I'm fine with that. I'm trying to be as lenient as possible on that. I mean, I don't expect you to be down there too long, but yes, I don't know if I mean, it's our jail's like, so theoretically, I'm probably never been arrested, which is a great thing. It's like a little bit like a bus station or a doctor's waiting room, right? So you're going to go, they're going to do the whole take your picture, get your fingerprints or what have you. And then there's like a big seating area where everybody just kind of sits and waits for magistration, which is where the judge will read to you what the charges are. That's not going to be super helpful or illuminating for you right now because he's not reading the entire charging document. He's just going to read what the warrants are for, which they've kind of already told you. Your attorney will get a copy of the entire arrest warrant with the PC affidavit, which is a probable cause affidavit, which will explain what their investigation revealed, and how they came to this decision to make this arrest. On paper, I see it. Like I said, I don't know if I necessarily agree with this being the direction I would have gone if it was my investigation.
That one comes over here.
What, this one?
That one's mine.
Okay, the tan lid one. If they don't get it right, we'll figure it out for you. Is there anybody you're supposed to be meeting or anything that you need to readdress? I know that's all tricky. I'm just, because then, even if there is, I'd be willing to maybe send a text message on your behalf, but that doesn't help me because you probably don't know their phone numbers, or if you do. I don't know. So I'm just thinking outside the box on things I can do to kind of minimize the impact this is going to have on you today. Anyway, it's where we are.
This is all about money.
See, now I think my wife would laugh at me if I wore my Rolex and but I get it. I like so I pick and choose family events, nice place, But
my daughter Courtney Davis all watches.
Yes, my wife. We gave our hand-me-downs to our kids. Very convenient to have. I don't know how parents did it back when we were young. I'm only 53, but. Not being able to know where your kids were. And, I mean, now when we pull it up on our phone, I can see how fast they're driving and everything else. Did you want to decide about the credit card?
I'm going to need a couple of cards.
I put my Apple in my purse. Should I put a different one? I mean, in my pocket. Should I go get it?
I was explaining to him about the bond being $5,000. Yeah, and just to kind of.
I need to get a credit card then.
Should I keep this one? Different one?
I'll go get mine. You're welcome.
I won't need one. Okay.
Yeah, no problem.
Can you go?
Somebody's going to go with her. Oh, you want to go instead?
Can I go in and get my card and use the bathroom?
Yeah, that's up to you.
I was just going to run an errand and come back. Let's go. Come on,
let's do it. Here you go. Oh, yeah, that's yours in your pocket. If you want to have a seat, I'm going to move his truck into the driveway for him. He asked me to do that.
Okay.
Are you calm? You good? I mean, as calm as you're going to be under this weird deal. All right. He and I were just discussing it. It is what it is. But I'm just going to have to go.
Shit is what it is.
My heart goes out to y'all. This is, I can't imagine. I'm a homicide investigator, so I recognize what collateral damage in these type of investigations, and we try to limit that as much as we can. That's just not, in this case, happening. So, I'm just going to pull his vehicle down. It just goes on the other side of yours. Is that yours is correct?
Yeah,
I'm going to lock it. I'm going to bring the keys. Do y'all have a way to get in without keys, or do you just take his keys with him? You can think about that. I'm going to lock his truck and bring the keys to you. Okay? Hey, I'm going to move his truck forward. She's just going to sit right there and wait. He's going to the restroom, and then we're going to transport when patrol gets here. I will let you help out in any way possible. This is a deal out of Miami, not us.
Maybe
So
can I, if I gave you Morgan's phone number, would you call her? Okay.
Here, you want to write her phone number down and I'll give it to him?
All right.
Take a deep breath. It's okay.
She's going to freak out.
Is Morgan your other daughter?
Mm-hmm.
Okay.
Oh, that's my number.
That's okay. Take a deep breath.
Tell her that they said we'll probably be out by the end of the day.
I got a longer arm.
Does she need to call you?
No, she doesn't need to do anything. But if we're not back by like 6, she'll need to come feed the dogs.
Okay. And Kim, does she have the key to your house?
Do you want Ron to hold the key?
Morgan has a key.
Okay, all right.
And the code, I can give you the code if we need to.
Here, I'll just let him write it down and I don't need to.
We'll put him in the house.
Okay.
Yeah, I locked your truck up. Windows rolled up. Yes.
Patrol's here.
I say that. Hang on. Did I?
I've got them both.
Oh, yeah. The other driver's license is the one. Yeah, thank you. Yeah, you got to look at it.
Oh, I'm glad you came home.
Yeah. Well,
Makes me feel a little bit better.
Yeah, just hand it to him. That way I don't have to worry about it. I don't want to know what your password is.
Okay.
I'm so sorry.
Yeah, all right.
She knows it.
Oh, okay. All right. Well, I don't need it unless you want me to do something.
No, but it can't hurt to have it.
Okay.
But thank you for calling her.
Well, yeah. No, that's no problem.
Put these in the house.
Yes, I will just set them inside and then lock the door.
I just had the dog.
Is there anything else? Okay.
Just need some phone numbers.
Everything. I know.
Frank.
You haven't done anything? We can look it up. You give me what's your attorney's name?
Well, I guess I need a phone number. Frank Prieta.
Frank?
But we also have an attorney here in town that Courtney's used.
Think about it and give it to us. Let me know, and we'll see if we can't find you. Ultimately, they have a list of phone numbers down there they can help you with. Like we try to, I
really need Frank's cell phone because he's not going to.
He's not going to know. Is he a criminal attorney?
I can call his office. I can talk to his secretary, Pam. Wish I'd change shoes.
I know. I'm sorry.
I don't make an ask.
What's the question?
Is that the one up on the hill so I can tell the daughter? I don't know where.
So they're going to the Travis County booking facility, which is downtown.
Oh, the one downtown.
Yeah, like right by the courthouse, 12th Street.
Okay.
So, and they have a really, I'm not going to tell your business, but yes, they should.
Okay, that's fine.
Yeah.
I'll give you a daughter call.
Well, they say we hacked somebody's computer, so.
Yeah, it's.
And it's felony in Florida, apparently.
Think they're out to persecute us?
Maybe.
Well,
Twist our arm. It's probably arm twisting.
That is an understatement.
Yes, that's right.
It is.
Okay, thank you.
Thanks,
I'll give her a buzz.
Right.
If there's anything you need to do, I'll talk to Morgan and that's much for
Okay. It's, tell her it's going to be okay.
Okay,
Tell her it's going to be okay.
Okay, all right.
It will be an inconvenience, but it will be okay.
Oh, Ron, will you also tell her that if Morgan tries to call, or Courtney tries to call her, please answer?
Oh, yes, I will.
Okay.
Yes.
Because they wouldn't let me answer Courtney's call.
Okay, no, I'll know.
Okay.
Okay.
All right. Give each other some hugs and stuff, right? Because once the patrol gets here and what have you, so give each other some hugs and stuff and some peer support. You're going to go to the exact same place. You're going to see each other, but they probably won't let y'all speak because they don't let men and women talk in the booking facility for the most part. So I was explaining to him while you were in getting your shoes. That's the whole weird, take your picture, get your fingerprint on the computer thing.
Pretty
I know,
much.
so yeah, give us
I was on my way to get brows and lashes dyed, so I had no makeup on whatsoever.
They're going to transport together, right?
Yeah, absolutely.
Let's go ahead and get you guys.
Okay. I'm so sorry. They're going to cuff you guys up. There's no way to avoid that. We're going to try to make that as low key as possible. Yeah, there's no way to avoid it. That's because that's transport rules. So we've done all we can to. Did he get the right trash can?
Yeah, he knows it.
Oh, okay.
Thank you.
I've locked your truck. Yes, I even made it honk to make sure. I rolled your window up as well.
Deputy Weaver, he's going to be over.
Mr. Weaver, I've explained that you are going to have to handcuff him up as per policy, so they're prepared for that. And that's it. You'll transport them.
Okay, cool.
Deputy Heller. Thank you. I appreciate your assistance keeping it low key this morning.
Yeah, no problem.
I know, as low key as we do in law enforcement. I apologize.
Thank you.
Okay.
And I'm going to need to visit with you for a minute here.
We will.
Y'all have our IDs, right?
Yes, he does.
Are we going to see you again, or me?
You probably won't see any of us again. Yeah. If you'll be addressing the courts in Florida regarding this, so. He didn't have Frank's number, and he didn't really have a real solution for that. What do you think? If I give you their office number? Okay, so if I Google that, we should be able to get there. Give me 1 second, I'm old.
You don't have any problems with your shoulder?
Get to Google.
Yes, I do.
Yeah, we actually both
I go to the chiropractor every week for it.
Okay. Florida, is that what you're trying to get a hold of? Okay. So let me write this number down and we'll put it in your pocket.
Isn't that with you? Yeah. Okay. I've got this watch too, so. No worries. Yeah. You look honest. Yeah, oh yeah. You can get. I'm gonna pat you down real quick right here. Okay. What was your detective? Why? This is my card. They are Miami-Dade. No, I mean the other one. Your guy. You can just either front pocket, whatever pocket you want to put it in. Doesn't matter to me. Okay. Alrighty. But I do understand I can do this. Okay, okay. Just pop in right there. My right shoulder's. Okay, I'll help you as best I can. All right.
No way you can lean on me.
I'm stuck here. So if you sit this, it's kind of, that's not, I feel like it'd be more comfortable if you try to put your legs up a little bit and just kind of, oh, I see what you're saying, the seatbelt's blocking it. There you go.
You know, could you tell my neighbor that I changed my mind? Maybe tell Morgan not to answer Courtney's call.
This is. Oh, what's wrong? What's it's. Okay, it's twisted up. Give me just 1 second. I'll fix it for you. Is this really necessary? Unfortunately, yes. It's just the way that the policy is.
Sir, would you do me a favor and tell my neighbor I changed my mind? I don't want him to tell Morgan to answer Courtney's call.
You don't want to tell Morgan?
I don't. I asked him to tell Morgan to answer Courtney's calls.
You're good. Okay.
I don't want him to answer, or I don't want her to answer Courtney's calls.
So he called, and of course it went to voicemail because it's probably a strange number. So I said, why don't you text her and tell her, hey, I'm your parent's neighbor. Please call me.
She knows who he is.
Okay, good.
But just don't tell her Morgan should not answer Courtney's call. calls.
Okay, this is gonna be a very short ride. There's no traffic right now, so we'll make it quick.
You sit forward now?
No.
Can I help you over?
No, we're back. I'm gonna cramp. I'm gonna these people now.
This is some type of arm twisting is what I'm convinced.
This is claustrophobic.
Is there any way I can grab you?
No, but it's too tight. It's too tight. Phones, taking the phones.
Yeah.
I'm about to go buy 2 new phones.
Thank goodness I didn't get a new one.
Got a cramp in my left shoulder now.
Anything I can do to help?
Thirsty too.
Sorry.
This is horse shit.
Not a word without an attorney, right?
Right.
Is that the one that tested?
Come on, let's go. We're gonna go. My leg bothering you?
No, it's not. That helps to lean. That's
All right, so that was Kim and Deborah getting arrested, and I've been posting, and if you guys weren't able to see that. So it's Christian Obumseli's laptop. After his passing, his laptop remained at the apartment. Courtney allegedly arranged for the laptop to be given to her parents after she left for Hawaii. Investigators later uncovered text messages in a group chat involving Courtney, her parents, and members of her defense team discussing how to access the laptop. The messages allegedly included attempts to guess Christian's PIN, with Kim Clenney later texting, "Hell yeah, that PIN worked." So the charges against Courtney and her parents were unauthorized access to Christian Obumseli's computer, not destroying evidence or altering files. So it was not Courtney's computer, it was Christian's computer. Prosecutors' theory was that they accessed his laptop without permission from his estate. Now, the defense is saying it was a shared computer used by both Courtney and Christian while they lived together. Courtney had permission to use it during the relationship. No files were deleted or altered. The computer crime charges were an example of prosecutorial overreach. Why the charges were, well, I'm not going to say yet, because this next, let's watch. I'll tell you the outcome. Let's watch this next video hearing. Maybe this hearing will tell us why. I don't want to spoil anything, but if we don't hear about it, I'll let you know what the outcome was.
all right.
Because we may hear the outcome in this hearing here. All right, so this is from June 26th. So this is a hearing from June 26th. And let me just pin this. Oh, shoot. Up here. Got to do it here. All right, just give me a second. Pin that. All right.
All right. You guys ready to go on Clenney?
All right. I'm handing up a copy of an initial order with my findings. I did get a copy of the defendant's reply to the state's reply to the defendant's supplemental briefing. Read through that yesterday. It didn't change what my order was going to be, but I am editing down the much longer version of this. I'm handing this up to you guys. I am granting the defense's motion in part as a motion. I'm treating it as a motion to exclude, and I'm granting it. So you guys can read through this, and I'm going to, and you'll see that in Mr. Clerk.
Yes, Judge.
And these up. You'll see that in this order, it references the fact that I'm going to supplement this on Friday with my longer version that has my analysis and reasoning that takes into account the most recent supplemental briefings as well. Okay?
Thank you, Your Honor.
Will we reset for Friday? You don't have to reset it for Friday. I mean, the findings are here. The findings themselves are not going to change, but I'm going to give you a much longer order with my analysis in it.
Well, we need that in order to have our office review it, so.
Absolutely. So we can reset it for Friday if you want.
We'll wait to get that order, Your Honor.
But it needs a future date anyway, so we can go ahead and give it a future status date in 60 days, and I can give you that order on Friday, or if we want to go ahead and set. There's obviously the second portion of your motion, which is the portion of the motion to dismiss that I did not address in this order. So you guys are just going to have to let me know what it is that you wish to move forward on.
So, Judge, first, would you like us to announce for the record?
Sure, yes.
Sorry, Your Honor. Chief Bushcombe, Mickey Radson on behalf of Kim and Deborah Clenney. I believe Tara Kawas on behalf of Ms. Courtney Clenney is on the platform.
She is on Zoom, yes, I see her.
Ms. Courtney Clenney is present in the box. Our clients are present in the gallery, Your Honor. We also have Diane Karamis, Frank Prieto, and Ms. Sabrina Puglisi, who represent Ms. Clenney on the homicide case.
Good morning, Your Honor. How goes on behalf of the state of Florida?
Hello, Claire, back to State Court. So, Judge, my request would be, given the court granting this order, understand there's a longer order coming and the state will need to do their review, maybe a 30-day reset, because this may, and I don't want to speak for the state, prove to be dispositive of the matter, and obviously it's in our interest to have this resolved and Ms. Clenney's case move forward in a more expeditious fashion. We'd agree to that.
Okay, so let's reset it for 30 days. I don't know whether it will prove dispositive or not, but let's set all cases for 30 days from now.
7/29, George?
7/29.
I'm going to be out of town, Judge.
We have the next week.
Yes. Next week is our waiting until the 8/12.
8/12?
That week is fine, yes.
Okay.
8/13 then?
8/13, that's fine.
8/13.
8/13? All right, I will see you all then. Thank you, Your Honor. Thank you.
Judge, if I may, on Ms. Clenney's, the F-22 case, we also have some motions pending that we've requested an evidentiary hearing.
Okay.
Do you want us to just schedule that with the chambers? It is related to this order, so once we digest it.
I mean, regardless, you can go ahead and set it. I mean, nothing in this order is dispositive to that case, so you can go ahead and set those whenever you want to, if you just want to go back to chambers and ask Anna for a date.
Okay, we'll work with the state.
All right, thank you.
Thank you, Judge.
Thank you, Your Honor.
All right. Anybody else I can call out of turn in the courtroom? Ms. Montaner? Good morning.
I don't see prosecutor here.
Mr. Abihoff is in the second phase of the death penalty trial, so he won't be here.
It was an announcement he had, which was what we were putting
Yes, I know.
He hasn't called me or said anything or responded. I knew he was in, he just let me know he was in.
Does anybody have any notes from Mr. Abihoff this morning?
No. Devon Thompson, page 11, Marlene Montaner on his behalf. Sorry about that.
All right, so any update from Mr. Abihoff on what's happening? I've reset multiple of his cases for Friday. That doesn't mean that he's going to be done by Friday, but I don't know what's done.
We started coordinating the depositions. We started doing the next Judge. I have somebody that went to evaluate him, I have done that, but I really do think that it's very important because I am not death qualified on the review myself.
This one, I know that he's not going to have this announcement yet. For sure he's not going to have it on Friday. So for this, I'm going to reset it for 3 weeks for him to try to get that announcement as to whether or not they're waiving death.
7/17.
I'm not going to be here the last 2 weeks of July, so either before the 7th, how about, or the first week of
All right, this is another case they're talking about. I'm trying to see if they actually come back or not.
When do you leave to go out of town in July?
That's actually questionable. I might get on a plane on 7th.
I think, okay, yeah, they do come back. Seems like they come back. Let's come over here.
Are you guys ready to go on Clenney? All right. I'm handing up a copy of an initial order with my findings. I did get a copy of the defendant's reply to the state's reply to the defendant's supplemental briefing. Read through that yesterday. It didn't change what my order was going to be, but I am editing down the much longer version of this. I'm handing this up to you guys. I am granting the defense's motion in part as a motion. I'm treating it as a motion to exclude, and I'm granting it. So you guys can read through this, and I'm going to, and you'll see that in Mr. Clerk.
Yes, Judge.
Hand these up. You'll see that in this order, it references the fact that I'm going to supplement this on Friday with my longer version that has my analysis and reasoning that takes into account the most recent supplemental briefings as well. Okay?
Thank you, Your Honor.
Will reset for Friday?
You don't have to reset it for Friday. I mean, the findings are here. The findings themselves are not going to change, but I'm going to give you a much longer order with my analysis in it.
We'll communicate that in order to have our office review it, so.
Absolutely. So we can reset it for Friday if you want.
No, we'll wait to get that order, Your Honor.
But it needs a future date anyway, so we can go ahead and give it a future status date in 60 days, and I can give you that order on Friday, or if we want to go ahead and set. There's obviously the second portion of your motion, which is the portion of the motion to dismiss that I did not address in this order. So you guys are just going to have to let me know what it is that you wish to move forward on.
So, Judge, first, would you like us to announce for the record?
Sure, yes.
Sorry, Your Honor. Jude Bushcombe, Mickey Radson on behalf of Kim and Deborah Clenney. I believe Tara Kawas on behalf of Ms. Courtney Clenney is on the platform.
She is on Zoom, yes, I see her.
Ms. Courtney Clenney is present in the box. Our clients are present in the gallery, Your Honor. We also have Diane Karamis, Frank Prieto, and Ms. Sabrina Puglisi, who represent Ms. Clenney on the homicide case.
Good morning, Your Honor. How hold on behalf of the state of Florida?
Hello, I'm back to State Court. So, Judge, my request would be, given the court granting this order, understand there's a longer order coming and the state will need to do their review, maybe a 30-day reset, because this may, and I don't want to speak for the state, prove to be dispositive of the matter, and obviously it's in our interest to have this resolved and Ms. Clenney's case move forward in a more expeditious fashion. We'd agree to that.
Okay, so let's reset it for 30 days. I don't know whether it will prove dispositive or not, but let's set all cases for 30 days from now.
7/29, George?
7/29.
I'm going to be out of town, Judge.
We have the next week.
Yes. Next week is our waiting list on the 8/12.
8/12?
That week is fine, yes.
Okay.
8/13 then, George?
8/13, that's fine.
8/13.
8/13. All right, I will see you all then.
Thank you.
Yeah, that is weird. We did just watch that. I'm like, wait a minute. Why did they put two of these together? All right, that makes no sense. That video makes no sense. All right. That video makes no sense to me. All right, well, we may eventually hear what happened, but well, you know what? Let's just keep going. Let's just keep going. I don't want to spoil it, because if they do say something, then we'll be like, there it is. Yeah, that video made no sense whatsoever. Somebody was doing some weird editing there, and they put the same video together twice. All right, so let's move on. let us move on. This is from September 11th. All right, so this is a hearing from September 11th. That last hearing was just kind of a big nothing burger. They were just basically setting another court date. All right, so this one is from September 11th, 2024.
Oh, no, ma'am. I got Charlie College. No, ma'am. No, ma'am. Oh, man, please not want your phone in the box.
I know, I was just I don't have a purse. I know, I kind of...
Yeah, y'all showing out.
I know, I'm sorry. I know,
Sabrina, I'm going to put it in my purse.
Okay, thank you.
She's supposed to be in here, but she is out of uniform. He was asking about you.
Good afternoon, everybody. Let's go ahead and get started with the Clenney case. We're here for State of Florida versus Clenney. Everybody can announce their presences for the record.
Khalil Clinton, Sean Applehoff, Captain Hogan, Stewart Edwards,
Good afternoon, Your Honor. Attorney Frank Prieto, along with co-counsel Sabrina Puglisi, Bank MS, on behalf of Ms. Clenney on the F-22-14137.
Mr. Hedrick, are you chosen to join us?
Voluntarily, correct. Yes, I will be probably coming in to work on parts of the case.
Okay. All right.
Judge, as a housekeeping matter, the deposition of Dr. Maricini, which is our medical examiner expert witness, was started yesterday. He was in trial and Ms. Baroness was able to break away from her hearings to take part in that deposition. She had to leave again, so that deposition was not completed yesterday. We communicated with the state, and we do not disagree that they should be able to finish that deposition before we move forward on the defense's motion to dissolve Your Honor's pretrial detention order. We think that's appropriate. However, we want to schedule that. We offered to finish the depot today, but obviously they couldn't do it. So that just needs to be coordinated hopefully in the next week, but we'll work on that and contact your office ASAP to get that set. So that would leave the that portion of the case not for today, obviously subject to your approving that. But I know Mr. Bashadilmo, so this is motion is pending.
Give me one moment. Was there anything else that was pending prior to where there were two experts that you guys wanted to depose prior to that motion? Did the other one happen? Or?
Yes, Judge, I believe there are certified questions that we will bring before Your Honor. We're going to file that motion, but we do need to finish this deposition before we move forward. So we are asking for the reset.
Okay. Well, you guys go and get a date with Anna once we're done with the other motion, and we'll set up whenever you guys can set up. Okay?
Thank you.
So, Mr. Pasadomo, let me turn then to your motion to intervene and Wash.
Yes, good afternoon, Your Honor. Jude Pasadomo here on behalf of Kim and Deborah Clenney, who were present in the courtroom. We did file, as Your Honor indicated, our motion to intervene under the F-22-14137 case. which is obviously the threshold question before we get to anything more substantive. I'm sure Your Honor's read our motion. I'm happy to expound on it if you'd like.
I have read it. I'll give you a couple minutes to expound on it if you'd like, and then I'd like to hear the state's response.
Sure, Judge. Well, I know Your Honor pulled the rule. It's under Florida Rule of Civil Procedure 1.230. Obviously, in the absence of a criminal rule procedure governing, we revert to the civil rules of procedure, not unlike, say, in a 3.220H deposition situation where it refers back to the civil rules. If Your Honor looks to the entirety of that motion and the rule to intervene, it's actually very, very broad. I think the exact language is that any party claiming to have an interest may move to intervene. I would proffer to the court that this goes well beyond a claim of an interest. I know at the last hearing, the state's position was that they were objecting to our intervention. Obviously, that was the first time it was raised. I don't know if they're maintaining that position. If the state's position is that our clients do not have an interest in 3 years of their personal iCloud data, I'm sure they can explain that to the court. If their position is that, yes, they do have an interest in it, which I think would be the ethical and genuine position, but that the state's interest trumps that, then I think we can move on to the second motion in our fun-filled afternoon here together. But the reality is, judges, what we are seeking to intervene on behalf of is that under the homicide case, the state of Florida executed a search warrant. I'll reserve my commentary on that should we get to the second motion. That search warrant allowed the state of Florida to go through the personal iCloud accounts of 2 uncharged, unrelated to the homicide offense, non-defendants, private citizens outside of the state of Florida, starting from November of 2020, which is 2 years prior to the predicate offense, to November of 2023, a year and a half after the predicate offense, with no limitation. So what the court has in its file right now are personal, medical, financial, spousal communications, attorney-client communications, all of which the state would very much like to go through. And those pieces of data belong to 2 parents who are, and I'm assuming the state will concede this point, but were not involved in the homicide offense, which by their own theory is a heat of passion, heat of the moment homicide. It is not premeditated, there's no financial component to it, and yet their seizure through this warrant of the Clenney parents' data is broad and vast, and it is very, very private, and we have an interest in that. And based on that, we are moving to intervene so that we can address the warrant itself, which is the substance of our second motion, because that warrant, in our opinion, never should have even been applied for.
Question to you.
Yes, ma'am.
Do you think that it's a 2-pronged test before I allow you to intervene, not only that you have an interest in this, but that the state's interest does not outweigh yours?
So, Your Honors,
I think it's just that they have an interest in it, and then you move to the substantive motion itself.
That's our position, Judge, but it is Your Honor's discretion under the rule for intervention. You can decide if there is an interest. If Your Honor is going to address that second prong that you just mentioned, I am happy to address that. I don't know if that's Mr. Quinn's argument. I haven't discussed it with him. If the state is going to proffer that, hey, this is our case and we need to do what we need to do, and our interest in prosecuting this homicide trumps private citizens' privacy rights, so be it. I'll respond accordingly.
But what I'm saying is that you would have, I couldn't tell what you were saying, whether or not you thought that that was a 2-pronged test for the intervention itself, or that you were saying that the only test for whether or not you're allowed to intervene is whether or not they have an interest.
So
Because
I think we're allowed to intervene, and then Your Honor can address that after we intervened into it. If you look to the rule itself, it's incredibly brief and direct, and it discusses any party claiming an interest. Now, that interest, I think what Your Honor is referring to is the portion of the rule that discusses whether our interest is subordinate, right? So the court can allow us to intervene, and then when dealing with the substantive issue, make that determination as to whether our interest is subordinate. I think that goes more to the crux of the motion to quash the warrant, because Your Honor is going to be asked to determine if this warrant is so overly broad and invasive that it trumps the state's interest in what it is looking for in this iCloud data so as to continue to prosecute Ms. Clenney.
Your Honor, crystallize my argument. The rule, the plain language of the rule governs, the rule provides, and I'm going to read it. Anyone claiming an interest in pending litigation may, permissive, at any time be permitted to assert a right by intervention. But the intervention shall, meaning not permissive, be in subordination to and in recognition of the propriety of the main proceeding, unless otherwise ordered by the court in its discretion, which ultimately gives the court discretion. But before we even cross that bridge, there has to be an immediate recognition that the rights of the intervener are subservient to the state. I would generally not object to the intervention of a third party who has property interest rights, as to, for example, a firearm, right? An innocent person had their firearm stolen and used in a homicide. Once the homicide litigation is closed, then that person can intervene and take their property. Generally, that will be done through agreement. This litigation is ongoing. At the end of the litigation, the defense can intervene and seek to obtain that evidence. But notwithstanding that, that evidence is also not theirs. They have an expectation of privacy in that information. But that was Apple's records. The Excel spreadsheet with messages were not made by Mr. and Ms. Clenney. They were made by Apple. The list, the business record certification, the inventory, or whatever the materials they're in, were all made by Apple. So again, I don't disagree with that expectation of privacy and would have standing, for example, to challenge a motion to suppress, where they are charged with defendants, but the material is not theirs. It is Apple's. It would be not unlike a cell phone where there's a forensic extraction. They can get the phone, the data itself is part of the evidence of the case. Maybe there's an appeal, maybe there's a retrial, etc. So, for those reasons, I don't think they should be granted intervention.
So you agree that they have at least a privacy interest, but not a property interest, and you believe that that privacy interest is subservient to the ongoing case?
Yes, and 3 seconds, absolutely.
So, Judge, rarely as this happens, but I happen to agree that the plain language of the rule does govern there. So the first part of the rule discusses intervening. I think we're getting ahead of ourselves when we're making a determination as to what the subordinate interest is, because that is the subject of the second motion. Once we intervene, we can make our argument to the court as to what the interest of Mr. and Mrs. Clenney is, and the court then weighs that against the state's interest. And that's particularly important, Judge, because I know Your Honor did read our motion, but the warrant application is incredibly vague as to what it is they are looking for in this wide berth of data and how it helps them prosecute a homicide from 2 years prior to when they started looking into this iCloud data. I also think, and with respect to the state, that's a very disingenuous position to take, that Kim and Deborah's private data belongs to Apple. The state of Florida has a robust constitutional privacy interest, and to hide behind the fact that there's a company that acts as a conduit to their data and say that this data belongs to Apple is an end run around their privacy interest. I don't think we're there yet. I'll be happy to go further into those arguments, but it sounds like we are all in agreement that they have an interest. I think we need to move now to the substance of the warrant itself so the court can weigh whether that interest is in fact subordinate or not.
Yes, Judge. The business record certification is not from Kim and Deborah Clenney, it's from Apple Incorporated. So, as it pertains to that aspect, the collateral party, in particular the intervening part, is, in this case, quite literally before arraignment, Mr. Creates a copy motion to essentially close discovery. Anything that would be subject to a public record cannot be disclosed to the public record. And then Judge Buscaino denied that motion. The Miami Herald had to intervene in that litigation. In that context, Ms. Clenney's right to privacy was not subordinate to the media and the public's rights. And honestly, the motion was too broad anyway. But the point is that they failed to have even pled that the state's interest in evidence in the prosecution of a homicide is somehow less than their right to the privacy, or to the evidence.
So, Your Honor, in response briefly, it is when you have two private citizens not charged with a crime. This is the only avenue of relief that Kim and Deborah Clenney had. So for the state to stand here and suggest that, I didn't understand the argument about the motion prior to arraignment. So I don't know if that was relevant, but to suggest that Apple owns this data, to leave Kim and Deborah Clenney without remedy and the possibility of extreme prejudice to have a government agency go through the most private data for 3 years, I don't know how the state attorney's office stands here and makes that argument. I would suggest we go forward on the substance of it so they can advise the court why this is so important and what they're looking for.
There are so many times that the police do seize cell phones of witnesses or victims or people who are not the defendants in a criminal case, and because they believe that it has evidence, I mean, sign warrants for them all, where they then get the contents of those phones as cell phone dumps, and they're used in criminal cases, and then the phones themselves are given back. I certainly understand the argument, but it's not as if this is a novel, something novel that happens. It happens all the time. All the time. This is the first time that anybody has actually been in front of me and made this request where the owner of the cell phone is asking for that information to not be used or to be quashed, instead of the state being allowed to proceed with this investigation based on the evidence that was seized during the warrant. I read this rule as saying that this is a two-pronged test before we even get to the substance of the motion, that I make a decision as to whether or not you're allowed to intervene. I don't see that. I mean, I could let you intervene, I guess, as allows me the may. But given what I know already about this case and about the communication between, particularly Mrs. Clenney and her daughter at the time of the homicide, the nature of the relationship before the homicide, the nature of everything that happened after the homicide, and having read through the warrant as to why it is that the state was requesting this information, I'm going to deny the defendant's requesting it.
Your Honor, may I respond briefly?
Absolutely.
Because I understanding that Your Honor has ruled on the position of the claims as subordinate, I now need to address that, if nothing else for purposes of the record. So, what we have here is a warrant that asks for iCloud data. Let's be clear about what iCloud data is. And I think we all know, everybody with a cell phone in their pocket has private information on that phone. Let's talk about that private information. We are talking about medical records, confidential. We're talking about financial records, confidential. We're talking about spousal communications, confidential. Photographs, potentially confidential. We know the state read attorney-client messages, confidential. The warrant itself, and I would encourage the court to review it again because it does not speak to anything that could be related to the homicide. And playing devil's advocate, Judge, Your Honor's position regarding the calls between Courtney Clenney and Deborah Clenney. Okay, Why is this warrant not narrowly tailored? Why are we looking at private data that dates 2 years prior to, with no restriction in the warrant, Judge? There's no limitation. In fact, I'll read into the record what it is asking for exactly, Your Honor, because it is a little frightening that a government agency in the Miami-Dade State Attorney's Office believes that simply because you are related to somebody charged with a crime, that you are allowed all stored electronic communications or files dating 2 years prior to that crime to a year and a half subsequent to that crime. Let's also keep in mind that the defendant herself was in custody from April of 2022, or from August of 2022, past when that warrant was then issued. She has no access to devices or communications with her parents. Why would they be allowed to see that? Simply because my clients are related to her? That's a very scary, slippery slope, Your Honor. Everybody in this courtroom who maybe knows somebody who was charged with a crime is now subject to the state attorney's search. That's what this warrant says. And that is a slippery slope that we are not inclined to go down. Where is the narrowly tailored warrant as required by statute? And that brings up the issue, Judge, that yes, we understand that this was presented to a judge. We're asking Your Honor to correct what we believe to be an error. Your Honor has the jurisdiction to do so. Previously, my colleague has, during hearings has mentioned his experience as a state attorney and his experience and what he's seen and what he knows. Mr. Clenney. So he's referenced that several times, Judge, and I take him at his word, and he does have significant experience in this courthouse. I've been in here 20 years, and the only thing I know is that I've been wrong before, and I will be wrong again. And anybody in this courtroom who's being honest will say the same. And you as well, Your Honor. The reason I say that, Judge, is because being wrong is not the problem. Not correcting it when you have the opportunity to do so is the problem. If Your Honor is inclined to allow this to stand, I would suggest that it be redrafted and tailored, because what the one area you referenced was the only thing, and I'm taking the position of the state attorney for a moment, is the only thing that could possibly be considered to have any relevance from that wide berth of massive amounts of private information. Florida respects and protects privacy. The state attorney's office drafted a warrant, which frankly, we don't think it should have been signed. I don't think it ever should have been applied for, because it is scary how broad it is and what it is asking for. And so Your Honor's reference to other witnesses and other victims who may have, just because they haven't asked for it back doesn't mean they weren't entitled to it. So, Judge, I try to avoid doing this, but I am going to ask the court to reconsider its position. I think the sheer breadth of this warrant speaks to the fact that it is a fishing expedition, and it will create an irreparable prejudice to two private citizens who are now not charged for the crime and open their private information up to be traced through by a government agency. That's not something we do. So Your Honor is sitting in the unenviable position of being able to correct that.
All right, Mr. Clinton, I know that that this argument is being made after the ruling, and we're now getting into a little bit of the substance of the warrant itself, but I would like you to actually respond.
Sure, Judge. As it pertains to the beginning date of the warrant, it begins just like every other warrant on digital evidence in this case, which was the beginning of the relationship with the defendant and the victim, at least as far as we can tell, which was November of 2020. nature of this case, candidly, is the nature of the relationship, because there were only two persons in the Woodbury's apartment at the time. One's dead and the other's a defendant. And so a significant portion of the case has clearly been identified through similar fact evidence and nature of the relationship. That, frankly, was a lot of the break in the case as it pertains to Mr. Obumseli's phone records, his prediction of his own murder, the defendant slicing his lip on January 30th of 2022 in Miami, Florida, and telling him to enjoy the hospital, for example. Given that significant digital evidence in that case and surreptitious recordings taken by the victim, there was significant interest in the defendant's communications, including the communications with her mother, which the state contends were indications by her mother to the defendant who would claim self-defense that did not exist. That is our proposition, that is our position. If Ms. Clenney testifies, that Ms. Deborah Clenney testifies, we will cross-examine in that respect. Because candidly, on the night of the homicide, she did not tell police that Ms. Courtney Clenney was defending herself. So in that respect, we have an interest in Ms. Deborah Clenney's communications with the defendant. We did not get those communications. We could not get into Ms. Courtney Clenney's phone, at least originally. Ms. Deborah Clenney's phone was in Texas, and this honestly presented an opportunity for doing a warrant, might as well do all. In finding out, right, an element of a search warrant is evidence of a crime that presently exists at the place to be searched. We subpoenaed Apple to find out whether is there an iCloud backup. And we discovered Ms. Courtney Clenney's accounts was commingled with Mr. Kim Clenney's accounts. The phone numbers are all intertwined. And if necessary, I could have opened a subpoena response to essentially outline how each of those accounts were intertwined. And active access was being done to Courtney Clenney's account in December of 2022. I don't know who's accessing it. I don't know how they are accessing it. And frankly, I need to know, especially since Mr. Kim Clenney commingled his account with that person, which also requires me to get all of the backups in that intervening period to find out whether anything had been changed or not. So that outlines probable cause, which I think is the second and third last paragraph of the affidavit for the warrant. That actually, let me pull up Mr. Faciadomo's response because it is deceptive quoted in this motion. And I want to make sure I censor it properly. So beginning on page 10 of Mr. Faciadomo's motion, he begins quoting paragraphs of pertinence to Ms. Deborah Clenney's probable cause, and then intentionally omits portions. And I don't necessarily disagree that paragraph 11, 13, and 14 are not necessarily pertinent, but in the end of the conclusion here at page 11, Mr. Faciadomo fails to quote page 11 at the top where it outlines specific probable causes to each account. It says CTC, there's probable cause to search CTC 496 at may be cause. There's probable cause to search DEV 007, etc. And that's in the affidavit for search warrant. So if the court looks at the top, page 11, and in his motion he denied the
You're referring to the warrant?
Yeah, the shape of the warrant.
Okay, on page 11.
Yeah, ironically.
Beginning accordingly based on brutality of circumstances?
It outlines specific, well, I was discussing both, but it outlines specific probable cause to each of the accounts. So that is all to say that I honestly have no idea what's on the records, despite the shots across the bow that we've read all of the messages. We ceased our review immediately upon finding Mr. Creative's message. So I don't know what is in there or not. The only thing I could, and if the court required me to do so under oath, I will say, is the 4 months of messages from April 3rd of 2022 between Ms. Deborah Clenney until January of 2022. And then I did a word search. So So I have no idea what else is in there. I don't know to the extent that it is in there. And I should also let the court know that we told Apple, that's plain in black and white in the warrant from November of 2020 to present, Apple provided every single text message Ms. Deborah Clenney sent since 2011. We didn't ask for that. Apple just exports the iCloud returns. So even if we had said from April 1st to April 3rd, Apple was going to provide us everything anyway. So I don't control that. And the bottom line is that it is evidence in this case, the communications that existed between the defendant and her mother who testified, who gave an interview to TMZ claiming that she was told all of these attacks that occurred and the not in those messages are all pertinent substantive evidence in terms of the nature of the relationship and impeachment evidence if they were to testify.
Your Honor, with regard to the paragraph that Mr. Quinn is relying on, it's self-conclusory. You know, it seems to be the state's design to issue how the warrant was drafted, and frankly, we don't find it I think it's intentionally mistaken. And it's also curious why a pending case in front of Your Honor on a non-exigent warrant was not brought to Your Honor with knowledge of this case, but notwithstanding.
I actually don't think that's typically done. It's typically taken to the already judge, so that the person who's actually overseeing the case is not issuing.
So, Your Honor, the state offers up conclusions as to why it believes it has probable cause without any detail, based on the totality of the circumstance. Probable cause similarly exists for KDC 50 and KDC 50 at Austin because K. Clenney utilized his own accounts with those of the defendant and an email belonging to the defendant as verification and an email for his own. Okay. What evidence of a crime is there? The state's desire to investigate their case does not trump a private citizen's privacy interest unless they can pinpoint specifically something that establishes probable cause that there will be evidence of a crime or evidence of a future crime. None of that exists in the warrant. This is the definition of a fishing expedition, and it is designed to go directly at the parents of Ms. Courtney Clenney. The question for the state is, did they do the same for the victims? Did they do the same for the victims' family members? Because what they are suggesting here, and through this warrant, are telling this court that if you are related to somebody charged with a crime and possibly had communications with them, you are now subject to their invasion, and your privacy interest is no longer paramount to their interest. It is a typical and seemingly theme of this case that we can do what we want to do, and we're going to do it with a without probable cause. What they say in here, and this paragraph that has no relevance to anything, and makes no reference to anything of worth, cannot be relied upon to say that two private citizens outside the state of Florida as well, Your Honor, should now have all of their personal private information searched. That is a terrifying prospect.
First, my co-counsel here brought something to my attention too. I meant to also say with regard to financial records, if the court recalls at the Arthur hearing, we contended that the defendant intentionally moved funds to possibly prepare for a flight, which he did flee the jurisdiction, albeit to Hawaii. That was our contention, it still is our contention, and that kind of came out in the cross-examination of Mr. Clenney when issues about commingled funds came up and so on and so forth. That's number two. The distinction between going after Mr. Obumseli's family's records and Ms. Clenney's family's records is that Mr. Obumseli's mom wasn't on the phone with him when he was killed. The defendant's mother was. Mr. Obumseli's mother didn't text him saying it is 20 minutes after not knowing what happened. It is very important even though you were defending yourself.
I've got a question for you, and I have no idea what the answer to this is, honestly. I agree that there are possibly lots of different things on these phones that could be relevant to your case. So I don't think that it's a pure fishing expedition. However, similar to anybody's phone, but there are also lots of records on there that are not relevant to your case. And typically speaking, it is true that a lot of these warrants are not as narrowly tailored as they could be. What power do I have as a judge now to somehow protect some of the more private data that is not relevant to this case, which would be things like medical records or other private communications from the plaintiff parents, or quite frankly in any case, because again, this case is not special in that way. I don't know what power I have after this warrant has been signed, because a lot of it is relevant. I can see why the time period itself is relevant as well, for the nature of the relationship and what's happening after she's arrested. But clearly there are records on anybody's phone that's going to be so extraneous to this.
Absolutely, Judge. My son's passport application that's on my iPhone has nothing to do with anything that, for example, might exist or might not exist. And I don't know if that exists or doesn't exist on any of these iPods. I'm only using that because I just did that. The bottom line is that for anything that is beyond the scope of admissibility, then frankly, it is not used. The remedy for anything that is beyond the Fourth Amendment scope is exclusion under that, and I can't use it substantively. Notwithstanding that, I appreciate that the court's actually raising that topic because it's part of my outline, albeit I never got to this responsibility, which is they have standing to intervene and move for a protective order preventing disclosure to the public of those materials. Absolutely. But the state has a right to review that materials because we've outlined probable cause, and which is our threshold, period. There are a ton of things that go towards other records or documents that we both need, and it's just a natural consequence of doing these searches. For example, even if a forensic examination of my phone, even if only narrowly tailored to the communication between my spouse and I between a week-long period of July 1st and July 7th of 2024, the extraction of that material still produces logs. For example, when my phone was open and closed, whether it was open through biometric measures or through a passcode, whether it was put into charge or not charged. They're just a natural consequence of the forensic extraction. Furthermore, certain aspects of the records, albeit just since I figure there's a stipulation that the records belong to these persons, is the state on occasion has an obligation to prove possession and who controlled it, which honestly, again, is why we had to go through the KDC accounts, because they were commingled not at our direction, but at the direction of whoever controlled those accounts. And I don't know who controlled those accounts. I have to review those records to ascertain who was controlling those accounts and what they were doing and whether evidence of a crime to murder exists on those records and found those records, etc. So, again, as I mentioned, the remedy for them, if they want to preclude the public from finding out personal communications, from finding out financial or medical, is a protective order. And I don't know that I have grounds to object to that. And that would also be a motion to intervene, and I don't know that I have grounds to object to that. As a matter of fact, the privacy interest in that respect would be my interest in the case would be subordinate to their interest. That is the proper aspect of this. So my ability to review those records, ascertain what is and is not evidence in the prosecution of the state of Florida versus Courtney Clenney is well within my rights as the state of Florida pursuing search warrant.
So, Your Honor, what Mr. Clenney just said there reveals the fundamental issue and misunderstanding of the state of Florida as to the nature of an individual's right to privacy. It's not about the public, it's about anybody. Private is private. And I think one thing we can all agree on, Miami-Dade State Attorney's Office is a government agency. It is a government agency that is looking to go through personal, private records of two people who are not charged with a crime in the hopes that it may find some communication related to this case. Also, Mr. Quinn pointed out, he's done it twice now. The conversations between Courtney and her mother around the time of the homicide. That actually is something that they may have an entitlement to, but that is nowhere near what they are asking for. They keep referencing that because they're hoping to bootstrap it to say, and that way we can get everything else. Also, the testimony of Mr. Clenney at an Arthur hearing regarding finances, there's no financial component to this offense. The state just said they think it may be related to risk of flight. All of this is state speculation and is unrelated to the prosecution of a homicide, Judge. Let's remember, we're not dealing with Medicare fraud, we're not dealing with mortgage fraud, we're dealing with a homicide. And to then say that private citizens' personal data needs to be reviewed by the state, and to suggest that us reviewing your personal data is not a breach of your privacy is wildly misguided.
Judge, consciousness of guilt is direct evidence of the homicide. If the defendant's moving money to flee the jurisdiction, I'm sorry, Mr. Petrodome, but that's evidence of the homicide. I get to make an argument if I have evidence of that effect.
But they went fishing for evidence that they had nothing to support that it existed, Judge. That's the crux of this issue, is Mr. Quinn's speculation as to, I may find this, so let me go get this. There's nothing to support that. The testimony of Mr. Clenney as to whether he could post bond or not does not suggest risk of flight, rather the opposite.
So I'm going to stick with my ruling. I appreciate the request to reconsider it. Hopefully you've laid your record. I don't know what appellate remedies there are here, but I think that we covered all of the arguments for this particular motion unless anybody has.
Well, with regard to what Your Honor just raised, so what I'm going to ask is the court to stay the release of the hard drives so we can pursue appellate remedies. My understanding is that the court's ruling in this aspect is a final order as to the movements and would be subject to a direct appeal.
Okay, so let's do this. Let's go ahead. Can you give me a piece of paper so I can go ahead and order a copy of this transcript?
I don't have a paper, Judge, but I can allow.
Well, there should be actually.
Let me see.
I have my.
Have it in now.
Or actually, two transcript requests right there. And then what I'll do is I'll attach a copy of the transcript to just the written motion that I'm denying this motion and reference the transcript itself.
I was going to agree to this day only because my witness that would take custody of it is not available to take custody of it. Additionally, we were intending to outline, based on the court's ruling regarding communication between Ms. Deborah Clenney, based on the aspects of the privilege ruling, we were essentially going to present to the court the protocol with ASA Hecker and the certain permission. So we were going to ask the court to.
All right, so I will keep these. I will stay the release of them. I'm ordering a copy of this transcript. It will be back in 10 days. I'm going to need it sooner than that.
No, Judge, as long as there's no prejudice, then 10 days is fine.
All right, so I'm going to order it, and I will make sure that everybody has a copy of it when I get it.
Thank you.
I will also attach it to the reference to my order. Okay? All right. Thank you all. Go and get your next hearing date if you don't mind playing them out.
That's Thank you.
We're off the record, Judge?
Yes, and for everybody on Zoom, I'm going to log off now.
So that is the woman on the left is, I don't know who the woman on the right is. Woman on the left is Sabrina Voya Puglisi. I believe that's how she. So Sabrina's on the left. I'm not sure who the woman on the right is, but Tara Kawas represented her at one point, and she represented Catherine McBanawa from the Adelson Dan Markel incident. I'm not even quite sure. There's like all these trials are like coming together. So ultimately, that state attorney gets removed. So that state attorney gets removed through all of this. So they were talking about this iCloud account. So eventually, judge rules that the prosecution had improperly obtained and reviewed attorney-client privileged communications from their iCloud accounts. So the state dismissed the charges against Courtney and her parents. So that ultimately got dismissed. But then the state prosecutor, is removed because he would then become a witness. So he was removed, and then that's when they bring in the next Sean Obenhoff, I believe his name is Sean Obuhoff. Yeah, so he comes in next. I don't know if he's going to come in on this hearing. Let's see if he's in on this hearing or if it's still Khalil. I'm not quite sure. Let me just come here. All right, so this is from October 14th now. So now we're going to fast forward to October 14th. All right.
Everybody ready to go?
Good morning. Good morning, please support Khalil Quinn, Kathleen Hogue, and Sean Obuhoff for the state of Florida.
Good afternoon, Your Honor. Chief Prosecutor Mickey Ratson on behalf of Tim and Deborah Clenney, who are present before the court.
And we do have Ms. Clenney present, her attorneys as well. So we'll go ahead and get started. Mr. Fascidomo, my understanding is you want to be heard first on your motion for reconsideration.
Yes, Judge. Thank you. I appreciate you accommodating me. I know we've got a lot of attorneys and moving parts, so just so we weren't getting in the way of everybody's schedule, and we're trying to squeeze a couple of things in. So thank you.
I will allow you to argue it briefly, but I did read through it. I read through the civil case that you cited. I think it's analogous. We have yet to cite any criminal cases, but I was certain that you already
So thank you. Yes, Judge. I appreciate that.
What I'm probably going to do.
Go
ahead.
I will keep it brief. I know that motions for rehearing and reconsideration are not always the court's favorite.
No, it's fine. I mean, I think that it's final up to this point. If you're going to do it, then this is the time.
I'm hoping to not have to, Judge, but the leading from the court is not making me overly confident. So let me do my best, Judge, if I may. And again, we appreciate that. So part of the reason why the court doesn't really see any criminal cases because it's a civil rule of procedure, and generally it applies to, as the court pointed out last time, physical property. We're talking about data here, which I think is a pretty unique issue. Here's where the issue on intervention, I think the problem is with the court's analysis. We've all agreed, and that's a rarity, especially in these cases, for us to have an agreement, is that the plain language of the rule governs. The court, in its denial of our motion, employed this two-pronged test. I don't read the rule that way. The rule says that the intervention shall be in subordination to the main interest, and we can concede that the interest we're discussing is the state's right to investigate and prosecute Courtney Clenney. There is nothing in the plain language of the rule that precludes the intervention based upon the intervener's status. So we disagree with this two-pronged analysis. But let me say this, Judge, because I do have a duty of candor to the court, and if the court retains its position, yes, it is our intention to seek a review of it. So I think it's important that I point out that in my review of the case law, even if I'm correct, which I may not be, the appellate courts will still look to the more substantive issue and consider the court's ruling on the intervention itself to essentially be a harmless error. It's kind of akin to a tipsy coachman analysis. So I think the bigger issue and the better use of my limited time is to discuss that issue of subordination. And I think I did the court a disservice at the last hearing because I did not draw enough attention to the Florida Constitution, in particular Article 1, Section 23, which is, as Your Honor knows, the section of the Florida Constitution that in its own right creates a privacy interest. That is unique, and just again, Judge, for purposes of the record.
Because I do think that it is an issue that is more, well, go ahead.
Okay, so Judge, again, because we are talking to the record now, let me just be sure that. Yeah, so let me cite to Article 1, Section 23, right of privacy. Every natural person has the right to be let alone and free from governmental intrusion into a person's private life, except as otherwise provided herein. This section shall not be construed to limit public's right to access to public records. More importantly, Judge, I'm going to cite the court, and I know Your Honor did read our pleading, but Winfield v. Division of Pari Mutual Wagering, which is 477 Southern 2nd, 554. It's a Florida Supreme Court case that discusses Florida's unique privacy right and its unique interest in the Florida Constitution. This is, and I'm quoting now, Judge, this amendment is independent, freestanding constitutional provision which declares a fundamental right to privacy. Article 1, Section 23 was intentionally phrased in strong terms. The drafters of the amendment rejected the use of words unreasonable or unwarranted before the phrase of governmental intrusion in order to make the privacy right as strong as possible. And that's why I'm back before Your Honor, because I am having trouble understanding how the court is reconciling the warrant as it is with Kim and Deborah Clenney's very, very robust privacy interest. I will concede, Judge, the state has an interest, and not a small interest either, Judge, in prosecuting Ms. Courtney Clenney. Kim and Deborah Clenney are not charged with a crime. The reason their data is even subject to that interest is because they are related to someone charged with a crime. Florida's constitutional amendment protecting privacy doesn't allow for that. Now, there is a compromise, Judge, and there is a way that this court, with its jurisdiction, can address this issue. So, again, as I was saying, I was having trouble reconciling the denial and the data that's in the court file with that constitutional amendment. However, given the breadth, both in scope and time of the warrant itself, I think it's incumbent upon the court, in consideration of Article 1, Section 23, to narrow that. And let me put a finer point on that argument, Judge. The state has pointed to 3 separate instances of what they think they are going to find in this data and why it is relevant to the prosecution of Courtney Clenney and why they should be allowed to go through 3 years of iCloud data of 2 private citizens uncharged with a crime. First, they say that Deborah Clenney may have been on the phone with Courtney at the time of or in close proximity to the death of Obumseli. I'll concede that point, Judge. If it's true and the state can support that in an affidavit, then we know when the death happened. A narrowly tailored search warrant or subpoena for that data is perfectly appropriate. The second issue, they pointed to photographs that were voluntarily turned over to the state to show the abuse by Christian Obumseli of Courtney, and have argued that there are gaps in the images. Again, the time, we know when that happened, easily searched, easily collected, and certainly within their interest to prosecute this offense. And the third argument that was made by Mr. Quinlan at the last hearing, and that we've heard before, is that Kim Clenney in the Arthur hearing testified to something about commingling of assets, and Mr. Quinlan's exact argument to the court at the last hearing was that, and this is I think on page 29 of the transcript, Judge, that was indicia of risk of flight. Okay. Here's the question for that. The Arthur hearing took place in November of 2022. Why would Mr. Clenney's testimony and the state's concern of risk of flight after Your Honor pretrial detained Courtney be relevant to a warrant that was issued a year later? So that begs the question of the legitimacy of what they are looking for. Let's assume in arguendo that those points are all needed and they're essential to their job to prosecute this case. Very easily, narrowly tailored. There's no reason why Mr. Clenney saying that there may be commingling of assets should open up his financial records from 2-3 years prior. Should allow the state to look into medical records or private photographs or private spousal communications. And what's preventing them, and what I'm arguing to Your Honor, and again asking you to reconsider the position and find that compromise, is that Florida specifically tells you they can't. The constitutional amendment is there for a reason. Not every state has a specifically enumerated right to privacy. Florida not only has one, but an incredibly robust one, telling this court, hey, government has an interest, but that interest does not trump a constitutional right. So you have the answer, Judge. And that's what we're asking the court to do, is to say to the state, hey, you don't need Mr. Clenney's medical records from 2020. You don't need Deborah Clenney's photographs from 2021. These are the things you told me you're looking for. Bring me a more narrowly tailored affidavit and warrant, and I will review it and sign it if it's appropriate. That is the compromise, Judge, that allows the court to exist between the state's interest in prosecuting the case and Kim and Deborah Clenney's extremely robust privacy right.
Judge, I don't have significantly more argument unless the court has precise questions. I would point the court to the rule of motions for rehearing. The rule explicitly provides that the motion will be filed in 10 days. The motion was filed in 16 days, so it's time barred from rehearing on the court's matter. And as it pertains to the constitutional argument, I agree that the Florida Constitution provides the right to privacy. Section 12 also allows the state to apply for warrants, which we already have done. Mr. Patridomo's recommendation of a compromise express to do something we have already done was obtain a warrant that's supported by the warrant clause. Therefore, the court does not defend this motion.
All right. So I'm going to go ahead and allow for him to move forward on the notes past the time limit. Again, the only thing that is cited in your motion are civil cases. This is not a civil case. This is a criminal case. I did my own research. I could find absolutely nothing that is analogous here, and I think that there's a reason for that. I don't want to be the one to set the precedent for looking through every single search warrant that comes before me because somebody is going to put forward the right to privacy. That would exist in every single search warrant for every single thing that the state gets a warrant for. Listen, if the third overturns me, great, they overturn me. Let them do that balancing test between the constitutional right to privacy and the right of the state to pursue its investigation and get its warrants. I'm not going to be the one to set that precedent. I don't think that is my job. I don't think that you have the right to intervene. I think you have an interest in the case, but I do not think that you have a right to intervene. I did all of my own case law research on this. The only thing that I found were victims who were coming forward intervening in cases because there was a violation of Marshall's law. This is not this. They are not victims in this case. If the third wants to carve out its own balancing test between the constitutional right to privacy and a judge determining what parts of what was already determined to be a valid search warrant that was drafted by Judge Wilson. If the third wants to do that, then they can do that. I am not setting that precedent. Okay, so it's denied.
Thank you, Judge. Just to clarify one point. So the court does have that responsibility under 933 to review each of those warrants. And Judge Wilson actually renewed Judge Cabargo's warrant. So,
but at this point in time, there was already a want to resolve the probable cause. There is a privacy interest everywhere. I'm sticking with my original ruling. I think that it is the correct ruling. I think that I used the correct two-pronged test. Again, I can find nothing analogous, and I think there's a reason for that. However, at the third, if you want to take it up to the third, I know that this is final order and is approval as of this moment.
Okay, so this is the court's order orally pronounced?
Yes.
Thank you.
Okay, and if you want to, I can do a brief, I'll do a brief order saying that it's denied, and I will incorporate by reference the transcript for this case. Okay?
Thank you, Your Honor.
All right, thank you. Let's move on to this motion to dissolve.
Yes, Judge, can you give a copy of the state's motion to strike?
Yes, good morning. Good afternoon, Judge Frank Defendant Courtney Clenney on behalf of 22-14137 case, along with my co-counsel, Ms. Sabina Puglisi.
Okay, so next up then, motion to dissolve, and I have to say this motion to strike. I'll be real brief. I tend to agree with the statement that there's no basis for a dissolution, however, I'm going to treat it as a motion for consideration. Should that motion for consideration subsection 947.0416 subsection 5K versus N. I don't think that there's anything even in the motion that talks about a subsequent event. There's nothing there. What's your subsequent event? There's not one. But you do talk a lot about why I should reconsider it based upon evidence that was unknown at the time of both the Arthur hearing and the pretrial motion. There is no discussion of the Arthur hearing in your motion to dissolve. I mean, I did make the finding based on the Florida Constitution, Arthur hearing, as well as the pretrial detention statute. So even if I were to reconsider the pretrial detention statute, are you also asking me to reconsider the Arthur hearing ruling?
Judge, the rules allow for the court to take into consideration of 3.132 subsequent events. I hear what Your Honor is saying.
Well, first of all, are you also asking for me to reconsider the Arthur hearing ruling?
Judge, we know that you've made a finding of proof better than presumption great, but the phase 2 arguments are what we're readdressing, which is permitted under the bond statutes 3.131 and 3.132 sub C.
Okay, so you are asking for me to reconsider the...
Just the part of the Honor's ruling that coincides with Your Honor's ruling under 3.132 pretrial detention, because those two, Arthur and those two obviously are very intertwined.
Okay, so what's your subsequent event that you think that it qualifies as for dissolution?
Sure.
Subsection N?
There's several subsequent events. The term subsequent event is not defined in the rule, but there are subsequent events such as this discovery of the body on camera of an eyewitness showing the abuse that Ms. Clenney faced. That is a subsequent event that presenting that to the court, finding that in discovery.
You don't believe that that's evidence that was unknown at the time of the hearing?
Correct. But I believe that's an event. I don't know how you're defining event. I think that qualifies as an event, along with the listing of expert witnesses in this matter. Your Honor considered, I think...
The listing of the expert witnesses is a subsequent event?
The discovery from the expert witnesses, their belief.
That's a subsequent event?
Yes, Judge. Specifically, you are finding there's a substantial probability that she committed the crime, okay? And what we are showing the court is that she's justified in her actions when she acted in self-defense. Now, we made that argument at the expert hearing and the detention hearing, and the court said that you didn't find there was sufficient evidence to believe that. We now have sufficient evidence, which is a subsequent event, and that's what we believe, because there's no case law to really, there's no definition in the rule that tells you what subsequent event is. So we do believe that that falls under subsequent event.
I'm going to let the state address that.
So Judge, for one, I do not believe, and the state will stand on the premise that that is not a subsequent event, an event that the defense is creating. And in this specific case, it's an experiment created by the defense to throw knives at a pig carcass. To create the general premise that it is possible that this defendant could have thrown this knife. So one, the factual scenario itself would not rise to really a consideration against the dangerousness of the act itself. But even then, the subsequent event, that isn't a subsequent event. They've created a circumstance that isn't factually supported by any of the evidence in this
Let me
case.
give you a definition of a subsequent event. Subsequent event is if you have victims who are living near, in the country and then move abroad. And that moving abroad means that the person's not a danger to those particular people. That's a subsequent event. Somebody getting a terminal illness and or becoming paraplegic and therefore not being able to travel, that's a subsequent event. Discovery issues and the hiring of expert witnesses, that's not a subsequent event. You can go to motion for reconsideration. That's why there are two prongs in the statute, reconsideration and dissolution. Dissolution means that it should be dissolved because in quote unquote, let me go to subsection, what is it, N. Because the subsequent event has eliminated the basis for detention. That's not what any of these are, okay? So that's not what this is. What you're asking for is reconsideration. Your creation of a video from an expert witness or your discovery of the body-worn camera for somebody that you didn't know existed at the time of the pretrial detention motion, although I know that it existed, but maybe you hadn't seen the body-worn camera, none of that is a subsequent event. So, nothing that is the basis, and I went through your entire motion, nothing is a subsequent event. However, I'm not going to strike it, I'm going to treat it as a motion for reconsideration, okay, under subsection K. All right, none of those are subsequent events, and I'm making the finding that they are not subsequent events. Nothing that is listed in your motion is a subsequent event. Okay, so I'm not dissolving anything, however, I will reconsider them. Okay, so we're moving on to reconsideration. You can discuss what it is that you believe that I should use now in an analysis for reconsideration, both of my ruling for the Arthur hearing as well as my ruling for the pretrial detention motion. Go.
We have evidence to present, Judge, in the form of Dr. Maricini.
Okay. All right, so would you like to call him as a witness?
Yes, I just have to see if he's here because we were set at 1:30 actually for this, so I told him to be here at 1:30. We can go through our other arguments, Judge, before we get to that, though. We have other evidence to present. Oh, okay, he's here, Judge. What would you like him to say? Yeah. And the only thing, Judge, is I had the whiteboard. He had asked. His courtroom is so it's hard to even. I tried to even bring it in, and it's very hard. Yeah, he's gonna want to use it. I don't know if we'll be able to even fit it in here. Is it possible for him to sit on that chair instead, Judge? Is there a microphone or no?
There's no mic.
Oh, there's no. Okay, because I was going to say it might be easier to just leave that whiteboard there. Mm-hmm. Yeah. We have some additional evidence to introduce. One is a clip of the video of Dr. Maricini during the demonstration. I believe we sent that to you, right, Judge? Okay, so I was just going to have him walk through that, what he was doing during it. I'm going to have to show it on my laptop, though, because we don't have a TV screen. So I'll just put it close to him where you can see it as well.
I'll allow you again. You can show me whatever you want to show as a motion to reconsider my previous ruling. I have already looked at most of what you sent, which includes the videos, body worn camera video, Mancini, and then the name of the microphone guy.
Dr. Ray. All right, I'm sorry, Mr. Ray. I'm just, Dr. Mancini is also an actor.
That's true? Yes.
So, Judge, the only question I have is the video that Your Honor saw, was it a singular video?
It's the same one you I showed you. Yeah, the first video for what?
So the throwing of the knives towards the couple.
So that was one of them, and the other one was Mancini checking the door.
Okay.
All three videos took body worn, knife throwing, and Dr. Mancini with the hit.
And we clipped them down to the shortest.
Is he here? Yeah. Oh, yes. The judge we would just call Dr.
All right, Dr. Mancini, if you could come forward. I'm going to have you sworn in. Do you have an eraser for the whiteboard?
And I have markers.
You swear affirm the evidence you're about to give, that you told nothing but the truth, all of that?
Good afternoon, Dr. Mancini. Can you, did you introduce yourself to the court already?
No, my name is Dr. John Mancini, M-A-R-R-A-C-C-I-N-I.
Okay, and very briefly, I just want to go over some of your experience as a medical examiner. Let's start just with your education.
Judge, I think we can stipulate to his expertise.
Perfect. Great, okay, so we would have him as an expert in the field of forensic pathology, clinical pathology, and anatomic pathology, in which he of course is an expert.
I will absolutely agree that he's an expert in all of these things.
Great, thank you. Can you tell the court what you were retained to do in this case?
Simply put, I was asked to investigate and review evidence as to whether a throwing knife, specifically the knife involved in this particular case, could penetrate and inflict the wound found on Mr. Obumseli.
And did you review various documents in making your determination, prior to making your determination?
Sure, I reviewed the complete work product of the Office of the Medical Examiner, including
Yeah, there's a step there that's on both.
I reviewed the complete work product of the Office of the Medical Examiner, including but not limited to the autopsy report, the autopsy photographs, and miscellaneous notes. I reviewed police reports, some police statements, some videos associated with this, and then we conducted some research collectively with a knife-throwing expert named Bobby Branton. And after the conclusion of these different things and the review of other evidence and statements, I formed an opinion regarding whether the knife could, if thrown, penetrate and inflict a wound as seen on Mr. Obumseli.
Let me ask you this. Did you review crime scene photographs?
Yes, I did.
What about the Arthur hearing transcript of the testimony of Dr. Hutchins, who is the medical examiner of the state?
Yes, I did.
What about the crime scene, the documents including the floor plan, the report and floor plan?
Yes, I reviewed all of those things.
I believe you said the medical records from the trauma center. What about the fire rescue reports?
I did.
Okay. Did you review Ms. Clenney's statement to the police?
Yes.
And did you receive, or did you look at any of the knives in question? And I don't mean the specific knife that was used in this case, I just mean the type of knife.
I asked the defense team to proffer an identical weapon so that weapon could be looked at and tested with. This was done both with myself and with Mr. Branton and so forth. And then there was some testing, which has been video recorded of the knife being thrown. I made arrangements to select a suitable biologic material. And what we finally settled on was using a side of pork, essentially.
How did you make that determination?
Pardon me?
How did you make the determination to use a side of pork?
Well, I wanted mammalian tissue with skin and muscle and other structures similar to the human body and the general way that we're struck. So we didn't need to go through bone, but we need to have a part of the pig that would have sufficient muscle, fat, fascia, and so forth with skin.
Now, and I know you're not here qualified as a knife throwing expert. Do you have any experience throwing knives?
Well, I've been an amateur knife thrower for about 30 years.
And did you yourself try to throw these knives in this case?
I did.
Now, did you participate in a demonstration that was done with Mr. Branton throwing the knives into the pig carcass?
Yes.
And can you just describe what your role in that was?
It was primarily to determine after the knife was thrown, to examine the penetrating defect and to see if the strength, resiliency, and other features of the tissue was similar to human tissue in the case of where Mr. Obumseli was struck, which was the upper pectoral area and the deeper.
Now, how the demonstration was conducted, and I mean specifically how far distance-wise the knife was thrown, that was something made by the defense, right?
Right, the defense proffered and communicated with Mr. Branton about what they wanted to do.
And you have no knowledge as to why or how that number was picked?
No, I don't.
And I mean, just to be clear, you weren't present on the day of the scene, so you don't have any specific facts about what happened on the night of April 3rd?
Well, I only know the facts as collected by crime scene and from other sources, but I was not obviously present.
Okay. So now going back to the demonstration, and what I'm going to do is I'm going to play it for you. And we don't have a TV, so I'm going to bring this to you, and you can say we're going to. Yeah? Oh, okay. Okay. Mr. Prieto is going to try to bring the TV in. Okay.
Yeah.
So in the meantime, we'll just keep going. Let me just ask you this. What is your opinion in this case?
That a thrown knife, such as identical to the one used in this particular case to inflict a lethal wound, could have been thrown and inflicted said wound.
And when you say could have, can you be more specific as, I mean, can you say percentages? Are you able to do that?
Well, I mean, the simplest way to divide between whether or not it was directly thrust into someone using the hand to use the leg or whether it's thrown, and we can use penetration. This particular knife is very sharp, and getting to the skin, it gets to the skin very easily. Most knives only require 6 to 12 pounds of pressure. So, a human being with even average or less than average strength could easily drive this knife almost 6 inches. But the actual penetration of this weapon is around 3¼ inches. So, also there's no hook mark. And so, these factors.
Can I stop you for a second because I didn't hear? I'm sorry. There was no what?
So HILT mark. In other words, when a knife goes completely through to where the handle is, it sometimes leaves an interface mark where the blade needs to handle. That wasn't present. So at the end of the day, I favor it being a thrown knife rather than it being a directly inserted knife as in the usual stab. The difference in penetration, in my mind, is one of the decisive factors that favors one over another.
And what about slippage, where there might be marks on the defendant? That can happen if a person is using a knife, right, to stab somebody?
Right. I mean, a knife that does not have what we call a hilt guard, which is like a cross piece to the blade, it's pretty easy when you drive a knife to, your hand to slip up onto the blade edge. No one's found.
Did you review the photographs of Ms. Clenney's hands?
I did.
Okay, and you didn't observe any kind of damage to her hands that would be the result of slippage?
Right, there were no cuts.
What about any defensive wounds? Did you, in your review of the photographs of Mr. Obumseli, did you see any defensive wounds on him?
I did not.
What, if anything, does that tell you?
Well, usually defense against knife, you see some cuts in the hand by the person who is receiving a knife assault with the hand, holding a blade and inserting. So we just didn't happen to see any in this particular case.
And I know that you wanted the whiteboard for a reason. Was there specific, you wanted to show the court something?
Well, I mean, if necessary, unless Your Honor probably gets it, so I probably don't use it.
Okay. Was there something specific?
Well,
just to make sure she understood?
I would just, show a trajectory of the throwing knife just for purposes of our discussion. And some other things that might be pertinent to the defense there.
Okay. What specifically would you think is important for the court to understand that goes towards your opinion in this case?
Well, there was a proffer by defense that at some point in time there was an altercation immediately preceding the knife event. And one of that proffers was that the defendant was assaulted by means of an arm going across the neck of Ms. Clenney by Mr. Obumseli. And so the question was there any physical evidence from the examination of the neck of the defendant, meaning photographic evidence in this case, that might indicate that?
Judge, at this time I would, do you have an objection to it? I can run it. Yeah, you're okay with it.
Can you offer whether or not these are the two pictures that you reviewed?
Yeah.
I don't have any questions.
Let me let Mark first. Take a look at these two photographs. Let me know if you've reviewed those.
Yeah, there's another one that's a little better.
I'll show it on. I'm going to show you on the screen because it actually comes out better than if it's printed. But you said that you have seen those?
Of course.
Okay. I would move without objection the defendant's
will become defense A, A2 will become defense B.
Can I have a moment and I'm going to hook it up on the TV here, please?
Ollie, can you move the whiteboard and see if you can see that?
Oh, okay.
So yeah, sure, put the TV right in front of the camera. That works. So yeah, she was a bodybuilder. She was a bodybuilder and model. She said she was 5'8". I thought she said she was 150. I thought she said she was 150. Because I'm like 5'10 and 145, 150. If she was 5'8 and 115, I think she'd be like rail thin. I don't think she was 115. All right, so we have this stabby expert coming up who's tossing it at this pig carcass. We played it once before, and we kind of gotten a little bit of trouble. Not anything like with the firearms, but so I'm going to be very careful with how we play this. This knife expert, the stabby expert. She was thicker than a Snickers. Yeah, 115 is a little too thin. Hey, Jennifer. Whether her bodybuilding steroids matter. I haven't heard anything about steroids. I haven't heard anything about that. Yeah, I've got my cats ready. I got my cats already. Cats are at the ready. I could just fast forward through it, but all right. First up is some pictures of hers, and then they show this. I don't know why we can't say knife. All right.
A1 or not? A.
It's defendant's A. I'm showing you defendant's A. This is one of the photos you said you observed?
Correct.
And what, if anything, do you see from this?
Well, can I step down, Your Honor?
Yes.
All right, well, this particular picture, there's several pictures of the defendant. This is one of many, and some of the other pictures showed it better than this, but there's a faint blue-green discoloration here and some faint reddish discoloration here. And, when we see that, it doesn't prove it because it's, obviously it's a very fine, but nevertheless, I would consider whether some pressure might have been applied to the front of the neck at some time. And then on the hands, of course, there's blood on the hands, but there's also some bruising, and it's better seen on the photographs actually, where her arms are down to her sides.
I'll show you defendant's exhibit B.
Okay. So what we have is some bruising here, some bruising there, and there are some other pictures where her hands, and you're seeing the knuckle side, and you can see some discolorations there. Now, the probative value of these are more difficult because I'm not quite sure the age of these. I can't say that this occurred immediately before the lethal event or not. But nevertheless, what you have is you have some bruises on the arms, you have some bruises on the knuckles, and you have a discoloration in the front of the neck. And that only came up primarily because of the defense theory that there was some physical interaction preceding the lethal event.
Okay. I'm going to go to the demonstration now that
You said that there were other photographs that you looked at that showed the neck better, or was there another photograph?
You can try to pull them up.
Just about a half dozen
There were
photographs.
quite a bit. I will see if I can look at some additional ones.
All right, go ahead.
Going to the demonstration, Judge, this is a digital evidence, so I have a USB to give to the clerk.
Okay.
Well, how would you like to?
What is on the USB?
There are 3 videos on there. The first one will be the video where he looks at the demonstration. The second one is Mr. Brandon doing the knife throwing, and the third one is the
Typically, we do it as 3 different USBs. George, how would you like to do that? Because it's all 3 videos on one USB.
If they give me 3 separate USBs, I would do that.
Okay, can I replace this one?
Yeah. So let's have, let's just go ahead and name which video is going to be each item of evidence, and then we'll replace them with the 3 separate USBs.
The first one would be, and I'm using the C1, which would be,
They're going to be entry, no stipulation?
will be the video demonstration with Dr. Mergy.
That's going to be defense, A3 will become defense C.
The next one will be a knife throwing demonstration video by Mr. Bratton.
A4 will become defense exhibit D.
And then the last one will be a body cam statement.
A5 will become defense E.
Okay. Thank you. If you want to take a seat, Dr. Mergy. I'm actually going to show you defense D first, because defense D is the actual demonstration. Can you walk through for the court just how that demonstration took place so that she can get an understanding? You know, where did it take place? How was it?
Sure. I'd rather stand up and...
Whatever you need to do, I just have to make sure that she can see. And as long as you can see, just one time.
We all good? Okay, so Your Honor, arrangements were made for me to fly to Columbia, South Carolina, where the studio would be setting up this production. The setup actually went on for a couple of days, and I arrived on the second day. The studio arrangement was indoors, air conditioned, and had video set up from a number of different angles. And was capable of slow motion and all sorts of technical things.
So it was a kitchen knife, all right? It was a small kitchen knife. What this guy actually throws approximates the actual, you know, I mean, what the, it's stabby. I don't want to get in trouble. Pointed thing.
The video was shot. While I was there, they began to work on a project which consists of taking the side of pork out and hanging the side of pork or hanging the side of pork on the front of the backstop board. And there had already been a layout of the physical distances between that board, that target, and where Mr. Bratton would be standing to throw the knife set. A set of 6 identical knives, presumptively identical to the weapon involved in this particular case, were available to Mr. Bratton, and then he began to do what he does, and that is throw knives. And I observed him throwing the knives, and then the penetrations, that is, the areas where the knives impaled, I then inserted a gloved finger to make sure that the tissue, in fact, was a reasonable representation and similar to human tissue that would have been affected in this particular case.
Do you know how many times Mr. Brandon threw the knife that day?
I don't know, I don't remember.
And can you say whether he hit the target every single time?
No, we did not.
And we already, I believe that you already agreed that the distance that was created for Mr. Brown to throw, it was your understanding that was made by the defense, right?
Correct.
Wait, ask that question again. The distance used for throwing was decided by the defense.
That's correct.
In your medical opinion, does the pressure used to cause this type of injury, does it depend on the strength of the person?
In this particular case, with this particular knife, in this particular location, very little strength is needed either for a direct thrust into the knife with the hand. That would be 6 to 12 pounds. And throwing the weapon just simply adds it's a little bit different than pressure, but it's a ballistic event. And you don't need a lot of strength, and you don't need a heavy knife, and you don't need a specifically designed knife, providing it's point on. And it doesn't have to hit point on directly perpendicularly. It can strike point on, below or above the horizontal plane, and still damage penetrate.
Now, would you agree with me that Mr. Branton's body size is not similar to Miss Clenney's body size?
Right. He was, I think he was 5'10" in height, and he was overweight. And I think Miss Clenney was proper to be 5'8" and 150 pounds at the time of the incident.
Does that change your opinion, the fact of how the pressure and how it goes in with the knife? Does it change your opinion based on the fact that you watched a demonstration with an individual that is not similar body size, weight as Miss Clenney?
No, I mean, it's qualitatively the same event. It's just a matter of different body mechanics, and Miss Branton could better address that. I'm not an expert in how people throw knives who are novices, and so he could talk about that.
Judge, at this time I would ask to publish Defendant's Exhibit D so we can have Mr. Maricini confirm that was what he observed on that day. I'm going to play this video.
All right, here's the incident coming up, or the experiment. I want to show like just a little bit of it. Let's just so you guys can see. All right, there's some of those. So those were the size. All right, let me put in. We'll put Super Ball here.
Now, we're going to see there's no sound here. Do you know if there was a sound recorded or not?
We did not do a sound recording.
All right, hold on a sec. Let me, I hate that we have to do this. This just irritates me to no end. But such is the world we live in. All right, let me do this. All right, hopefully that'll be okay.
Can you describe to the court, I mean, obviously we can see what's going on, but from your observation as an expert medical examiner, what, if anything, does this demonstration show you?
Well, he threw 6 knives, and he essentially had 3 of them stick, and the 4th one came in and hit one of the 3rd one, knocking the 3rd one out, but probably that would have been an impalement. Then there was a clean miss, number 5. Number 6, the impact was just barely grazed the side of the carcass. It was not representative. So what we did was, where this, you can stop the previous, go back 1 inch.
Okay.
But what we did was, the knife at the point of impalement, where the skin touched the edge of the knife, indelible marker was used to mark the side of the knife. And then after, as you see here, and then after that happened, the knife was removed and simply put in front of a tape measure ruler to measure the inches of penetration. And so that's what's being happened here. This is, you can see that this particular penetration was in excess, close to 5 inches.
And what was, in this case, Mr. Obumseli, the depth of the knife wound? What was that?
It was about 3 1/4 inch, something in that order.
I'm going to show you Defendant's Exhibit C.
All right, apparently I got to get Super Bowl ready again.
Well, I see, obviously. So what I'm doing is inserting my finger in the defects above the penetration to confirm that the resistance of the tissues and their general features was similar enough to represent the useful for analysis of the penetrating wound present on Mr. Obumseli's body.
And you said you did this. What was the result of that, by you putting your finger in there? What did it tell you?
It confirmed that the tissue was a satisfactory representation of the human tissue for purposes of this experimentation.
What are you doing right here?
All right, so let me just show what I did, and then I'll explain what I'm trying to do here. So now you can stop it there. You can freeze it for a moment. So what I'm trying to do, what I've done is I've inserted the knife and then turned it, rotated it to see if I could find an accessory mark. Now why is this important? In this particular case, when you look at the wound as it goes through muscle, fat, fascia, etc., that wound is just an elliptical wound like you expect to see with a knife injury. I can draw that on the whiteboard in a couple of minutes. But the question was, let me come back to it. Let me show your other image and then...
If you're going to show us something, can you just reference what you are looking at, please?
Yeah, do you have one of these?
Mr. Evans, he's referencing...
The picture of the knife.
Nothing, I just wanted you to see what he was referencing.
Okay. Let me get a color version of that. I'm sure it will be.
So what you reviewed are the autopsy photos and specifically the wound that was on Obumseli.
By the way, this is something else that might be useful if you want to look at that later. Okay. Hold on a second. I know I got it here. All right. So this is the picture I'd like to show.
Well, it's not in evidence, so,
You want me to hand it to you?
yeah, let me.
You have my copy. And actually, what I'd like to do is these two. Okay. So these two would
Judge, without objection, will be moving defendants F and G into evidence.
A6 will become defense F, and A7 will become defense G.
And I'm going to show them to the court first, and then. Doctor, if you'd like to, if you could just reference whichever one you're looking at the time, and you can explain your testimony.
Okay, first of all, this is a photograph which gives the general location of the entrance wound for the only wound caused by sharp force.
And specifically, you're referencing defendant's exhibit F.
Right. So you can see this is an elliptical wound. The wound is typically bigger than the knife itself. And the reason it's bigger than the knife itself is that, in my opinion, this defect that we have here is not from the knife just coming directly perpendicular, but from a slight angle. And I can show you a larger image of this.
Why is that important, or what does that have to do with your opinion in this case?
So that was Christian. His face was pointing that way. It looked like he was like right here. Looked like he got hit like right here. So not in his heart, like below his shoulder, but in his chest area. That's what it looked like to me. So not in his back, on his chest.
The slight angle.
Well, Your Honor, that slight difference doesn't mean a whole lot in this case, except that I wanted to explain size and marks to make it clear what we're looking at. And that would help us with some of the issues we're talking about. All right,
Now
so
looking at defendants G.
defendants A7.
And G.
Oh, no, G, excuse me. I'm sorry. All right, A7 is a larger picture of this hole. Now this is like 4 centimeters and change in size, and the width of the blade is not nearly that wide. But getting back to the original, why am I doing this to the side of pork with the knife and twisting it? I was trying to figure out this mark right here in the skin that's adjacent to the hole. So the hole is like an ellipse. If you look further in, it's a rather narrow elliptical mark. But here, there seems to be more going on at this one end. And so I was trying to figure out if that was evidence of a twisting of the blade, either in reference to the state's theory or in reference to what had been proffered, which was that Mr. Obumseli removed the knife himself from his own chest. So then I was trying to figure out, well, if he did that, well, could he have twisted it, taking it out, because naturally well, not naturally, but you might expect some difference in mechanics from a throw knife and a removal and so on. But when I attempted to do this duplication, I didn't see a lot that resembled this. So my bottom line conclusion is that this is an artifact related to attempts to save Mr. Obumseli's life. And you can see basically some suture holes here for where the needle went through with suture material. And it's probable that this is just an artifact of the attempts by the surgeons to save his life. But I went through the extra maneuver of putting the knife and twisting it, and it really didn't look like that at all. When you want to twisting the knife, the cut came off at more of an angle here and further up. So this is not from the twisting of the knife blade either, coming out by either parties. So I wanted to dispense with that in case there became an issue at a later date. So that's what I was doing with the side of pork after Mr. Brandt had done most of this work.
How did the pig's skin and density compare to the location of the wound in Obumseli?
Well, I would expect that pig skin.
Objection to the speculation. He wasn't there for the autopsy.
Let me just be clear, from your review of the photos and the records by the medical examiner, how would you say that the pig skin and density compared to a human body, first of all?
Well, let's talk about the skin per se. The skin here is processed a little bit to remove the fur. What remains, the epidermal remnant of this skin, is probably a little bit tougher than human skin at this particular site. Unlike the elbows, the palms of the hands, the forearms, and other areas, this area under the clavicle, the skin doesn't have particularly a lot of resistance or as much structure as elsewhere. So once again, if anything, the pig skin per se in this particular model would offer more resistance, but certainly not less resistance than the skin of a human being at that site, based on my dissections of that area, 4,000 autopsies.
No, you weren't present for the actual autopsy of Mr. Obumseli, right?
Correct.
So you didn't actually get to feel what his skin feels like.
Correct.
But as you said, in your over 4,000 examinations, the skin type differs so greatly.
It doesn't differ that much. And this area is cut through very often because, as you may know from an autopsy, there's a...
Sorry, I just had a thought. And when you claim self-defense, your response has to be equal in, I forget the wording right now, but it has to be equal. So if somebody's coming at you with fists, you have to defend yourself with fists. You can't pull out a knife. Well, I guess then there's stand your ground. Shoot. Isn't there something when, like, you can't, like look at Raul Valley, he brought a knife to a fist fight. So it wasn't equal force. It wasn't met with equal force. But then there's stand your ground. So that's where it gets confusing. So if she's truly claiming self-defense and Christian's coming at her, for her to throw a knife at him for her to throw a dart at him doesn't meet that level of an equal force. But then there's the stand your ground doctrine in Florida, which muddies everything. So I don't know.
A wide incision in the front of the body. So we very commonly go through this area to enter the body as part of the basic autopsy procedure. So I have a lot of experience cutting through this area in thousands of autopsies.
The states, you read the examination, direct examination and cross-examination from the other hearing of the medical examiner, and you heard him, and his opinion is that this could not have been an injury caused by a throwing of a knife. Do you agree with that testimony?
No. Objection, Judge, said that wasn't his opinion. It wasn't conclude, like, his complete opinion.
I mean, I will rely on my own memory of what it is he said. I also have a copy of the transcript, but in general, I understand your questions all about it.
Right, it's my understanding that the medical examiner's statement as reflected in the transcript was his opinion. It was his opinion that a knife thrown by this penetrated and caused the woman in question. And I disagree with that for the reasons we just talked about.
Okay. And you reviewed Ms. Clenney's statement?
Yes.
Is your opinion consistent with Ms. Clenney's statement that the knife, she threw the knife?
Yes.
If I can have a moment, Judge.
All right, so reading your comments then, is it reasonable that she had the knife, had the dart? Is it reasonable? Then John doesn't need to be armed in all 50 states, needs to be reasonably perceived to be imminent threat or great injury. Stand your ground is irrelevant. So is it reasonable that she grabbed that in self-defense? Is that reasonable? Crunchy 5'2" girl. Well, she's 5'8", but whatever. 5'2". She's 5'8". He's like 6'1". She has to meet with equal force, which could be could be. You haven't really heard anything about stand your ground. They haven't done anything about that. She's just saying self-defense. She's saying Christian charged her, and that's why she grabbed the dart and tossed it. So.
I have nothing further. Okay.
Good afternoon, Doctor. Good afternoon. Okay, so first off, you were hired on this case by the defense team?
Correct.
Would you explain to the court your hourly fees?
My actual rate is $600 per hour.
And to date, including your testimony today, how many hours have you appeared or worked on this case?
Around 15,000 would be the amount. So do the math.
Okay. So now, this experiment that was done, you were brought in and informed of the circumstances. You yourself were not outside of the defense team. That's your only knowledge of what happened in this case.
Well, yeah, I think the statement that the defendant made at some point in time was sort of an approximation. But she was in a room, and they asked her, how far away were you? And she said, well, how big is this room? And they said around 10 feet or something, words to that effect. And what was drawn for that was an initial 10-foot measurement. So that all of that was a proffer.
Well, you've seen the video that was just shown to the court. It's your opinion that that is a 10-foot distance?
No, there's a 10-foot range set up, but Mr. Branton has moved in closer for the actual total.
Can you explain to the court why is it that Mr. Branton threw from 5 feet instead of the 10-foot distance of the room that the defendant stated in her statement was roughly the distance that the victim was from her?
It's my understanding from a proper defense that they revisited the scene with the defendant or talked to the defendant at some point and established where exactly she was standing and where exactly Mr. Obumseli was when the event occurred. And they recalibrated to an opinion that it was about 6 feet.
So you were not there for those conversations?
Correct.
But it's your testimony today that the defense disregarded the defendant's own statement to police and created a different distance based on subsequent meetings with her.
Right, if you want to go back to the video, we can go over that. But at the end of the day, an adjustment was made based on the defense doing an assessment at the scene of what the actual distance was. And using that assessment, they then instructed Mr. Branton as to what to do.
Are you aware of who was there for that subsequent meeting?
No.
And in regards to the style, and actually, so we're discussing the conversation, the actual statement of the defendant. So not only has the defense disregarded the distance that she says, can we talk about the style in which we see Mr. Branton throwing these knives?
Sure.
And the video speaks for itself, and correct me if I'm wrong, he's stepping forward into it and directly throwing it almost, as a pitching, not necessarily art.
Right, he's using a different style, and he's using forearm extension at a closer distance. And we had some discussions of what happens at 10 feet. He was doing something a little different at 6 feet.
And why is it that we are seeing him change the style of throw from what the defendant said she threw this knife like in her statement?
Well, I don't know that she gave a lot of particulars exactly how she threw the knife.
Well, you have good knowledge as to the distance that she says. You should also then remember that she says she flung the knife. Right? You remember that?
Well, she said she flung the knife, but to me that doesn't, it's like saying I flung the baseball. I mean,
well,
I don't know, I don't have a clear idea about how much follow through or extension is in our arm. And I think Brett discussed that a little bit in his depo.
Well, when you end up receiving this statement by the defendant, was it the video recorded statement or was it audio?
I can't remember.
Well, do you remember being able to observe the style in which the defendant showed the detectives how she flung this knife?
I can't remember.
You are in agreement, though, that Mr. Branton has changed the style in which the defendant has shown the detectives she threw this knife.
I would rely upon the view of her statement, the image, the video. I can't remember what the video showed right now. But I would simply compare that video and what Mr. Branton's done. I don't know what else to say.
Well, you said also you had a chance to review Mr. Branton's deposition.
I did.
All right, and you are quite aware that Mr. Branton says, he can't confirm whether Courtney would be able to throw this knife, if the defense attorney would be able to throw this knife, but he would say that he could at least get the knife to stick.
Sure, that's what he said.
Him being a knife throwing expert.
Yeah, sure.
And you have no knowledge as to the defendant being a knife throwing expert.
Correct.
You'd also agree that, and it's very clear from the video, the differences in body shapes and sizes for Mr. Branton and the defendant.
Yes.
He's got multiple inches on her.
Yeah, he's several inches taller, and he's also probably twice as heavy as she is. So.
And logically speaking, someone who can generate that, or has that much weight to them, would be able to generate a much larger amount of force stepping forward.
Yes.
So the fact that we're looking at the larger than the defendant, taller than the defendant, Mr. Branton, throwing a knife from a different distance than what the defendant says, this experiment is completely different than what the defendant said and the circumstances she faced at the time in which Mr. Obumseli was killed.
I wouldn't say it's completely different. There are some differences. And, rather than me trying to go from memory, I think the court will draw out those differences in time.
Well, that's why in a hearing I can ask you about your memory. So go ahead, tell me, what are these specific instances that are the same?
Well, the weapon's the same.
Oh, let's talk about the weapon. So the weapon itself, did you go and inspect the weapon?
I didn't inspect the original.
Why not?
Because I was proffered that the weapon was identical to the exemplars, number one. Number two, I would not be at liberty to throw the original weapon. Number three, there was sufficient photography of the original weapon to show that the tip was not dented and that the weapon did not seem to have significant wear.
But you would not be able to determine the actual wear, the actual sharpness of this weapon, unless you analyze it yourself. Is that not correct?
It's true.
Right, so you guys for this experiment purchased knives that are the same type, but you did not create the circumstances in which this knife that was impounded, that would have been available for you to inspect, to make that comparison.
I worked at the proffer that there was no substantive differences between the test knives and the actual knifing event.
You talked about the resistance of the human body, but again, you're not there for the autopsy of Mr. Obumseli, right?
Correct.
You don't know the condition of his skin, the muscle density of his body. You could not recreate that in this pig without actually being a part of that autopsy, right? You could not guarantee that to this court.
I can guarantee that it's reasonable. I can't guarantee it's identical.
So again, you are changing the circumstances that were faced that day.
Well, we don't do experimentation on human tissue, so we have to do the best we can with mammalian tissue. But yes, it wasn't, 100% identical to that of Mr. Obumseli.
And now, have you ever seen or observed the defendant throw anything?
No.
Do you know whether or not she could, actually, not do you know, you don't know whether she could generate enough force as Mr. Branton throwing that knife at that pig carcass?
Well, I don't know about the word no. I think it's likely she can. And the reason is, the penetrations that Mr. Branton got were almost 5 inches. And we only really need 3 1/4 to duplicate what was seen in this particular case.
So again, though, you're saying it's likely. You have to speculate because you don't know how she throws, you don't know how hard she can throw, and again, you've changed the circumstances and style in which she is thrown in your experiment.
I haven't changed anything, but I observed what was done by Mr. Branton.
And this observation, this experiment was set up by the defense team.
Correct.
You are also quite aware that multiple attempts, the court has only seen one of these attempts at throwing multiple knives at the carcass, right?
I don't know what you've seen. I know there were a number of hours of video talking.
So you would be aware, you were there for all of it that
Yes,
day.
I was.
And so you were aware that roughly only 50% of the knives, even Mr. Brand, he was only able to get roughly 50% of the knives to stick on that carcass.
Well, in the last video we saw, it was probably close to 4 out of 6, because one knife knocked the other knife out. And then when 2 knives coincide at the same target, they generally interfere with each other, and then you wind up with neither of them sticking. So, but the answer is, let's go 4 out of 6 in that particular run. I'll go with 3 out of 6, that's fine. It's not 100%.
Right, so the knife throwing expert can only get 50% of the knives to stick at a closer distance than what the defendant explained in her statement. She was from Mr. Obumseli.
Right, so that's an interesting point. That means that the defendant had no reasonable expectation of seriously harming Mr. Obumseli.
You mean throwing a knife at somebody isn't expecting to? That her allegation of throwing a knife? I would say throwing any knife would be inherently dangerous, no?
Oh, it is. But lethal, you're telling me, and I would agree with you, that it's not a high probability that she would connect. But nevertheless, if it does connect, then you have an individual like Mr. Obumseli who's legally injured.
And so you would agree that the experiment that you observed is different than the circumstances in which the defendant faced that day?
It could be. I can't affirm 100% that there's total agreement.
You mentioned during autopsies that medical examiners, cut open this general area of the human body, right?
Correct.
What is the type of device that's used to cut open a human body?
Well, you can do different things. I would typically use a scalpel.
And so the amount of force that's needed to cut open, you can't say that that is what Mr. Branton is using in this experiment.
Mr. Branton. Okay. I'm sorry. Could you repeat the question?
Of course. So the amount of force that one would use to have to use a scalpel to cut open someone's chest, right there. You can't say that that amount of force is the same that Mr. Branton uses in the experiment.
All I can say is when I went to cut the skin of this pig sample with that knife, that it was almost as easy as a scalpel. So it's a very sharp knife. It cuts very easily.
You mentioned that there are no markings on the defendant's hands for slippage. Again, though, you don't know the circumstances. You weren't there on the date of the incident to determine slippage. Whether or not the knife actually slipped in her hand at all when she stabbed Mr. Obumseli.
No, what you can say is the converse, that if she was holding a knife and if she was stabbing it the conventional way, that there was no evidence that the knife slipped up, the blade engaged the palm or surface of the hand or any other surface of the hand.
You mentioned for the photograph showing the bruising on the arms, you can't tell at any point in time when those bruises were left or how they were left.
I don't know at any point in time, but I'm willing to say that the bruising is probably less than a week old. But how recently, I can't really say.
And that would be the same for any sort of marking on her neck.
No, not really. I mean, the marking on the neck looks completely different than the bruising in the hands. The bruising of the hands is dense and multicolored.
And could you show the court exactly, this is State or Defense Exhibit A, exactly where it is that you're talking about this marking on her neck?
I would just ask if I could use the original photograph on here versus a copy because it's not as clear in the printout.
This is your evidence. So you can, I have no issue with you showing it, but I would just like, I'm trying to have him point to exactly where the court should be looking.
Show it.
Okay, Your Honor. So we're seeing some discoloration. Step down so I have another advance here myself. So, we look here to see if we can see any discoloration, but more importantly, whether we see any reddening of the skin in these areas. So this is inconclusive. I don't mean to affirm to the courts that I can look at this and say, that's it. But nevertheless, we are concerned about these marks, and there are better images from the collection of images of Ms. Clenney than this particular photograph for both the hand and the neck stuff. So.
But again, though, you have no clue how, if there are any marks, how they got there, or when.
I was asked in a proffer, could this be from Mr. Obumseli applying force to the neck of Ms. Clenney? And if the question is, could it be, the answer is yes.
Okay. So Judge, the only other thing that I would do is, if Your Honor so wishes, we can introduce, we have the other videos if Your Honor continues to see them. Otherwise, I have another question for you. There's multiple attempts, so Your Honor only got to see one of the tests. I guess the number of throws, there's, I believe, 4 other attempts at this carcass to throw next.
I'd be curious to see this.
So, if defense is willing to
No
sit
objection.
okay. So then, we could publish them, Your Honor, or if not, then we could just provide them to the court for Your Honor to review. But
Are they on the same, are they on any of the same?
we'd have to mark it.
Okay, so you can publish it and then we'll have it marked as a lead as well. So you could just put the additional 4 videos as part of the state's evidence and they'll provide a different variety of just those videos.
So now we're going to see a 4-up. They're going to show a 4-up of this dart throwing incident. So I'm not quite sure how I'm going to handle this. We'll cross this bridge when we get there.
Can we go ahead and publish?
Yeah, no objection, Judge. I would just say that it's going to be, they're very lengthy if we go from start to finish. I don't know if they've been cut.
How long are they each?
They're roughly 3 minutes, I believe.
We have no objection.
Show me a couple and then if they're long.
Jane, we heard that you're asking what direction. I think they said slightly down. That's why I want to hear from the medical examiner. Hopefully on Monday, we'll actually hear from a medical examiner. But I think they said it was slightly down. Slightly down.
And I'll go ahead and take them back and take them.
All right, so maybe I'll put up Super Ball for a little bit here. Let me see here. I think this is let me try this. I hate that I have to do this, you guys. Trust me. I'm not a fan that I have to do this. But let's just see. Actually, I think I'm going to do it this way. I'll put Super Ball over here. Then we'll do that. And trust me, I hate that I have to do this. Oh, Lordy, then we got the one up there. All right, let me get this one over here. All right, we got dual Super Ball. Try that. So he's not 10 feet away. That's the other thing. She said she was 10 feet away. He's like 5 feet away. He's not 10 feet. She said she was 10 feet away.
And while we're setting up this third one, just very briefly, Mr. Marancini, or Dr. Marancini, I apologize. And if we could pause that really quickly. The way that Mr. Branton is holding the knife, is that specific to a knife throwing expert?
I don't know the answer.
I'm sorry?
I don't know the answer.
All right, you and your amateur throwing status, would you be able to hold, or would you hold the knife in the same way for purposes of trying to stick it into a target?
Well, when I threw from 10 feet, I held it differently.
So the question I have then in that regard, in this instance, do you have any knowledge as to this is in fact the way that it's alleged that the defendant held the knife when she apparently threw it?
I don't know. By the way, just to clarify, even though the left foot is extended forward to here.
So a couple questions there. David, he's 6 foot or 6'1". I think Sherry just posted he was 6 foot and like 220. Courtney's 5'8" and 150. And Ray, glad you're joining us. We get smacked by YouTube for the most bizarre things. We got taken down for firearms issues, showing court and people in court. We've gotten taken down for that. We've got smacked showing Lindsay Clancy because of the talk of self-deletion. So we're really super, super sensitive about anything like this. So trust me, not happy about it, but we do what we do to protect our channel, to continue to be able to show you at least this. So we're just doing our best to protect our channel. So thank you for asking, and thanks for joining us. Oh, the knife throwing guy? That I don't know, David. I'm not sure. I don't know. I don't think they said. They may ask. He may ask. I'm not sure. All right. Super Bowl, come on.
His belly, the front of this gentleman's belly never really goes past 6 feet. And his center of mass, even though he leans maybe a few inches, doesn't really step through the throw. So it's a forward leaning of the torso, really only a matter of a few inches at most. And the center of mass is basically moving from here to there as he executes the throw. So it's not like stepping into a 1-2 throw, it's still a relatively static throw in there.
All right, again, sorry we got to do this. We just trying to protect our channel because you never know.
Just briefly. So Dr. Marancini, you picked out the pig carcass that was used in this, right?
Yes.
Did you, when you're making these experiments, doing these experiments, are you replacing the pig every time?
No.
So, in essence, if you're hitting a spot that already has a knife mark, it is easier to penetrate.
Yes.
I didn't realize they did 4 experiments. This is like the 4th experiment. So I guess it doesn't really matter how tall he is. David, you were asking, because he's trying to throw it all up and down the carcass of the pig. So I guess it doesn't really matter, right? It doesn't really matter how tall he is.
Because I don't have any other questions for the witness.
And stage 1A will become stage 1.
Dr. Maricini, prosecutor asked you about different circumstances that were reviewed in this case, other than what really Ms. Clenney said. Do you remember him going over several of those circumstances? Okay, so the first one he asked you about was the way the knife was thrown, and you mentioned that Courtney said the word flung. Do you remember him asking you about those questions?
Yes.
After reviewing the testimony, do you know whether law enforcement or the detectives asked her any follow-up questions to be more specific about what that meant?
It's not my recollection that said specific questions were asked.
Now, they asked you about the 10 feet. That was something Ms. Clenney said in her statement, right? Do you recall that the last thing she tells them is they should look at the room?
Yes.
Meaning the apartment?
Yes.
Objection, Judge, is speculation.
I don't know.
No, it's not, Judge, for what the defendant meant in her statement.
Oh, I thought she was asking what was actually said in her statement, and did you recall that being said?
No, the last statement, Judge, was a speculation as to what she meant. Whether it be the apartment or
I think he
the
said
office.
he didn't know.
Okay. Yeah.
That's her copy.
What's the division? 8-8, defense 8-8 will be defense H.
Judgment will move to evidence defense H. Then, Dr. Martini, I'm just going to show you defendant's exhibit 8H, excuse me. Can you just take a look and tell me if this is something that you have reviewed, both pages?
Yes, I've reviewed it.
Let me give a copy to the court.
Is it evidence or not evidence?
He's holding the one that's actually in evidence. That's your copy, Judge. Looking at defendant's H, this is the diagram from Courtney Clenney's apartment.
Yes.
And this is from crime scene, right?
Presumably, yes.
You said that in the beginning of your testimony you did review documents given to you from crime scene.
Yes.
Okay. And can you tell us, looking at number 15, going to the second page, what number 15 actually is? What was located there by crime scene?
I have to look at the alleged counsel. I wouldn't want to speak from, let's see. The global knife was located at 15.
Okay. And looking at the diagram, you listened to her testimony, and her testimony, do you recall where she said that she was by the island and then she threw the knife at Obumseli?
Yes.
And looking at the distance between right behind the island and 15, would you say that's less than 10 feet?
I'm sorry, from where you went that?
If you can tell, if you can't, that's okay. If you're able to see from the diagram that it looks that it is less than 10 feet.
Well, the
based on
island looks less than 10 feet in length.
Let me ask you this. One of the things she testified to was that Obumseli started aggressively coming towards her, and that's when she threw the knife. If somebody starts moving...
Judge, so first off, this is outside the scope of my cross. Also, it's calling for a speculation.
Judge, I don't think it's beyond the scope because he asked questions about her testimony, various questions about the testimony, and the circumstances that are different, so...
Let's hear what the full question is.
The question would be that if somebody is moving, how the wound, or how the knife, if it was thrown, how it would be consistent with the wound.
Okay, hold on.
The wound that you observed in this case, Dr. Maricini, how was the knife? Was it at an angle? Was it straight in? Can you tell the court what it looked like?
I do apologize. Are we talking about the carcass, or are we talking about autopsy?
No, the autopsy of Mr. Obumseli.
Okay, so the knife wound goes inward, mostly front to back, but slightly from the deceased right to the deceased left.
Can you describe whether, does that mean it was at an angle or not an angle?
Well, it is a slight angle, in my opinion. The ME didn't seem to think so. It's not that much, and it doesn't change any of my opinion, so for the evidence as far as I can tell.
And if somebody were, if Obumseli were walking aggressively towards her, would you say that that wound is consistent with somebody doing that?
Objection, just speculation.
I'm asking you to, based on her testimony, and you're an expert, so you can give your opinion.
I'm a little bit confused by it, but go ahead.
I mean, it's consistent with that, but it's consistent with many other events.
Now, you were asked whether if anybody else could do this other than Brandon, who's a knife throwing expert. Were you present when I threw the knife during the demonstration and it stuck in the carcass?
Yes.
And I was able to throw this knife and make it stick?
Yes.
You don't know me to be a knife throwing expert, do you, sir?
I don't know you that well, counsel.
And you're...
I'm just wondering whether they're going to be amending a witness list and maybe testifying as to how much force you might have put into that knife.
Your fees in this case, are they in line with an expert who has your same experience?
As far as I know, counsel.
Have a moment, Judge. I have nothing further, Judge. Yes.
All right, can this be excused? Can you step down? Vote for this. You have one question that you really need to ask on recross?
Judge, I would ask probably two.
Yes, go ahead.
In regards to the last questions about defense counsel potentially throwing a knife, was that ever recorded? Do you know?
Well, not unless the video is still running.
Okay. And the circumstances to which she threw this knife, were you made aware of any of them at the time that she threw this knife?
I can't recollect.
And lastly, the exhibit, which I believe is H, the CSI diagram, the item that is marked as item 15, you would have no knowledge as to how 15 got there.
No.
And you would have no knowledge as to whether Mr. Obumseli was standing right in that specific spot when he was struck by the knife, as alleged by the defendant?
No, I mean, the knife is more or less at the beginning of the blood trail where it's found.
And in regards to her statement about where she's standing, you would have no idea of where exactly around this island to be able to place her on a specific spot on this diagram?
I have no opinion.
I have no further questions.
I have had the request for a quick break, so if the witness is allowed to step down, we'll take a 5-minute comfort break and then
So unfortunately, we do not hear the rest of that. She said they're taking a little comfort break, so I could not find the rest of that hearing. So we're going to jump forward to December 19th. And Clairview and Linda, welcome in, you guys. Good to see you both. Thank you for coming in. Hey. Stop.
For the record,
Khalil Quinn and Kathleen Hoke for the state of Florida.
Sabrina Puglisi, Frank Prieto, and Diane.
Super Bowl attacking poor Roger. Hey, cats. Feeding time here. Super Bowl, just stop being mean. All right. Let me just get this queued up. This is from December 19th of 2024. All right. All right, apparently this gets heated. I have in my notes that this is heated. A heated hearing. So let's see what this what this brings.
versus Courtney Clenney. If everybody wants to announce their presences for the record.
Khalil Quinn and Kathleen Hoke for the state of Florida.
Sabrina Puglisi, Frank Prieto, and Diane Crumpness for the defense.
Okay. And then, good afternoon. And then I have the motion to intervene from the Miami Herald. Okay. All right. So we had before us what defense had titled as the unopposed motion to determine the confidentiality of the court records and the state's memo of on regards to that motion. So we're here right now for that. It does relate to the motion to depose Mr. Khalil Quinnan. But right now, the motion for intervention is what I think that we need to address before we go forward with that motion to depose. Thank you. And so we rescheduled this so that we could hear from everybody, including the Miami Herald, about that request. I did read through everybody's, well, obviously the original motions, the Miami Herald's motion to intervene, and then the responses to the Miami Herald's motions to intervene, which I think were filed by both parties this week. So let me hear from the state and defense, both about the initial motion without referencing anything that's not already on the court record about what you're asking to be confidential. I think at the last setting, we almost went into some of those facts. We're not going to do that today. And then I'll hear from all of you I'll hear from the Herald about the motion to intervene, and then the state and defense about their responses to that.
Do you want me to start, Judge, since it's my motion?
Oh, yes. I'm sorry. It is your
No, that's all right.
motion. Yep.
So, Judge, I don't know if you need me to, it's laid out in the Pleading Florida Rule Judicial Administration 2.420, kind of the process on how that works as far as subsection F in criminal cases, which takes you to a few other subsections, but really it is C9A1, little I, Roman numeral I, that says that records are exempt if it prevents a serious and imminent threat of fair, impartial, and orderly administration. So that's kind of where we start in the rule, and then we move on. You received the document in question, and I think the first thing to say is that document was drafted specifically for litigation purposes. I think that's clear. I also think, I know one of the arguments the prosecutor made is nothing within the document has not already been publicly stated by either of both defense counsel, had not already been made public through discovery, or will not inevitably become public. What is inevitable to become public is not something that should matter to the court, because the defense in a case does not need to be laid out and until and unless the defense is ready to do that. Could be motions in limine that the court puts in an order as far as when that's due. It could be, for example, just generally speaking, if a defendant were going to testify at a trial, the court doesn't get to know that. The defense doesn't have to say anything. The prosecution doesn't get to know that unless the defense announces it, or right before it's that portion of the trial, the judge asks that of the defendant. So I think we can generally speak about the document without going into the specifics of it. Just like anything, it's obvious any defense lawyer is going to do investigation and do research, legal research, and try to find witnesses. Those are generalities, which we can talk about without getting into the actual specifics about what that is in the document. And I think that is what the rule requires for the judicial rule of administration. It says you must be able to specify and identify it, and with specificity, but without going into the reason why it's privileged. So I guess the real question here is this document privileged? It's attorney, client, and work product. We believe it's both. And the standard is different with respect to both. And so I think the first thing the court needs to do is, one, determine if the document is attorney, client, and or work product privilege. Two, if the court does believe it is one of either of those, whether it was waived when the defense disclosed it to a third party that was not Ms. Courtney Clenney. And three, even if the court believes it is one, not privileged, or two, yes, privileged, but was waived, should that still be kept confidential and sealed? And I think this is the only part, and I'm not going to speak for Mr. Ponce, but I think that's where we kind of differ, which is even if the court doesn't believe this is a privileged document or believes we waived it, it still should be kept confidential because it's information that should not be disclosed to the public. So that's kind of where we're at. And I'm happy to go into each of those. I did brief them, but I can speak briefly as to each of the privileges first and why we didn't waive it.
Give me your bullet points on the attorney-client privilege, and then we'll go into work product. Yes.
Okay. So with respect to attorney-client, if you look at 9502C 1 and 2, specifically, a communication is confidential if it is not intended for third parties except one, those to whom disclosure is in furtherance of the rendition of legal services, and two, those reasonably necessary for the transmission of the communication. So the question here is, what is in furtherance of the rendition of legal services? We know that the Clenneys, Mr. and Mrs. Clenney, the parents, are paying the legal fees. That came out in the Arthur hearing. Mr. Clenney testified and he talked about it. So the fact is, and this really applies to any case where family members are paying for the fees of their loved one, defense attorneys do speak to them because they need to discuss. Can you imagine what the ramifications would be if I just went to a client and I said, for example, give me $50,000, and I'm just throwing a crazy number out. Give me $50,000. I'm not going to tell you what I'm going to do. I can't tell you anything about the case. I can't tell you any experts, any investigation, any motion. I'm not going to do anything. That's just not practical. And that's why the court specifically in this rule, actually, that's why it specifically allows for attorneys to be able to discuss if it's in the furtherance of rendering the legal services. And if you look to the case that we cited, Gerheiser versus Stevens, that's Gerheiser versus Stevens, Stephen's. That's a 4th district case from 1998. And there's really not a lot of cases on this, Judge. So really this 4th district case, it was a mother who communicated with the lawyer about hiring or retaining them for her son. The question was whether that communication was privileged. And the court said that, yes, it is privileged because it is in furtherance of rendering legal services. The state cited State versus Black, where it was not considered privilege. And that was a jail phone call between a defendant whose sister made a three-way call to the attorney. And what the court said is, no, this is not like the case of Gerheiser. This is different because one, it says the call is going to be recorded as you're making the call. So that should have been known. And two, in that case, the attorney didn't explain why, that person's needed to be on the call. So it can be distinguished. As far as, and just to be clear, Judge, we were communicating what needs to be done in the case because they need to understand in order to be able to be prepared for the costs that will be involved and to justify the fees that were being charged. So I think this clearly falls within a communication that would be under attorney-client. Now, with respect to work product is actually even, it's even broader. And the court knows about this because in the last hearing we had, you even in the order, you distinguished between opinion and fact work product. The case of State versus Rabin is very good at kind of laying that out. And actually the state cited a case that it doesn't really apply. It was in the corporate context for attorney-client privilege, but it gives a great analysis of work product privilege. And that is Burrow versus Forjas Torres, Burrow, Forjas is Forjas, Torres, Taurus. It's a Southern District of Florida case from 2018. I have a copy for the court if you would like. And really, if you go to page 2, Judge Torres does a really great job at setting forth an analysis on work product. He talks about the difference between opinion work product and fact work product. And what he says on page 2 in the first paragraph dealing with the work product doctrine, he says, and this is on 1227 page, because the work product privilege looks to the vitality of the adversary system rather than simply seeking to preserve confidentiality, it is not automatically waived by the disclosure to a third party. It requires the party asserting protection under the work product doctrine to demonstrate that the drafting entity anticipated litigation at the time of the documents were drafted. I mean, clearly this is the roadmap, what we're going to do to prepare for trial. So I don't think there's any question it was drafted in anticipation of litigation. And because this is about what it is, the logic behind it, the rationale of work product is that your adversary doesn't see your mental impressions. And that's what opinion work product is. It's the mental impressions of the attorney. Clearly, these are the mental impressions of myself and my team. And so the question really is, was it disclosed in a way that your adversary would reasonably get access, that I would reasonably know my adversary is going to get access to the document? And the question then would become is, okay, I sent this email to the Clenneys. Would I have known that Mr. Quinnen or any of the prosecutors in the case would have been able to get access to the case? I would have to assume that and have knowledge or evidence that they got an iCloud warrant for them. I couldn't know that in the case. The parents are not part of the facts in this charge, and there would be no reason for me to know that. And let's assume that even I was afraid that somebody could look at it. This is why I titled it privileged. I titled the document checklist of things to do - privileged. And I agree with Mr. Quinn, just calling something privileged does not necessarily make it so. But this clearly is a privileged document when it's my mental impressions. It's work product. I claim it as work product, and I wrote that it was privileged. So the question becomes then about waiver. And just to go back in that case, on page 4, it says opinion work product enjoys a nearly absolute immunity. It is much more stringent than attorney-client privilege, which I still believe belongs here, but it is very hard to waive opinion work product privilege. And so then we have to ask ourselves, did that happen in this case? And in the work product aspect of it, Judge, no, I couldn't have known. I did everything to protect that document from being disclosed to people other than who was on that email. And the prosecutor stating that we have disclosed some of what's on it or will inevitably be disclosed, it doesn't matter. If a document is privileged, it's privileged from when it was and forever privileged. And so whether it's a roadmap of my case, whether I've already filed a defense witness list with some of the witnesses, whether I filed some motions, I can tell you that at least 9 points in there have not been disclosed to this court, to the media, to the prosecution, to the public. And whether the defense inevitably decides to put that out for trial, I don't even know yet because we haven't even set a trial date. We're still preparing. We're still investigating. There's a lot that goes into it. So I don't even know at this point, but there clearly could not have been any kind of waiver. Let me just see if there's anything else with respect to the waiver, Judge. And I don't know if you have any specific questions about what I've said so far.
I don't.
And I would probably wait to go into the third point, which is even absent those things, unless you want me to, but
we can wait and see whether or not I agree with the Herald that it's
because I don't think we get
decide one or decide the other.
I don't think we get to 3. Okay. So okay.
All right. So let me hear from you, Mr. Quinnen, about those points about the privilege first, and then we'll get to the sealing and the confidentiality.
Yes, Judge. I think I would like to begin with Ms. Puglisi's argument that even if it might have been waived in some respect, the document, because it's quote opinion work product, maintains its privileged nature, even if she went on TV and literally said the 20 items on that. And I think that's incorrect. Just as a premise, if we proceed to trial, Ms. Clenney's convicted and she attacks her representation as ineffective, that privilege is waived. We get a copy of the file, we review a copy of the file. As common within a Rule 3 litigation, I think it's actually explicit in the rule and the doctrine about the waivers of privilege that come with that. So that's not correct. We have to read all of these rules together with one another. And so as Ms. Puglisi correctly cited into 9502, it has to be in furtherance of the representation. So was this email communicated to the parents first as their other clients as witnesses? Yes or no? I think it's unequivocal no. That wasn't, this is what we're doing to prepare you as witnesses. It's, this is what we're doing on Courtney's case. So it was unequivocally uninvolved to Kim and Deborah Clenney's representation by Frank and Sabrina, or excuse me, Ms. Puglisi and Mr. Prieto. My brain just went to your first name. So it's unequivocally uninvolved with that representation. So it's regarding Ms. Clenney's representation. What within that email really discussed, so for example, I'm going to use Ms. Puglisi's example of money. We need $50,000 to do X. Okay, was that in that email? It was not. Was it, we need you to sign an authorization of, school records from Ms. Clenney so that we can build mitigation? Again, hypothetical situation. That's not what was there. That was, we want you to know what we are doing. Email. And that is a textbook voluntary disclosure to a third party, period, bar none. There was no request for work. There was no request for assistance. And the Gerheiser case that we cited to, that I appreciate Ms. Puglisi mentioning, and in the original privilege litigation, we also cited to a case called Witt versus Witt, and I can get that cite for the court, where there are circumstances where family members can be agents. So in Gerheiser, that was a juvenile who was in custody and could not retain his own counsel. So his mother went to retain counsel. And what was privileged in that discussion was the discussions with the lawyer about the son's case, period, in terms of retaining that lawyer. That's not what we have here. Again, Mr. Prieto and Ms. Puglisi, as we argued in that proceeding, were already retained by Ms. Clenney. They had every means of going to go see her at the jail and talk to her at the jail and explain what they need and why they need it. And as it pertains to her parents, if there's any kind of bill, for example, Ms. Clenney has frequent calls with her parents. She could say, Dad, I spoke with my lawyers and they need the $50,000 for the thing that they're doing. That's perfectly fine. That's perfectly protected. But the problem here is that that's not what existed in this email. That's not what occurred. Besides that, I don't entirely agree that it's opinion work product. At the end of the day, it's just a fact work product of, we have to do X, we have to do Y, we have to do Z. It's not, I think that this is going to be a problem, or I think this witness is not credible, or what would actually impart impressions there. It's essentially call the witness, schedule the witness, get this, and I'm not quoting anything there. These are all hypotheticals because I have to tiptoe around it. It's a to-do list. It's not a we think this, we think that. So respectfully disagree as to whether it's opinion work product. As it pertained to the instant motions, and again, this is a slight shift from the privilege, because again, our position on the privilege has never changed, including as it pertains to the other litigation. And of course, we respect this court's order on that case, though we disagree as we outlined in our pleadings. This is inherently different in various different respects. Again, explicitly voluntary disclosure, but beyond the voluntary disclosure is the remedy. Well, I guess I'm getting into the other argument, so let me back off of that. The state's position as it pertains to the confidentiality was that all the matters should be confidential because it would necessarily limit our ability to discuss in the response to the deposition motion the document, because that's a good chunk of their position. So all of the proceedings should be confidential. If the state is correct and the court agrees with the state and the court grants our motion or denies the defendant's motion, however that proceeds, then whatever is appropriate to be unsealed would be unsealed. The problem is that candidly, the defendant in their motion to compel and our deadlines in responding to that motion to compel required us to address at least one bullet point in that respect. So it's put us in a position now where, the cat's already out the bag, the bell has been rung. So there's that aspect. And then finally, as Ms. Puglisi mentioned, there's at least 9. I haven't really re-reviewed that document on purpose for this court's reasons and for collateral matters. But if there are 9 things, and I'm assuming it was 20 items on the list, just taking their word for it, 11 of them should not be redacted. So at the end of the day, that's the bottom line law is, as I don't care whether it is or isn't sealed, but that's just the state of the law. So,
Judge, with respect to Mr. Clenney doesn't believe that it's work product. So the rules, sorry, yes, opinion work product. The rule states the mental impressions, conclusions, opinions, or legal theories of a party's attorney or other representative concerning the litigation. That does not say and in between there. It says or. The mental impressions. Those bullet points, it does not say it has to be in a paragraph format, how it needs to be put. Those bullet points show, after evaluation and knowledge in the case, things that need to do. Those are mental impressions moving towards litigation. I mean, I don't think it could be more clear than the fact that this is opinion work product. Now, as far as the attorney-client privilege, yes, this is not a communication that involved our representation of the Clenneys as the parents. This had to do with Courtney Clenney and her representation. And it's just not practical what the state attorney is saying, and I don't think this is what the rule says, which is that, yes, we were retained, but that doesn't mean that costs don't still come up throughout the case, that you're not still discussing with the family about the case. And it says here, he says, Mr. Quinnen said, it's what you want you to know what we are doing. Yes. How is that not disclosure in furtherance of the rendition of legal services? That's exactly right. What he said, it falls exactly under that definition. And so it's just defense attorneys don't do that. They don't talk to their clients about the fees when she has no access to the money. So you're talking to the people who have access to the money and pay it, and you're talking to them about what you're doing. And this is just very common communication. And as far as even if we've disclosed some, because that's part of our case, we've done it through filing defense witness lists. That doesn't mean that, okay, you can unseal or disclose part of it. I've not read any case that says part of the document can be privileged in part. Now I have read some cases that they've talked about, okay, if you have 5 documents, maybe one document would be sealed and the others are not, but there's never been something that, okay, part of this document it's a privileged document. It doesn't matter and it should not be disclosed. And again, I won't go into the third point because I think it would matter for the court to determine whether it's privileged or not first, and then whether we waived it. But I think the strongest argument here, I believe work product has not been, or sorry, attorney-client hasn't been waived, but either way, the standard is not the same between the two. It's almost always immune in the opinion work product. So I would just make sure it's clear that the standard is different. And I don't know what Mr. Quinnen needs to say that needs to be on the record that he can't say without like us having to seal the entire proceedings. I feel like we all know the court and the attorneys here involved know what it's pertaining to.
That's what we're going to get to next.
Okay.
Okay, so this is the issue of privilege. And what I want to hear next is what it is that, given what you're arguing is privileged, what it is that you're asking, defense is asking to be sealed versus what state is asking me to be sealed. And then we'll hear from Miami Herald about their response.
So I think the rule, Judge, does, if you go through the case, Lewis versus the Miami Herald, I think it does lay it out. And I think the biggest thing at the end is it says it has to be the least restrictive. Because
so for you guys, it's just essentially the one document.
It is. I think that protects it as long as we are not discussing like the absolute details of what's included. We can talk around it in generalities, but I don't see, and I haven't heard Mr. Quinnen point to anything that makes me feel like we can't do it and just seal that one document.
Right. So Mr. Quinnen, before I get to the Miami Herald, why is it that you believe in counsel for the Herald also suggested that you discuss this with them? Why do you believe that more things need to be sealed if I decide that document needs to be sealed?
Judge, as it is, just as a premise, in our response to the motion to compel the deposition of myself, I had to note at least a single quotation about paragraph 19. Our response, we had to, for lack of a better term, neuter it. So we couldn't go in through the dynamics and the aspects. We can only touch about the topics broadly as to privilege, waiver of privilege, why the waiver of privilege was perceived and assumed under those circumstances, and so on and so forth, just kind of broadly. As the court recalls in the litigation on the computer case, the pleadings on these topics were north of 20 pages. And this one obviously was 10 for several reasons, but we could not go into meat and potato issues. Again, as we've been tiptoeing around here and as admitted by Ms. Puglisi, at least 11 of the 20 items have been disclosed already publicly. And again, that buoys the point that voluntary disclosure is waiver, period. So, which by the way, it's their burden to show through evidence, which they also have not done. Counsel's assertion is not enough. And admission that that this was disclosed to a third party with consent, as we noted in our arguments, that's essentially it, is there was consent to tell the parents the status of the case. Because at the end of the day, as the court noted and the state relied on both internally and externally through advice and research, the parents' representation by Mr. Prieto and Ms. Puglisi was problematic to begin with. That doesn't preclude it. We've gone down the rabbit hole. That's a dead horse that I don't want to beat any further. But the point is that this has nothing to do with the parents' representation, and it only exclusively has to do with Ms. Clenney's representation, and it's completely unnecessary to have been disclosed in those circumstances. Again, the proffered excuse was that, it's to let them know that we need money or we need this. That's not what that communication says. That's just telling them, hey, this is a status.
That again goes to my determination of whether it's privileged. So I'm asking you why it is that you believe that you can't just reference the document in your pleadings or reference the bullet points in your pleadings without having to seal everything else.
I mean, a standard legal analysis is like in this case where X, Y happened. I cannot do that. That's just a practical aspect. So I have to make these arguments broadly about there wasn't privilege and privilege was waived, and I can't address why or how. I can only really say, et cetera. And as it is, again, referencing the court to page 7 of our response on the motion to depose, we narrowed it as explicitly as possible to the pertinent bullet point as to how the document even came up in our search. So, that's just the practical reality of being able to respond really neuters our ability to address it. Even if we just go ahead and say, the court relies on that and on what we've already put and is understanding our arguments around the parameters of that. Again, the first bullet point had to be disclosed. That was part of the problem with this timeline of the briefing, because the bullet point had to be referenced, absolutely could not go without being referenced on paragraph 19 of page 7 of our response. So we were okay with the records being sealed, hence why it was called an oppose, for the purposes of just getting this over with. And then however the court rules is however the court rules, and whatever's appropriate to be protected is protected, and whatever's not, that's perfectly fine. And the pleadings could be redacted and so on. But that I had to file a pleading by last week, Friday, in response, necessarily undercut the defendant's premise of their motion. So they did not have to file their motion to compel the day after they filed the motion to determine the confidentiality, is what I'm getting at. And by forcing that issue and forcing us to respond within the parameters, it necessarily undercut the premise of their sealing.
Any response?
I don't know what Mr. Quinnen wants to say, so it's hard for me to say that. I didn't think it was the least restrictive means. I really don't care so much whether it's sealed. I think the Miami Herald has something more to say about that, so I would leave it up to the court. I just felt it needs to be the least restrictive, and if you ask me, that's what it was.
Okay. All right, let me hear from, remind me again your name. I have it here.
Scott Ponce on behalf of Miami Herald.
All right, Mr. Ponce, if you'll come forward to the microphone, please.
Yeah.
Thank you.
Good afternoon, Your Honor. Scott Ponce from Holland and Knight on behalf of the Miami Herald. I think maybe the best place for me to start is to explain why I'm here. Obviously, anytime a motion comes across saying sealing criminal proceedings, my client's antenna goes up. But this one in particular, when we got the motion and read the motion, it seemed to me that there were discrete issues that were kind of being conflated and bouncing off each other. And when I emailed counsel for the parties, from vacation no less, but when I emailed counsel for the parties to try to get an understanding, I got maybe even a little bit more confused. Although the judge I clerked for out of law school said, never say you're confused. But as I read it, what seemed to be my understanding of it was that there's a document, the defense contends it's privileged. The defense would like to make that an exhibit to an amended motion to disqualify. And it seemed like the issue of whether the document is privileged was going to be briefed in the disqualification papers also. And that seemed to not be the least restrictive means. And that was our concern, was that a motion to disqualify the state attorney's office needs to be done in public. This is a public institution, and the notion that that briefing might be sealed was problematic, especially problematic because it seemed like it didn't need to be. So our thought was, and I apologize if the papers were presumptuous, I don't think that they were, was that it made sense to determine in the first instance whether the document's privileged. Because if it's not, huh?
I'm fine with the way that you outlined it.
All right. Well, thank you. Makes me feel better then. So the thought being that if the document is not privileged, then I don't know that there's any basis to seal any document to which it's attached. If you find the document is privileged, and again, I'm not attorney for the parties and I'm the stranger here and I know least about this than everyone in this room, but it's not clear to me why the document would need to be attached to anything. I mean, your honors reviewed it, your honor will determine it's privileged. Okay, the state saw it. Is there a basis to disqualify him on that basis? I don't. When we talk about least restrictive, I'm not sure why the document would have to be attached to something. But again, I think in the first instance, our concern was that there was suggestion in the papers, at least as I understood it, that the issue of whether the document was privileged was going to be briefed as part of the disqualification issue. And that the state's position was that if that were the case, then everything in the disqualification papers had to be sealed. And that felt like too much. So I'm happy to answer questions if you have any. I obviously can't speak to the privilege issues, nor do I want to. But that's kind of why I'm here and why this came up on our radar.
I tend to agree with you as to the way that you've outlined it, which is again why I've asked the state to explain to me why it is that I can't simply rule on this being privileged or unprivileged. And if I do rule that it's privileged, why it means that everything attached to it must also be sealed. And I kind of understand your argument that in order for you to make a full analysis, you believe that you have to reference the exact portions of all the bullet points in the email that was sent. But I'll let you address what it is.
Well, Judge, I mean, again, if the topic has been voluntarily disclosed and it's been voluntarily disclosed, whether it's
aside from whether or not I say that I do rule that it's privileged.
Sure.
Why again?
Okay, so then.
Yeah, but say that I do.
Okay, so then part of the analysis as it pertains to both the deposition and disqualification is what prejudice, if any, right? What prejudice, if any, exists from the inadvertent disclosure of this document, right? And the items contained within that document. Well, what prejudice, if any, exists to the defendant if her lawyer went on TV on July 8th of 2023 and said, we are doing that checklist?
Well, I don't think that that's the analysis that we're talking about for sealing.
No, I'm sorry, I misunderstood.
We're talking about sealing right now.
Oh, Judge, again, the parameters is if the court assumes that it's privileged, then I can't discuss those materials openly, right? So if I can't say, they said they were going to hire blank, and they also said that on TV. You see what I'm saying? If the matter is sealed, I can't say they said this on TV. There is no prejudice.
Yes.
So here's where sorry to raise my hand, I was in third grade. Where I get confused a little bit here. Why would that be a discussion in the disqualification context?
Because if there's no prejudice, then there's no basis to disqualify.
Okay, I mean, it's just something I'm trying to understand, trying to be a partner here and work through this, trying to understand why, if there's a determination made that the document's privileged and there's a determination made that the state saw it, I'm trying to understand why are we still talking about what's in the document or not and a disqualification issue, if that matters.
Because again, if it's in a privileged document that was, assuming it's privileged because we don't take that position, and the basis of disqualification is they saw our strategy. It's like, but you also told everybody your strategy.
Why
Then-
should you be disqualified?
Yes.
Okay,
And
that's helpful. I'm just trying to understand.
And that's the problem is I cannot, I mean, again, if the court, listen, Google alerts are a beautiful thing. And so everything on this case that has come up from the defense telegraphing their case ad nauseum, it has come up. So again, half of that, from my original viewing of that, and again, I haven't parsed it recently, quite literally everything on there has been discussed in one respect or the other.
Like you could
So
reference the bullet points without going into exactly what was in that document if I did rule that it was privileged, because obviously the balancing test here is issues that you guys are talking about regarding the public interest, and there is a right for the public to, view pretty much everything in this criminal case minus what might be privileged. So do you not think that there would be a way to craft your response if I did rule that it was privileged in a way that didn't actually quote anything in that? Because I feel like you could.
yeah, Judge, I could theoretically say bullet point number 1 and then X, and bullet point number 2, then X. But then X was already disclosed, outlines what bullet point number 2 is. So for example, I'm just going to use something that is in the public domain. Find Arthur Cupp, right, as the witness that is alleged to have seen everything else, right? Off the top of my head, I don't know if that's there, but you guys check on me. So let's say that's item number 2, find Arthur Cupp. So instead of saying, for example, item number 2 was disclosed to the media on this date at this time by Mr. Prieto when he said, we've located Arthur Cupp. How am I not disclosing item number 2 in making that argument?
Isn't it just you're not using his name?
I mean, I think that you could just say the witness was.
I mean, that's the point is how is it that I don't, in saying.
Well, listen, I don't think that I don't think that you need to worry about that. I think that you can make the argument if they've already disclosed it and if it's in the public domain already, you can reference whatever's in the public domain. And that issue is a defense issue.
Yes, and that's we've already articulated that as much. So, but that's what I'm saying is at this juncture, we've already gone as close as we can without going and making a deeper analysis on our motion to strike. So at this point, that's why I'm saying is it the defendant's attempt to maintain the records confidential
That's their issue as to whether or not they have already gone public with this information. But I do think that I could give you the parameters and you could easily, I think, draft a response knowing that I am able to see the document that wouldn't necessarily quote the document. Your reference of any public disclosures by the defense, I mean, feel free to reference that in whatever way you want to. It doesn't mean that you're the one putting that, quoting the document. That's on them.
I also think that if that becomes an issue, we can always go sidebar. Mr. Quinnen can lay forward, to the court, off the record. This is what I'd like to say, and I can't say it because of this. And then we can decide that, yes, okay, now there's a basis. We should seal it because you can't make that argument unless it's out.
And to agree with you, and I understand what you're saying now. I understand what you're saying about needing to show prejudice for all the elements that are in there, but I think that could be done without referencing the document. Okay. All right, now I lost my place. All right, Mr. Ponce, was there anything else that you wanted to say about that?
Unless you have questions.
All right, do you have anything that you want to say about your response to what Mr. Ponce had said? Because it seemed like you were essentially in agreement with the idea of going with the privilege first and then deciding what needed to be, whether anything needed to be sealed. But you said that there was one thing that you disagreed with, I feel like. No?
No, I don't think so. I
Okay.
think, it was only that if the court doesn't find it's privileged or finds that the defense waived it, I think that Mr. Ponce's argument is then, okay, then it should be disclosed. And our argument would be no, because it still is our mental impressions of the trial, and there's no reason for the public to see it. And unlike what Mr. Quinnen is saying, that yes, the timing now is such that it's been disclosed. Some of these things have been disclosed. They're part of the public record, as you said. And we have discussed it in the media, but not all those things have. And that entire document is a privileged document. Whether we have disclosed some of it or all, doesn't mean the whole thing should be disclosed. It's privileged. And so, and I can matter-of-factly say that not all of those items have been discussed in the media at all. So,
And I don't think that he's disagreeing with that, Mr. Quinnen.
I'm neither agreeing nor disagreeing, Judge. I can't. Again, I've on purpose recently avoided.
Okay, so yes, you've got your bullet points. All right. Did you want to address anything else that Mr. Ponce had said or that the Miami Herald's concern is, other than what you've already said about why you believe that there needs to be a broader?
No, Judge, we were generally in agreement to maintaining that prophylactically. Our position was just that let's get this over with, and then after the fact, let's just get everything over with, and then after the fact.
Yeah, the idea was to get it over with before the new year. That's not going to happen, but we're at least at this point. Okay, so I agree with the idea of ruling on the privilege first, and then deciding what needs to be. Actually, I mean, I can make the ruling, I can make both at the same time, based on what you guys have said, unless you have any other arguments that need to be made.
Judge, as it pertains to the waiver issue, I mean, I didn't go down the dynamics of that. Again, we have separate parties. And by separate parties, I mean, there's the state of Florida versus Courtney Clenney. There are witnesses within that case. Those witnesses can have representation at the time.
Sorry, and by both, I'm sorry, I didn't mean to cut you off. By both, I mean, I'm perfectly fine with ruling on the issue of privilege and what should be sealed, not that we're arguing the motion for.
No, it's on the privilege aspect, because again, there were certain aspects of it that go more towards that dynamic. But the essentially the broad stroke rule that the defense is trying to propose, where the parents are always agents of the defendant or have been always agents, is not one that's actually premised within the doctrines of attorney-client privilege or within the jurisprudence or within that rule. And specifically what I'd refer to is several different dynamics. First is the defendant has several jail calls with her parent. Does that mean that because her father ministers her money, that I can't review the jail calls that she has with her parents? Logically, no, that doesn't follow. Notwithstanding that they're being told it's recorded or not. That's completely immaterial. Whether it's privileged or not, we should not be. Even if it is recorded, I believe all jail calls are recorded, even with counsel, but we don't get the ones with counsel. We explicitly are excised. They have to fill out paperwork and so on and so forth. So whether it's recorded or not is completely immaterial. And what's happening here is, for lack of a better term, because they keep using this term Team Courtney in this group chat, that was not evident in the group chat, first of all. But notwithstanding that, is just because you have a support group and everybody wants to know about what's going on and what's being done, it's incumbent on the counsels and their client to keep those lines of demarcation. For example, if Ms. Puglisi met with Ms. Clenney at the jail and said, we're going to do X, and then she picks up the phone and calls her mom and says, my lawyers are doing X, that privilege is waived. Ms. Hogan, I actually prosecuted another case where there was a similar circumstance where a person their representation was paid by a third party. I'm not going to go into the details because it's a little bit sensitive, but that third party had a complete barriers to the representation. Certainly, if you got a call and say, look, we need X more money because we have to hire an expert, I got to talk to my client about this, we should excise from there. And I explicitly use the example of when parents go in with a client to an interview and how the parents are supposed to be excluded from that interview with the client if they are to maintain any privilege, because if it gets discovered, we can't compel that testimony, which again, to the further privilege aspect, is the defense in December of 2022, when this email is being sent, knew A, The defendant was in communication with her mom, both written and oral, that they provided us photographs that Deborah Clenney took from her device on April 6th, 3 days after the homicide, purportedly showing bruising that was, again, purportedly caused by the victim. And so they knew that we had a basis to want Miss Deborah Clenney's phone and the contents of that. And we could have subpoenaed that, assuming she was within the jurisdiction for me to subpoena it. So what is on her phone? That is a textbook voluntary disclosure to third parties. That's what this document is. And again, calling it privilege, naming it privilege does not make it so. That document could have been called privilege and it could have the scores for the Heat game and the stats. That doesn't make it so. And in this context, even if it was, which we don't necessarily disagree that it was when it was created. We disagree that it was opinion because it's just facts of what we're doing. But once it was put into an email and sent to the third parties, that was waived. And just as a perspective, the two exceptions there are for the purposes of the representation, and I forget the second one, you had it. It's for the purpose of the communication functioning, I believe. It's the second one that you mentioned.
Reasonably necessary for the transmission of the communication.
Correct. So it's reasonably necessary. So that would be Outlook or Google or whoever the servicer of that email is. We didn't intrude on Google, et cetera, or any of that stuff. We got it from Miss Deborah Clenney's iCloud. A, not knowing that there was a representation there. And then B, under the circumstances where that email was even open, it said update, not update privilege or privileged communication or any of that aspect. And B, the document did not reference Kim and Deborah Clenney's representation in any way. It was explicitly about Courtney and what they were doing about Courtney's case, which again is textbook, top to bottom, within four corners, voluntary disclosure under 90.507.
Okay. Judge, I'm just going to say that I think the state tends to join the two privileges together, and we have to make sure we keep them separate. Attorney-client and opinion work product. Opinion, it doesn't have to be your opinions. It says mental impressions. Mental impressions are your thoughts. There's no question. These were my thoughts. And yes, it could have been the scores to the Heat game, but it was not. And it said privileged on it. And the prosecutor should have stopped when he saw a communication from attorneys to anybody and should have said, oh, I see an attachment that says privileged. He didn't stop at that point. He actually forwarded it to law enforcement, thereby making it a public record. So we have to, all his descriptions about it's not a jail call, which of course is recorded, and it doesn't have to be about finances. It doesn't have to say the magic words. This is, we need money from you. It says disclosures and furtherance of the rendition of legal services. These are points that help to justify what is being done in the case to represent their child. So I think it's very clear this is both attorney-client and work product, and that there was no waiver at any time, especially in the work product. It was meant to be kept from the eyes of our adversary.
And you don't believe that that was waived when you disclosed it to the parents?
In opinion, no, because opinion, especially opinion work product, it talks about you can disclose to third parties. The test, the question is whether you reasonably could have known that it would get to the eyes of your adversary. So by giving, they're two totally different standards. So by us giving this information to the parents of what our opinion is in the case, the question is, could we have known that the prosecutors would have seen this email? And in order to prevent that, that's why you write privilege, so that you know that only the family, the people you're sending it to, are going to see it.
I have a slight disagreement because Ms. Puglisi keeps referencing adversary. So first, again, as witnesses, whether by us or by the defense, they would be subject to subpoena. And we could have taken sworn statements of them and possibly had discussed that, where we asked the question, have you discussed your daughter's case with the lawyers? So it wouldn't be a question about, did you discuss it as a witness and client of theirs? It would be, did you discuss it regarding her representation? And they might have been compelled to answer that. The second part is that the standard is not adversary. It's that the communication was made with the intent to keep it secret. Now, certainly it was meant to keep secret with Kim and Deborah Clenney. The problem is that as third parties to state of Florida versus Courtney Clenney, it's a voluntary disclosure. The very act of attaching it to the email and sending it to them constituted the waiver.
Judge, and I don't totally understand what he's saying with respect to, there's no way they could have been compelled to answer that, but adversary is the state attorney's office in this case. That's who the adversary is to Courtney Clenney. And so clearly it was not meant to do that. And I can find the case, but it does talk about that.
I'll look at it.
Okay.
My understanding is adversarial party.
Okay.
Okay. All right. Anything further before we stop for the day and I give me time to read through everything and issue another written order?
No, Your Honor.
All right. So my order will be number 1 on the nature of privilege, whether I believe that it is privileged or not privileged, and 2, if I believe that either it's privileged or not privileged, whether I believe that anything should be kept confidential, and if I do believe that it's confidential, what should be kept confidential. Okay, so it's going to be 3 parts. Everybody follow that?
Yes.
Okay. All right, and you're not Marvin, so I don't know how long to ask you for the transcript. What is your name? Alex. Okay. Alex, if I want a transcript, will I be able to get it in 10 days, given the holidays, 10?
Yeah.
They should be there. I have copies. No, I have copies for orders there. If you look, there should, you guys, Ollie. No. All right, so let me reset it for 10 days for transcript, and then hopefully we'll get the transcript then, and then I'll give it a reset date with you. And if I get the current transcript, I'll give you all a copy of the transcript. Okay.
Thank you.
Judge, are we not then going to the motion to depose today? You're going to wait until that? Okay.
Because I agree, they should be separated.
Okay.
1-3 is 10 days from now.
30, 12:30?
That makes me feel bad, but we'll do 1-3 and yes. We're just gonna keep moving. Okay. All right, thank you. And then what was your name again, Alex? What was your last name? What is it?
Alejandro.
But what's your last name?
So, S-I? Oh.
Did you want to set a date for?
Right now, I'm just gonna give the transcript and then, I mean, you can try to set a date, but let's just, everything takes longer than I think it's gonna take, so.
So once we get the ruling, we should call your JA and ask
I
for.
think once we get the date for the ruling, you can probably come up with the date for the deposition.
Okay.
Or the motion for deposition. Alejandro Silva, and are you also with laws? Okay. All right, thank you. All right, happy holidays, everybody.
Thank you. You as well, Judge.
Yes. So we're all going to take a brief break and then we're going to go on to white. I'm sorry, but I am giving you guys lots of days off. So. What's today, the 19th? 18th. Today, the 18th. That's today.
Yeah, Sherry, that wasn't as exciting as I thought. I don't know why we had heated hearing in there. All right, so that's all about the iCloud, the computer. So there's those 2 separate things. So she has to determine what's confidential. I'm sorry, what's privileged, and if it's privileged, is it confidential? And ultimately, she decided that they had been, the charges were not dropped because she said the prosecution had improperly obtained and reviewed attorney-client privilege communications from the Clenney's iCloud accounts. So the state dismissed the charges against Courtney and her parents. So eventually this hearing led to judge saying the state did improperly access them, obtained and reviewed them. So then, and because of that, the state dropped it. Now the next thing is they asked for the state's attorney to be disqualified. So that's what's coming up now. So that was in May. I'm sorry, that was December. Okay, so this is going to be May of 2025. So now we're into 2025. So now, because of all of that, the defense is like, wait, we don't like all these shenanigans going on with the state. Let's get them
So
disqualified.
are we ready to?
So hold on a sec. Let me just. All right. Hold on. Let me just make sure I got the right one. Okay. Yeah. All right. So they want them disqualified now because of what happened. All right. So this now we're going to fast forward to May. Oops. I put it in here. All right, so this is a hearing from May. So this one could get a little dicey. Let's see what this one's about. Another Zoom meeting. Actually, the audio is really good on these Zoom meetings.
To go, we have defense counsel here, state here, defendant is present. You guys ready to go?
Yes, Judge. Sean Abuhoff on behalf of the state, along with Kathleen Hogue.
And Frank Briet on behalf of Ms. Clenney. She's
So Sean, that's the new state attorney, Sean Abuhoff. That's the new state attorney, the guy on the right. Yeah, he's the new Sean Abuhoff. He's the new lead prosecutor after Khalil Keenan was not disqualified. He was just removed because he would have turned into a witness. He would have turned into a witness. So that's the new state attorney.
She's present before the court and also co-counsel.
So are we ready to go? We have defense counsel here, state here, defendant is present. You guys ready to go?
Yes, Judge. Sean Abuhoff on behalf of the state, along with Kathleen Hogue.
And Frank Briet on behalf of Ms. Clenney. She's present before the court and also co-counsel Ms. Puglisi.
So we are here for defendant's motion or amended motion to disqualify the state attorney's office. I was able to get through a lot of the binder. I've obviously looked through the motions, the response, and some of the case law, but we're ready to go. So defense.
Yes, Judge, you have the binder. I know you've read it.
I haven't read through all of it.
Okay.
That dropped off a day in advance, but I have read through a lot of it.
Sure. And Judge, our written pleadings say a lot. And so I don't think this oral argument has to repeat everything that's already been delineated in our amended motion and especially in the reply. So I'm just going to highlight some things for you. So the standard is...
So for the standard and why you believe you've met the standard and...
Yeah, so the standard to disqualify the state attorney's office is found in Downs versus Moore. And that is the defendant must show substantial misconduct or actual prejudice. And the case law that interprets what actual prejudice means is more than just an appearance of impropriety. But in the reply, in the state's response to our motion, they're highlighting most of their conduct that they've done after what I would refer to as the misconduct of ASA Clenney. The court is intimately familiar with those facts. You send the deposition, so I don't need to rehash the facts of that particular breach into the defense camp. What the state argues is that look at everything that we've done since. We've sealed the V case off. We've restricted access. I would just note that Mr. Quinn's still on the delivery list for pleadings, but we unclick him to kind of wall him off. But what I think is most important, Judge, is Mr. Abuhoff and Ms. Hogue. It's not what they did, Judge. It's what they didn't do. And what they didn't do, which is contained, I believe it's Exhibit A to our motion. Yes, it's Exhibit A. We have a letter. As soon as we realized upon the arrest of Courtney Clenney's parents and the allegations contained within the arrest warrant, it was clear that the state had obtained our work product or attorney-client privileged communications. As recommended by the Florida Bar, as soon as we realized that they were in possession of our confidential communications, we sent a letter addressed to Chief Assistant Kathleen Hogue, Sean Abahoff, and Mr. Quinnen. That first letter was February 15th of 2023. The response to it was sent via email. The response we received from the state was complete silence. They didn't even acknowledge receiving this. Exhibit B, another letter shortly thereafter, February 28th, 2024, same letter, second request. That was received, sent out via email, and the response to that request for having our confidential privileged documents back or communications was silence. Exhibit C, third request. This one came February 10 of 2025. That was after the Chapter 119 revealed the email, the confidential privileged email. We sent the third request again. Ms. Hogue, Mr. Abahoff, Mr. Quinnen. This third request for our work product and confidential communications again met with silence. So why is that important? The case law that we've talked about in the written submissions talks about substantial misconduct. And what does that mean? The case law doesn't say exactly what that means, but what the case law does say, every case needs to be looked at on a case-by-case basis. So we have to look at the facts of what has occurred in this litigation, and the appellate courts, again, would review that on a case-by-case basis, because every misconduct it would, I think, be different. So what we have here is, again, the court's very aware of Mr. Quinnen's misconduct, but Mr. Abahoff and Ms. Hogue, they had a responsibility. When they received these letters, they should have said, you know what, Frank, Sabrina, let's look into this. What exactly is it that you think that we have? They didn't do anything. So I believe their misconduct is by omission, which I think the court should consider in combination with the misconduct of ASA Quinnen in reviewing those materials, not disclosing that to the court, which is it's not a two-prong analysis. It's substantial misconduct or it's not and. And what the state relies on is the actual prejudice. They're saying, hey, she hasn't been prejudiced. Nobody else has seen this stuff. But I think the analysis that we think is important for the court to consider is, does the conduct of the state by acts or omissions rise to the level of substantial misconduct? And I think it has. They had an opportunity to do the right thing when they received our correspondence. Hey, let me investigate this. What are they talking about? Let's talk to Quinnen and figure this out. Because if there was something done that was improper, they could have nipped it in the bud right there. And they didn't. So I think it's the combination again, the acts and then the omissions on the part of the state. And I think it rises to the level of substantial misconduct. The appellate court decisions, one that the state talks about is Nunez. We think this case is more similar to that of Martinez versus state, where ASAs heard jail calls between the attorney and the client. And in that case, in the Martinez case, the third district, I think it was the third district case. Fourth. In that particular case, that was affirmed on appeal. So it really is very unique circumstances that we're in. I haven't litigated a case of motion either on the side of the state or defense now 25 years. So it's an interesting topic. But I think that what occurred here, Judge, it's an abuse of discretion standard. I think there's substantial record evidence of what occurred and what should have occurred or didn't occur that would support, Your Honor, disqualifying the entire office. And that's what the defense is asking. The entire Miami-Dade State Attorney's Office should be disqualified.
Right, state.
Yes, Judge. So it's the state's position that the defense is misinterpreting the law on this issue. The defense wants to separate substantial misconduct or actual prejudice. But I think the case law is very clear, and there's a reason why quotations only appear around actual prejudice after the term substantial misconduct. And I think that's meant to define. There's a reason why in all of this, the case law on this issue, it only goes on to elaborate on this actual prejudice and what it is, and not just the mere appearance of impropriety. So that's the major part here. And if you look at all the cases that even the defense cites to, they all come about by some form of misconduct by the state. And the question just comes, does it rise to the level of substantial misconduct? And the analysis all comes down to, is there actual prejudice by the defendant at the time? And is there a fear of potential future risk of prejudice? So I think that's the analysis. And I think the defense, certainly wants to look at this individually and point to just substantial misconduct without a definition, whereas all the case law gives it to us. And when you look at those cases, there are plenty of them that are similar to this. You look at McWaters v. State, that the defense side of the Florida Supreme Court 2010, that's where the state actually even listened to jail calls between the attorneys and their client. So there's some form of misconduct that far exceeds what this can even be, but that's part of this analysis. And we have to look to and break down both who are the actors, and what is the prejudice that the defendant faces. And the question here is, does the defendant face prejudice right now in the position that she's in, with Ms. Hogue and myself remaining on the case? And then if that is actually true, then the question would then move to the office as a whole. So I would argue, Your Honor, that she does not face any prejudice, and we can break down the two breaches that Your Honor has found to be breaches. The first being the text communications. The defense points to these letters that they've sent to us, the February 15th and February 28th, 2023 letters that were received with silence. That's because after this all came about, we had all of this litigation on the issues of whether or not it was protected material on that computer case, that access case. Your Honor took control of those drives, and it's been in your possession ever since. So the idea of being able to turn back over these items, they were not in our possession. So I don't think we can be faulted for not responding to their letters. The content of those letters are important, though. And that's why McWaters becomes an important case, because in that case, in denying the motion for sanctions or disqualification, the court found that there's no evidence that the substance of these calls provided any benefit to the prosecution or were used in a way that detrimented the defendant. So McWaters goes on to explain that when you look at the context of those communications, there was no detriment to the defendant at that time or any future risk, because the calls were what they were. These communications, the only person who reviewed them was Mr. Quinn in their original format. The world has had an opportunity to review them in the arrest warrant and in the search warrants. And what is clear is that those are just discussing the access of the computers. So there's no prejudicial information within those text messages that either myself or Ms. Hogue have seen, or really anybody in the world has seen. And through Mr. Quinn's deposition, he did not even see. It was limited to just that. So from the context of just the communications of those text messages, there's no work product, or I should say no defense theory of the case. There's no strategy concerning the homicide prosecution itself. It merely is the access of this computer. That being said, again, myself and Ms. Hogue did not access this. So as we sit here today, there is no actual prejudice that the defendant faces. It cannot, I don't even believe it rises to the level of an appearance of impropriety, but that, even if it did, that is not enough. But I think the analysis really, and the harder question here is now moving to that, and I termed it in my motion, the Puglisi email. What's clear is that no one that is currently on the state's prosecution team had an opportunity to review this. Mr. Quinn himself did not remember this item, because when Your Honor ordered every part of the communications turned over to you, this would have been included. This is part of that. This doesn't come about until there is a public record request. And that is when the defense sends us, once they're made aware of it, they send us a letter to have us turn it over. Again, it's met with silence because we don't need to respond to it, but we do take action in it. And that's the importance. Myself, Ms. Hogue, has come before this court and stated that we have not viewed it, And we don't plan to view it. And I don't believe anybody in our office could ever view it because I've been able to verify it has been deleted from our servers. So the only person who accessed this is Mr. Quinnen. And in his deposition, what was clear from that was the only thing that he remembered from it was the name Mr. Haas, which was their computer expert. And again, going towards that investigation, that separate matter. So when you look at that, that is the Nunez case very specifically. It is a person who accessed, an individual who accessed attorney-client information and the contents, and we have no problem with stipulating that the contents would be prejudicial if the state reviewed it. Mr. Quinnen does not remember the contents of it. His only knowledge based on the deposition is the Mr. Haas aspect of it. And so he's also stated in that deposition, we've affirmed he has not discussed with anybody in the state attorney's office the contents of that document. So that goes to the Nunez case, which in that case they found, based on what the court deemed as misconduct, did not rise to the level of substantial misconduct for the office. It did for that prosecutor. They removed that prosecutor, but not the office. So that's why this is not State v. Martinez. In that instance, that prosecutor, not only that prosecutor, other prosecutors heard the calls and were discussing throughout the office. The state has done its proactive work to ensure that the rights of the defendant aren't violated, that the defense team's communications aren't overheard, and we have a filter protocol in place for all of this. Your Honor has been made aware that once and if Your Honor rules to not disqualify us, we have someone coming to receive these drives to ensure that that is all filtered out. We have no issue with allowing the defense to review those drives prior to any of the prosecution team or certainly the court, if Your Honor wants to review them. We have no issue with doing that, and I think that's the appropriate thing now that we're here where we are. So we can ensure that there's no more of those text communications that can be reviewed. Concerning this document itself, again, it's been wiped from our servers. No one can access it, and I've been able to verify that. So that's why this does not go to the State v. Martinez case, and this is the Nunez case. Bless you. The other part is that Mr. Quinnen has been screened off the case, and that's why I created the analogy of this is different from the Popjoy case, which is a third DCA case from 1992. That case, the office that was taken off of the case, too small to be able to handle that situation. And so the dissemination of information was inevitable. That's not what this is. The Miami-Dade State Attorney's Office is one of the largest in the country, one of the largest in the state of Florida, possibly the largest in the state of Florida. We were able to screen Mr. Quinnen to where he doesn't have access to the electronic file. He doesn't have access to the hard file. He doesn't have access to myself or Ms. Hogue. And actually his office is on the far reaches of the state attorney's office to where we don't have to interact with him. So we're able to ensure that anything that he has seen, which the deposition shows that there really isn't any prejudicial information, would not come about or would be discussed with the current prosecution team. So that screening process is an important part and why there is no risk of future prejudice that the defendant might face. So, Your Honor, based on the arguments that I'm making, as the defendant sits here now, based on what Your Honor has deemed breaches, two separate breaches, or one separate breach but two separate items, there is no actual prejudice as she sits here now with the current prosecution team, let alone the office itself. And then the risk of any future potential breaches or prejudice, we believe that we've taken proactive measures to ensure that that will not be a concern for this court or the defense team.
Yes. Your Honor, it's, how can I put this? The credibility of the testimony by Mr. Quinnen that he just forgot, right? He forgot discovering the linchpin, the evidence that he needed to find the laptop, locate our expert. That is just, that Your Honor can evaluate the credibility of those statements. What the state is trying, and just let's talk more about what occurred. Mr. Quinnen disseminated that information to law enforcement. His testimony was he didn't disseminate it to anybody else in the office. We know that the copy of that email was on the servers, but I do believe, and I do not doubt Ms. Hogue and Mr. Abhoff's representations to the court that they did not view it. But going back, the state's arguing that it's substantial misconduct has to have actual prejudice, but it's an or. And the quotes, I would say, are because the Downs versus Moore doesn't say prejudice, it says actual prejudice. That's the distinction of the quotes. It's an or situation. So for that substantial misconduct, we have to look at what the conduct was of Mr. Quinnen, and then again, the omissions, I believe, on the part of the two prosecutors. In the case of Nespler, which I think the state and the defense have argued in our written pleadings, I guess that's the beauty of the law. We're almost citing the exact same cases, but interpreting them differently. And then Your Honor has to figure out that who's wrong and who's right in a somewhat of a gray area. But Nespler, that's spelled with a K-N, E-S-P-L-E-R versus State 314 Southern 3rd, 287. That's a 3rd District case. And they cite to one of kind of the staple Supreme Court cases that addresses this issue, which is State versus Fitzpatrick, 464 SO2D 1185, Florida, 1985. So they talk about how the state is different than a law office. And they say there's a distinction between private law firms and government prosecutorial offices, and that's citing State versus Fitzpatrick. So as a result of that distinction, the Florida Supreme Court has recited that imputed disqualification of the entire attorney's office is unnecessary, meaning you can't do it or you shouldn't do it, when the record establishes that the disqualified attorney, who I would say here is Mr. Quinnen, right, has neither, one, provided prejudicial information relating to the pending criminal charge, which I think that's a tough sell, nor, meaning, and he also has not personally assisted in any capacity in the prosecution of the charge. Mr. Quinnen clearly, right, personally assisted in a whole bunch of capacities, right, in the prosecution of the charge. And again, that's, so what, why is disqualification of the entire office appropriate? Because he, Mr. Quinnen, personally assisted in any capacity in the prosecution of the charge. And that's at 1188 in the Fitzpatrick case. So, you know, we always, when I was in county court and we were all, you know, in county court, the judges, when it's DUI Mondays, there's the state, oh, judge, this isn't my case. This is, I say, so where's he? He's in the hallway, right? Well, you are fungible. That's what we used to always get. Well, you're fungible. You can go ahead and try this case, Mr. Prieto. So it's that distinction. The state is kind of considered their one fungible body. And that's what Fitzpatrick talks about, is that if, I believe it stands for the proposition that if the attorney that was disqualified participated in the case, that's it. You can do it, right? So I think if you look at you know, the totality of the circumstances of the misconduct by act or omission, I think that your Honor would be on solid ground in the third if you disqualify the entire office.
Judge, if I could just clarification, no argument. For the disseminated to law enforcement, that Mr. Quinnen, that was only specifically those law enforcement officers were on the computer case, is my understanding. And if defense knows otherwise, I believe it's just the.
I believe that's correct. Yes.
Right. So that, and that's a different department than prosecuting the homicide. So I think that is also important to note, because that's also other screening that can take place, that there has not been discussions with those officers as that case no longer exists. And the only other part would be that the Nespler case is a third DCA case that comes after the Nunez case, and Nespler does not discuss the Nunez case or call into question the Nunez ruling.
Judge, I do appreciate the state has tucked away Mr. Quinnen in the far reaches of the office. But, you know.
He's tucked there before.
Yeah, well, you know, we have to rely that he's not going to speak to anybody. And I think that that's the fear that the client has and we have as a defense team, that there's nothing to stop the state from, well, we'll end it there, Judge. I appreciate the court's time and the hearing, and appreciate the state's arguments.
Transcript, although I think I took all the notes. Let me set it for my ruling. I want to go. It's going to take me a little while to go through everything to write it all out. So let's get 30 days. Then we'll decide one or the other. Okay.
Thank you, Judge.
All right.
Thank you, Judge.
Be like a status.
It's going to do 30 days. My ruling.
Okay.
So would you like to do July 23rd? That'll be a Wednesday? No, let's do June. June. I'm sorry, Wednesday. June 20.
23rd might be on Monday too.
Yeah, it is.
June 25th is a Wednesday. Let's do it Wednesday. June 25th sounds good. All right.
They shook hands at the end of it. That was nice to see that they shook hands there at the very end. All right, so defense wants the entire department, the entire office to be removed. Who takes over then? I mean, you can't just drop it. You can't just, say, oh, I'm going to just drop the case. I mean, it has to continue going forward. So the upshot of that is, well, maybe we'll hear, let me see, hold on a sec. Yeah, the upshot of that is we're going to listen to this and let's see if this tells us anything. I'm not sure what this hearing is about. But this case has I'm telling you, it has a little bit of everything. Okay, here's where we get a new judge. Just when you thought it was going to get any. Hold on a sec, let me rewind. Oh, come on. Just when you thought it couldn't get any more weird, there's a new judge. So so from May to December, we get a new judge. So Judge Cruz is gone, and now we have Judge Wolfson. And the reasoning was that Judge Cruz was rotated out. She was rotated out. So here, this will be the presiding judge. This will be the judge that we're going to see from here on out. So Andrea Ricker Wolfson. What the hell? Exactly. What the hell? Yeah, they rotate him out, which is weird. I mean, we've seen so many trials where the judges will stay through years. Will stay for years on a case. Apparently not here in Miami. I'm not quite sure. All right, so this is from December 5th of 2025, and ultimately, Mr. Queenan, he was removed, and Mr. Abuhoff is in, and then now Judge Cruz, she wasn't removed, but she was rotated out, and then now we have Judge Wolfson in. So here we go. Let's check this one out. What more can this trial bring, or this case bring?
No, Ms. Gloss is not officially on this case. She was on the computer case. There's no problem.
All right, we're here now to address the state of Florida versus Courtney Clenney. The President Assistant State Abuhoff and Attorney Creator, as well as Clenney, who is present in court. And I'll turn it over to the defense.
Sure, Judge. Just to kind of update the court, we have pending a motion to dismiss. We have pending a motion for reconsideration of bond, which we filed a second amended motion recently. We have a motion for bill of particulars as to count 2 of the information. We have a motion to suppress surreptitious recordings. We have a motion to compel 404 evidence, and we have a motion to eliminate concerning the CGI that we've been working on. As of No, you're good. As of this morning, the only one that has been responded to in writing, which was last night at, I think, roughly 7 p.m., was a response by the state, which I have not reviewed, the motion to dismiss. All other motions have not been responded to in writing at all, and my communication attempts with the state have fell on deaf ears until yesterday. I had not heard from them in probably about 30 days, despite repeated emails. I know Mr. Abahoff was in that Clemens case and then out. I do understand that, and out for the holidays. But we need some hard dates for them to respond. Again, I know it appears Mr. Abahoff may be in trial on Monday, depending on what the defendant ultimately decides, but you know, as we used to be called fungible to a certain extent, you know, there's multiple state attorneys that are on this case, and we need to get it moving. And again, you know, we've been asking for over 60 days. This is not subject to a motion, but we've been asking for over 60 days, and it's gone unresponded to. If they can just please have their VICWIT update the addresses of all the civilian witnesses to make sure that, you know, in moving forward and serving them for depositions, that we're not chasing, you know, squirrels running around the country. So, again, Mr. Abahoff, last night, in his very professional response, indicated that he's aware that these things need to get responded to, and he's doing, I guess, his best efforts to make that happen. But at this point, we're asking for some hard dates for the state to reply, and especially hearing date. I think the most paramount one in the defense's mind is the motion for reconsideration of bond. So I would ask, I'm asking for dates, response dates for all of these, but I would put that one in the forefront for him to have a sufficient amount of time to respond in writing and to set a hearing on that.
Okay. Is that it before I turn it over to the state? I mean, I can't read my own handwriting,
but let me get these out. Yeah, but, I mean, that's where we're at.
Okay, so one thing I want to ask for, I will just respond in whatever way you wish, is I would like to take the easier things first. To me, one of the easiest things Mr. Craig mentioned was the addresses of the witnesses.
Yes, Judge.
What's the status of that?
So, Judge, I can tell you that the most that they've done is to try and make telephonic contact with them.
They being the victim witness?
My victim witness counselors. So, and I apologize because we need to do more than just that, obviously. So I made a note for myself. As soon as I go back today, that's the first thing I'm going to tell them to do, is confirm everybody's address one way or the other. Just so that I can get that to them hopefully by Monday.
Well, and I'm going to put a deadline on that for the next Friday. So by next Friday the 12th, all listed witnesses, now certainly I know that discovery tends to be an evolving process, but if something new arises, then this wouldn't be applicable. But any witnesses who are already on the witness list, you must provide updated addresses to the defense by Friday the 12th of December.
Yes, Judge.
At 5 p.m. Now, do you intend to file responses in writing to the other defense motions other than the motions to dismiss that you already filed?
Yes, Judge. So and not in any particular order, but I have a request or a question for the defense. One of their motions is to admit a CGI video. I have not seen this video. I'm not sure if it's been created yet. It's hard for me to object to it or even have an opinion on it if I don't know what it is.
Okay, that's fair, Mr. Creator.
Sure, Judge, it's a kind of a preliminary motion, limine addressed more so to the court as to the admissive. Ms. Puglisi was working on this, but we worked together. But it was more of a preliminary before we finalize anything with the CGI people. It's more of a base request with regard to the admissibility as a demonstrative aid versus evidence. It's not, obviously it's evidence-based, but it's
Your
really...
intention would be for it to be a demonstrative.
Correct.
Yeah, okay.
Right. There's changes in how the law applies. I don't think it's admissible,
Yeah.
but it's definitely demonstrative. So it's kind of a pretrial. That's why we named it motion limiting. We don't have a video. It's not complete. They've been working on it, but we just, before we go ahead and finalize the video, and obviously that's the court's ruling on this pending motion limiting could change depending on, obviously, the expert witness testimony that would be presented. But we want to have kind of a direction before we go through the expenses of finalizing the actual video itself.
So I guess what I would want to have happen is if you have a general idea or an example of something that has been created in some other similar litigation.
Yeah, no, absolutely, Judge. The company, I'm sorry to cut you.
Yeah, no, that's what I would need to say, okay, what do we even...
Sure.
In front of
The company is 3D Forensics. They have a 100% admissibility rate as far as being able to show they've never been denied. And we have samples of what they've done and the resume of the engineers that developed this technology and whatnot. So yes, we have all of that we can provide.
I think that would be something.
Certainly helpful, Judge, but the hard part about it is this comes down, especially for demonstrative purposes, a decision by the court. And it'll come down to the prejudicial effect of what this video actually shows. So,
So in general terms, if you provided an example of something that had been used in a similar litigation, which I'm sure, you didn't just come up with this out of thin air. Obviously, this exists, right? So I would need to see that type of an example. Then I think you would have to explain to both Mr. Aguilar and the court how you see and envision that playing out in reference to Ms. Clenney's case.
Sure.
That way then I could rule on a legal matter to say, okay, so yes, no, or a different route, and then create the actual video for a final ruling at some point.
Right, absolutely. I think it's going to be subject to a final ruling and testimony by the experts as far as how the court's going to rule on that. But yeah, Judge, they've done everything from the civil litigation, reenactment, vehicle collisions for personal injury cases to active police shootings. It's all based on video and then being able to get measurable points of reference, and then they do their fancy engineering stuff to it.
Which is what the problem would be, right? The fancy engineering.
Well, what this is, which is why this is, it's not different, but they used the raw data from the Faro scans that were done at the apartment to produce the scene.
Got it.
So that part clearly can't be contested.
I'm sorry, I didn't speak over you.
That's okay.
We're way far ahead of ourselves at this point.
Sure.
I think that I won't require necessarily the state to compile a response unless we're able to provide some sort of examples of how this would play out. So that one,
we can
that
take
to me
that.
is, that's way in the not distant future, but in the future.
Yes.
What about the motion for reconsideration of bond, which I agree with Mr. Prieto would probably be something we could do as a threshold matter. Are you going to file a response?
I am, Judge. That's the next one I'm going to work on. So this is a third request of the defense for a bond. First, was the Arthur hearing. Then there was another hearing for reconsideration based off of a medical examiner listed as well as a knife-throwing expert. And now there is a secondary witness, which has not been listed yet, is the grounds for this one. So the only issue with my response is they have provided this person's report. I don't know if they intend to list this person or intend to actually use them, but I do need to depose them. So it's hard to say, outside of just writing off of their report, what it is that I would respond to. So.
Yeah, Judge, I don't see why the state would need to depose this expert witness. It's an expert medical examiner from Hillsborough County that in the collateral civil case testified to matters pertinent to basically arguments that were made at the Arthur hearing by the state. The state argued at the Arthur hearing, quite honestly, and it wasn't Mr. Abeloff, but a timeline where they're in the state's mind, right, as charging this as a manslaughter, the depraved mind, charged as a second, right, the depraved mind aspect, which was the third element of what the state has to prove for manslaughter. They claimed that Ms. Clenney allowed the alleged victim in this case to bleed out basically 13 to 14 minutes prior to calling 911. This expert, the defense's argument was no, she called 911 right away. The phone records show, right, that she called 911 at this. Anyway, I'm getting into the minutiae.
Is there a transcript of the testimony that this witness gave at a prior proceeding?
There is in the collateral civil matter. Okay. There absolutely is.
And is that something that you could provide to the state?
It would cost me an arm and a leg, but sure, I could order his deposition.
I mean, I think that at some point in the future they're going to want to depose this person, but if you're relying on, and I'm not saying that it has to happen before the motion for reconsideration, fine, don't get me wrong, but what I'm saying is in order for the state to be able to respond, because that is one of the bases that you have put forth, then he needs to know what this person is going to say.
Right. I attached a very detailed expert report as an exhibit to the motion where Dr. Webb's, Malad Webb, details his findings, the basis of his findings. He refers to all the sources that he used to find it. All those opinions are contained in that expert report. Okay. So that's been provided to the state.
All right. How long do you need to file a response?
So again, Judge, so it depends on this trial. If this trial goes on Monday, I anticipate the trial will be finished Thursday or Friday. We have a probation hearing that I don't think is going to go on Friday. It should plea out. So in theory, I can start working on this either Friday or the following Monday. Okay. But I need to depose him. If I am provided this deposition, I don't need to depose him. I know what he's going to testify to. So the problem is the report is going to be a summary of what this person believes in.
I'm not going to have that. I'm not going to delay for a deposition for you to be able to respond. I think you can respond when you have.
Okay. And Judge, I did speak to Mr. Appelhoff, and I told him, look, the gist of the report, and obviously look at yourself. This medical examiner determines, based on his review of an expert, I believe qualifies as an expert, but he says that the injury occurred more likely than not to a degree of medical certainty that Ms. Clenney called 911 immediately after the injury.
Okay. Let me ask you this, Mr. Mayor. When you talk about the fact that you want to prioritize the motion for reconsideration of bond, which I agree, is that something that you are asking this court to do before we take a 2-week break during the holidays? In other words, does that have to happen before the 19th of December, or could it happen the week of January 5th?
Judge, I have to defer to the court, and Mr. Adolph is entitled to respond, so I'll defer to the court and the state on this. I mean, but obviously, there's a long history here of delay for a lot of reasons.
And talking for scheduling purposes, because
I will make myself available on the earliest date possible.
Okay.
If we can set it for the 19th, Judge. The 18th.
I have literally said everything in this division for the 19th, and we're also supposed to host a little gathering for the staff after calendar. So why don't we do the 18th? Okay. I want your response done by the 16th at 5 p.m. And we will set the motion for reconsideration on 12/18. Let me just take a look and make sure that that's not going to be problematic. All right, so what about the motion for bill of particulars? Does the state
Judge,
have a response on that?
By that 16th, well, the 16th, that one will be either handled or responded to.
Okay, bill of particulars by 12/16 at 5 p.m. All right, and the motion to suppress.
So, Judge, this was previously litigated before the Arthur hearing, specifically only to the Arthur hearing. There was motions filed by the defense, the motion filed by the state. The defense's motion is very similar I don't think it contains too many differences. I do intend to respond to it, but based off of the items that I think are taking precedent, I would ask that this be rolled over to the new year, and I'd be allowed to respond by maybe that first week of January.
I have no problem with that, Judge. I would just alert the state that this is an amended motion to suppress. We previously withdrew the motion to suppress simply because, although it's filed under a different rule of procedure, anyway, long story short is we amended it to specify the exact files as were provided to us in discovery that we're seeking to suppress so that they have them. And I would just urge this prosecutor, because his prior colleague filed a response, made certain arguments. I would just ask this prosecutor to review those and see if he wants to adopt those in his response.
I'm sure he will. So the motion to suppress response will be due by January 9th at 5 p.m. And what about the 404?
So I intend, honestly, we got a lot of it together for the Arthur hearing. There was one incident we were made aware of that occurred in Colorado. After the fact, we became aware of it. So it's going to take me not too much time to be able to put that together. The more important thing, though, Judge, is I don't want to list these incidents without actually having witnesses that will be available or I know I'll be able to produce. So that's the amount of time I'm going to need is going to be more so collecting those witnesses. So I would request probably the middle of January for that.
Any objections to that, Mr. Baton?
I would just ask that the state make their best efforts because the designation of the 404 really impacts the manner in which we take their depositions. So now this is going to push those 404B witnesses, actually I think in the state's 404A, but it's going to now push us into February at the earliest. So I understand the state needs to research it. If they are relying on specific incidents, they need to gather police reports. If there are police reports, I think they're required to disclose that to us. So I know they've got some meat on the bone there, but I would just ask that they make, that's a hard deadline.
January 16th, 5 p.m.
And that's the witnesses, designating the witnesses plus any documentary evidence that they're required to provide under the rule.
That's correct. All right, I think that we are at 12:18.
Right.
Anything further to say at this time?
Just to confirm, Judge, we want to litigate that motion to dismiss on that date as well? Or I'm not sure if defense wants to file a response.
Prieto wanted to prioritize the reconsideration of bond, but that's fine with me. If everyone would be ready to do that on the 18th, we can do both the reconsideration of bond and the motion to dismiss.
Was there they've already responded, so I need to review that. Do you think the court...
There's no rush on it.
We have enough time on the 18th to do that? I don't want to cram the court's calendar because I believe we can set that off in early January as well. Or the 18th. I mean, I'll be ready. I think the state's ready. We'll be ready.
And what are we talking about? A couple hours?
I think at the most.
Well, Judge, the better question is going to be whether or not an evidentiary hearing is needed. I think it's just argument. So I think, especially for the...
Yeah, let's do both. And on the 18th.
Okay.
And then obviously you might get a ruling on the dismissal part, but...
Right, I understand. And as far as evidentiary-wise, there's already record evidence in the collateral proceeding that is sworn to testimony, and that was provided to the state.
I'm going to provide a copy to the court.
Yeah, no, I'll put together a binder for the judge. But yeah, I think that's right, and I don't...
if I foresee some type of other live testimony being needed, we'll let everyone know.
Anything with Mr. Adams?
No, Judge.
I think that's it, Judge.
Very good. I have a meeting that I need to
Yep,
get to.
absolutely.
Thank you all.
You got it, Judge. Take care.
You too.
Good weekend. We're in recess.
All right, so that's basically introducing the new judge. All right, so let's get to the next hearing, which jumps to 2026 this year. So this one is from February 22nd. February 22nd. So this one's long. This is like 2 hours. So this one's going to have a lot of meat in it. I've got a few more to go after that. I've got I have 3 more to go, and then a quick 2.5 minute news about the family reacting. So we've got one from February, one from March, and then one from April. So we have 3 more hearings, and then we'll be done. And we'll be done, and we'll be ready. We will be so ready for this plea hearing. All right. Wait a minute. What is this? Who's this? We got people coming on. Not sure what that's about. Got some talking heads in this one. I got to be ready for the talking heads. All right, here we go. This is from February 22nd. Let me just post that here. All right. Hearing from February 22nd. Oops. February 22nd, 2026.
All right, good morning. We are on the record now in the case of the State of Florida versus Courtney Clenney, case F2214137. Would the parties please state your appearances for the record, starting with the state?
Yes, so good morning. Still, John Gabby Alfaro, and Kathleen Hogue on behalf of the state.
Good morning. And on behalf of Ms. Clenney, who is present.
Good morning, Your Honor. Sabrina Puglisi and Frank Prieto on my behalf.
Excellent. Give me one moment. I am going to get my notes in order. All right. So today we are here for a couple of purposes. First and foremost, I know that there are some witnesses on Zoom for the defense motion to exclude. And who will be calling the witnesses?
Judge, I'll start with calling Dr. Lenore Walker.
Okay.
And she is present on Zoom.
All right, Dr. Walker. And Mr. Abraham, is there anything preliminarily before we begin the testimony?
Yes, Judge. I believe based off the stipulation, there will be recordings that separate hearing. I apologize. So that's going to be the next hearing. I can do it after, Judge. So no, there's nothing right now.
Okay, very good. Dr. Walker? She might have stepped away from her computer.
I just asked her to put her camera on. Let me just check it. Oh, my camera's disabled by the host. I do see.
Yeah, that actually, we have to do that, otherwise we'd never get through a regular court session. Janet, can you please allow Dr. Walker to come on camera and unmute? All right, tell her to give it another try. All right, very good. Good morning.
Oh, there she is. Okay, perfect.
All right, Dr. Walker, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, very good. And Ms. Puglisi, you may proceed.
Thank you. And Judge, before I begin, there was an issue about confidentiality in a prior settlement that they had. In order to try to streamline this, I believe that both
the doctors are willing to waive any confidentiality. It does not, as I explained to Dr. Walker, change the terms of any settlement and her understanding of it. It just means it allows us to be able to address the matter. Dr. Walker, do you agree that you would waive confidentiality, any kind of confidentiality clause that you have?
Yes, I will.
Okay, thank you. And Judge, I think we're all familiar with Dr. Walker's kind of her expertise, so I wasn't really going to go into, her whole background. You
stipulate, Ms. Jackson? Okay, excellent. So Dr. Walker will be allowed to give opinion testimony.
Okay, Dr. Walker. And the only thing I will ask is, I know you've been previously been found to be an expert, but can you tell us again what field of expertise?
Yes, I'm a clinical and forensic psychologist with an expertise in trauma, especially interpersonal trauma, such as sexual assault, domestic violence, and other forms of interpersonal trauma.
Okay, perfect. And we're going to focus for right now, we're really here for a specific purpose. So I'm going to draw your attention to a prior civil lawsuit that took place in Broward County in 2004, and that was with yourself and Dr. Michael Brannon. Are you familiar with that?
Yes, I am.
And what is your understanding of what that lawsuit was about?
Dr. Brannon and his colleague, Dr. Sherry Carter, filed a defamation lawsuit against me for what they claimed was when I was teaching. I was a professor at that time at Nova Southeastern University, and used some clips from a newscast for testimony of different psychologists, because I was teaching forensic psychologists how to testify in court, and they claimed that I evaded them by using, he said that I evaded him by using those clips in my class teaching.
Okay, perfect. And are you familiar with the amended complaint in the case that was filed?
Yes, I am.
Okay, and did you stipulate judgment, stipulation of the parties, we would enter A1 for identification into evidence.
All right, it will be admitted.
Defense Exhibit 81 is nothing. Defense Exhibit 80 is nothing.
Was the case ultimately dismissed with prejudice?
Yes.
Okay. And was there a release signed to your understanding?
By each of us, each of the parties, yes.
And what was your understanding of any kind, if there was a settlement agreement, what was your understanding of it?
I had also filed a countersuit against them, and so all three of us agreed that we would not speak about one another, especially any kind of negative comments about each other.
Okay, so no negative comments against each other. Do you know if this agreement that you're referring to, was that ever memorialized in writing?
I think it was. I remember seeing some papers, but it could have just been my attorney who gave me the actual terms of it. But I saw it. I remember seeing it, but this is 20 years ago, and I can't find it.
So you have tried to look for it and you can't locate it?
That's correct.
So with your understanding of the fact that you can't have personal attacks against each other, what did that mean to you as far as handling cases with Dr. Brannon on the other side?
Well, it meant that in order to be a rebuttal psychologist, you have to have the testing
that you would do, that the person would do. And so I would have to hand over my testing and my evaluation, and then he would have the right to criticize it. And if he said anything bad or negative about my methodology, that would be violating the agreement. The same thing for me. I would be on the other side of the case for him, and I would not have that opportunity or the right. Second, that's the first most important thing. The second is that it's not ethical to take on a case where you may have a bias, any appearance of bias. That's in the ethical principles of psychological practice and in the guidelines for forensic practice. So it would be wrong to take on any case that you're on the opposite side of.
And so let's break that down just a bit. When you say if he critiques your personal methodology, what about that makes you believe that that's a personal attack on you, or vice versa?
Well, it's a personal attack on my professional methodology on how I conducted an evaluation, which is perfectly appropriate in a case, but not against the person. And given the fact that he's already, we've already had this kind of contentious history together, it just would not be appropriate, nor would it be fair to the client that would get us more involved with who we were and what we were dealing with, rather than what the client's needs were.
And you secondly mentioned professional ethics. Were you referring to the ethical principles of psychologists and the specialty guidelines for forensic psychology, the standards there?
Yes, I was.
Okay, and specifically standard 3.06 and guideline 1.03, can you explain exactly what those standards say?
Yes, standard 3.06 is a title conflict of interest, and it states that psychologists refrain from taking on a professional role when personal, scientific, professional, legal, financial, or other interests or relationships could reasonably expect to 1. Impair their objectivity, competence, or effectiveness in performing their functions as psychologists, or 2. Expose the person or organization with whom the professional relationship exists to harm or exploitation. The specialty guidelines, which are only guidelines but considered best practices, guideline 1.03, avoiding conflicts of interest. Forensic practitioners refrain from taking on a professional role when personal, scientific, professional, legal, financial, or other interests or relationships could reasonably be expected to impair their impartiality, competence, or effectiveness, or expose others with whom a professional relationship exists to harm.
And knowing these ethical obligations that you have and Dr. Brandon have you tried over the last 20 years or so to not be on the same case as Dr. Brandon?
Yes, I have.
And did you provide me with an email that goes back as far as 2011 between yourself and Attorney for Regional Conflict Counsel Kelly Peterson, explaining to her that you couldn't take a case if Dr. Brandon was on the other side?
Yes, I did.
Now, there have been some cases that you have been listed as a witness and Dr. Brandon's on the other side, so I want to ask you about those. The first one, well, let me ask you this. Have you ever, If Dr. Brandon was first listed, that's so much better, thank you. They just made you a big block, so now I can see much better. If Dr. Brandon was ever listed as a witness first, have you ever accepted a case opposite him?
No, I have not.
Now, in a situation of State of Florida versus Lewis Late, you were listed as a forensic psychologist on that case by the defense?
Yes, I was.
Okay, and later, Dr. Brandon was listed by the state, is that correct?
That's correct.
Did you advise the attorney, the defense attorney in the case of any conflict of interest that you believe existed?
I did.
And who was that attorney?
That was Jeffrey Wiener.
And at the end of the day, whose decision is it whether to disqualify or move to disqualify an expert? Is it yours?
No, it was the attorney's. At that time, it was the attorney's decision.
And so, did you end up testifying, and Dr. Brandon was also a witness in that case?
I did. That's how I understood that, how uncomfortable it was for me, given the agreement that we signed, to be able to do that.
Can you explain more about what you mean by uncomfortable?
Well, I have to I have to pay attention to what my information is for the client. I can't pay attention to myself and my feelings. And I was very uncomfortable, and that interfered with my ability to pay attention to what was happening and making good decisions and responding to questions. I was afraid of being somehow violating the agreement, which I didn't want to do.
And now there's another case of Satoya Johnson that you were listed as a witness in that case. That was a Broward County case.
Yes, that was many years later. Again, I was hired first. I performed the evaluation. I think we may even have gotten to depositions in that case. And then Dr. Brandon was hired by the state. And I did not want to turn over my documents, my evaluation documents to Dr. Brandon. And so I got out his.
Now, the next and the last case that you have, besides this one, that you've been listed as a witness alongside with Dr. Brandon, secondly, is the Corvalon case. That's a current case in this district here in Miami-Dade County?
That's correct.
Okay, and have you had to testify in that case as of yet?
No, I have not completed the evaluation. I have submitted a report, and the attorney asked me to turn over my rotated documents behind the evaluation, and I again said no. And the attorney, I think it happened almost the same time as it happened in this particular case. And so the attorney said that he was just to wait and see what happened with this case.
Okay, but you did advise him of the conflict?
Definitely.
Dr. Walker, what are your concerns of Dr. Brandon remaining on this case here?
Dr. Brennan and I were actually at a meeting maybe 2 years ago. He I was the presenter, I was extremely uncomfortable within the audience. I don't know exactly why, but I think just emotionally. It was very exciting for me. I have never been involved in that kind of defamation lawsuit before, or that kind of hostility that I felt. And so I feel that this has been so contentious, it's been lasting for so many years, and that it's not fair to myself as a professional, nor to my work for the client to have to deal with him and my uncomfortable feelings with him. I need to focus simply on my job as a forensic psychologist.
And you understand that as an expert witness, Dr. Brandon would have the right to be able to sit in on your testimony, just like you would have the right to sit in on testimony that he was, right?
Yes.
Okay. I don't have anything further.
Cross-examination?
Yes, Judge. Good morning, Doctor.
Good morning.
So this lawsuit, this was 22 years ago, right?
Yes.
And in that, the resolution of that lawsuit, it resulted in both of you all settling, both the parties settling and the case being dismissed for prejudice.
Correct.
You've actually worked against Dr. Brandon now since that, and we at least have 3 different occasions concerning that.
Only one time. It was the light case, and that was way back at least 20 years ago. I've never worked at any other time.
So Cecilia Johnson is not another case?
It was a case that I got off of rather than work and having to jeopardize what I thought was jeopardize my objectivity for the client.
Right, but you made that decision. It didn't go before a court.
Well, the attorney and I made the decision.
Again, you made that decision.
Yes.
Now, with this agreement, and right now, as we sit here today, you've waived any sort of confidentiality, if there so exists one, right?
I'm sorry, I don't understand what you mean. There is an agreement. I have a copy of it, and I did agree to waive the confidentiality that states in that agreement for today.
For today or in its entirety for this case?
I believe it's for today.
So you have an issue, and again, you haven't presented this confidentiality agreement for the future, or for, I guess, some filing showing that this is a confidential settlement.
I don't understand what you mean. It's been already filed, and it's already, I have a copy of it. And I believe even it states,
So does that direction states we move in 1B, 1D, and 1C?
All right, they'll be admitted. One moment, Doctor.
Just for the record, Sex Exhibit 1B was space 1, 1C space 2, 1D space 3.
And can you pass those back to me?
Yes, I'll pass them to you.
Okay. Mr. Abiop, do you need those back, or can I retain them? Okay. All right, you can proceed.
Dr. Walker, I'm sorry, are you alone? Are you alone in your office?
My husband just walked into the room and he was making noise, so I was trying to ask him to, but not in my office, but I told him out of the room.
Okay. So concerning, this sort of court order, and I just want to make sure, because you keep looking off to the side, that I have your attention. Are you good? You're on?
Yes, I am. I was looking at the document. I was going to read you the statement from the document when you stopped me.
Concerning this document and these documents concerning this case, there is no filing of this court, of that court, the judge that presided over that has the terms confidential in it, that's filed and a part of the document.
Of the court from the original case, the document that I have was filed by the court. I have it in my hands. And number 5, it's the end of that sentence says, obligations imposed by this paragraph, which are the confidentiality, are ongoing and shall survive the consummation of the settlement. The parties and their attorneys consent to the continuing jurisdiction of the court for the purpose of enforcement. And this is the document that I wanted to read.
So, Doctor, and I think...
And this was filed by the court.
So, Doctor, and just for the record, we're going to agree to stipulate to another document coming in, I believe, you know what's marked?
It's
A2 to come in as defense exhibit.
Let Darlene be. Let's not overstep our expertise. The clerk knows how to.
Stepping out of my
Exactly.
Stepping out of my lane.
A grade there. Okay, you said B, right, Darlene?
It's big judge.
Yes, ma'am. Thank you. Go ahead, Mr. Abney.
So, Dr. Walker, concerning this document that you're referring to, the court now has it. Can you indicate to the court, to this court, where that is signed by the judge that was over your case?
The last page.
The last page that has number 3 at the bottom. Just so that I'm talking about the same thing. Can you say?
Yes, I got it by Judge Robert Sanders.
Can you say whether?
Yeah, I may as well sit down and do it.
So, Dr. Walker, I'm going to ask you, where is it signed by the other parties? Dr. Brandon or Dr. Carter? Or their attorneys?
It is, if you look at the last pages, the first page of mine says from my attorney that they will have individual signatures on each, for each party instead of circulating one copy.
Would it surprise you, Dr. Walker, that, and these aren't numbered, but page 1, page 2, page 3, page 4, page 5, and page 6 were actually not filed with the court in that case, and were not agreed to by Dr. Brandon or Dr. Carter?
That's not what I was told. I was talking about 20 years ago. And I do have signature pages that are similar to the ones that I have.
Correct. And that is the final orders. But that does not include that confidentiality statement. And actually, are you aware that the clerk of court combed through this file, and the first 6 pages of this document has never been filed, nor agreed to by Dr. Brandon or Dr. Walker?
That's not my understanding.
I understand, but I guess my question to you is, are you aware that the clerk of court did a search? This court issued an order for any confidential documents to be able to be turned over, and there are none.
have followed it, and Dr. Brennan has followed it up until just this point. And so why would he be following it for 20 years if that wasn't his understanding? Doesn't make sense.
Doctor, when it comes to this confidentiality, are you willing to waive any confidentiality going forward in this case, if it so exists?
No, I'm not looking to waive confidentiality. I'm fine. I don't want to get into the weeds of what happened at that time. I don't think Dr. Brennan does it either.
Well, doctor, you speak for yourself only, and not other doctors. But my question to you is, now that knowing that there is no court order making this a confidential case, are you unwilling to waive confidentiality?
Object, because I think this is beyond her knowledge and expertise. He's asking questions about the law, and that's beyond her knowledge.
It's overruled. Repeat the question, please.
Doctor, knowing that now that there is no confidentiality order by the court that handled your case, are you saying that you are unwilling to personally waive that conflict?
That's correct. My understanding it is possible that the court does not have the document. That doesn't mean it wasn't filed. It simply means it's not 22 years later or 20 years later, we don't have it.
Well, doctor, and that's how
so I'm not willing to accept that it's not, that I'm not bound by it.
Despite this agreement that you had to settle and go your separate ways, at least in concerning Lewis Light 2009, you did participate in that case.
Yes, I did.
You chose to participate fully in that case and testify.
And it didn't go well, which is why I have to now insistent upon not doing it.
Question for you on a conceptual standpoint of cases that you are brought into on. Doctor, there's no doubt you are an expert for battered spouse syndrome, right?
Yes.
And for a defense attorney, that this defense is not something the state ever brings up, right?
No, that's not true. I testified to the state on occasion when they have raised it.
That's not my question to you, doctor. When it comes to an affirmative defense of battered spouse, you were always hired first.
Well, I can be hired also by the defense, by the state rather, because it's my understanding that the law allows the state to examine somebody who brings up battered woman syndrome as his defense. And I have been hired by prosecutors who have wanted me to look at the case and say whether they thought what my opinion was about how, if and how battered woman syndrome might impact the person's state of mind at whatever the act
There's a board that monitors ethical actions of doctors, right?
Yes, I'm not sure I'd say they monitor, but you certainly could be reported to them.
And you can report someone if you believe they are violating their ethical values, their ethical obligations.
I could.
There has never been a report from you concerning Dr. Brand.
Because we have not engaged like this before.
That's not true. You engaged in Lewis Light in 2009.
And as I explained to you, that was a case that I did not realize it was the first time that occurred, and I did not realize how it would impact me. And as soon as I did, I stopped doing it.
And Satoya Johnson, 2018, when you decided to get off of that case, you did not refer Dr. Brand to this ethical board.
No, it is another ethical issue that I did not go further. If I would have gone further and stayed on the case, then I might have had the opportunity after the case is over. But there's such a thing as witness tampering, and I would not report somebody who's a witness or scheduled to be a witness on a case until after the case is done.
Doctor, 2009 was a long time ago, right?
Yes.
2018 now is kind of a long time ago, right?
Yes.
Both Lewis Light and Satoya Johnson's cases are over with, and you have not reported Dr. Brand to any sort of board.
I've had no experience with it that would make me report him. He chose to stay on the case, I chose not to stay on the Satoya. I don't even know if he was on the Satoya Johnson case. I only knew that if I was not going to send my documents to him and the attorney and I agreed, then I would get off the case.
Karina Corbalon, you have not reported him to any board now that you both are on that case.
I didn't know. As soon as I knew he was on, I informed the attorney. It did not say anything to me until I then knew it. And at this point, we knew that this case was coming up as well, and that we were going to handle it in front of the judge. So that was no reason for me to report it.
Concerning your notes and Satoya Johnson, that case, you decided personally you did not want to turn over your notes.
Yes.
And it's your testimony you never turned over your notes.
Well, I think I did have a deposition, but I did not turn over anything that I'm aware of to Dr. Brandon.
Is it your...
It's possible that the defense attorney said had turned over what she had to do, but I did not.
Is it your testimony that Dr. Brandon was not provided your notes in that case?
It's my testimony that I did not provide my notes to Dr. Brandon.
That wouldn't have stopped the defense attorney from fulfilling that obligation, though.
Objection called.
I don't know. I'm saying,
Dr. Walker, you don't need to answer that question. Go ahead, Mr. Acker.
Concerning the understanding of the agreement with the judge, your understanding is that you're not to make any negative comments about each other, right?
correct.
And you, without any explanation or understanding from the court, take that to also mean that you cannot comment on someone's professional work.
Of course, this is all about professional work, not about personal comments. He was upset with me for what he claimed was using his testimony as examples in my class.
And there is no court order that prohibit you or him from testifying as to each other's work or to comment on that work?
I don't believe there's a specific court order about that, but there's no way I could comment on his evaluation without commenting on if I saw something that was not appropriate or not what I think would be appropriate methodology, then I would have to say something that would be negative or bad.
Doctor, if he waives any liability for you commenting on his work, are you saying to this court here that you will not waive the same?
Correct.
Does that have further questions?
Redirect. Thank you. If there's no court order, do you still believe there's a settlement agreement in the case?
Yes.
Are you an attorney?
I'm sorry?
Are you an attorney, Dr. Walker?
No, I'm not.
Did you draft any of the legal documents in that civil case?
I did not.
Did you personally communicate with Dr. Brandon's attorneys in that case?
I did not.
Did you file any documents with the court in that case?
My attorneys, they have on my behalf.
Did you personally, though?
No, I did not.
Are you?
I was actually represented by two sets of attorneys because Dr. Brandon also sued Nova Southeastern University in that lawsuit. And so, I think the attorney Canada was also involved initially, and then I had a second attorney for my malpractice insurance. So I had two different attorneys, so I didn't keep track of what they were doing.
Are you aware that it's not uncommon for settlement agreements to exist but not be filed
Objection to that
publicly with the
speculation.
court? Sustained. Do you have any knowledge? It's okay.
One moment, Dr. Walker. She's going to ask the next question. Go ahead.
Okay.
Are you familiar with the law on settlement agreements and whether they need to be filed or not?
I do not. And I don't familiarity with it. It's the only case I've ever been involved in. That would.
Did you sign a confidentiality agreement in this case?
I did.
Do you believe it still exists?
I do.
And do you believe it would be unethical and cause harm to the client if Dr. Brandon were to remain on this case as a witness?
I do.
I have nothing further.
All right. Thank you, Dr. Walker. You're excused. Have a nice day. All right. We're going to move on to Dr. Brandon. Hi, Dr. Brandon. How are you? Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Very good. Mr. Adcock?
Yes, Judge. Good morning, Dr. Brandon.
Good morning.
All right, and is the defense willing to stipulate as his expertise as well?
Yes. All right, very good. Dr. Brandon will be allowed to give expert opinion testimony.
So, Dr. Brandon, can you shed some light into this lawsuit between yourself and Dr. Walker to the court?
Sure. It's pretty simple. There were several students who were from Nova Southeastern University who were doing more practicum work in my office and some day work. And several of them had reported to myself and my partner, Dr. Sherry Ricardo, that Dr. Walker was making negative comments about us routinely in the classroom, specifically about us being unethical, and that they should stay away from us and not have any sort of experience with us or any sort of contact with us. So it had nothing to do with playing videos. The videos may have been done or not. I don't quite remember. It was 20 years ago. But our concern was, Dr. Walker, if that was true, this is what the students were saying, was making negative comments that we felt affect us in terms of our careers at that time with future students and colleagues, as well as other people at Nova Southeastern University. So that was our concern, was just to get her to cease and desist if that was what was occurring.
And Doctor, concerning the resolution of that matter, could you explain, for one, was there an agreement to dismiss the case?
There was, yes.
Concerning that, did you sign an agreement in order to stipulate to that agreement that the case would be dismissed?
That would be dismissed, yes.
Did you ever sign anything concerning confidentiality?
No.
Had you actually signed something like that, would you be willing to waive any sort of confidentiality in order to be a part of this case?
Yes, absolutely.
Concerning the court's order that is filed and part of this case, what was your understanding as to what you were prohibited to do?
Well, in some ways, similar to what Dr. Walker said, that we should stop saying personal things about each other, which was really the basis. This wasn't anything that happened in the case. It was just negative comments made in the classroom about us as told by several students. So my understanding, matter of fact, our attorneys, we accept our attorneys, myself and Dr. Burke, of this, basically goes to the judge and said we should stop saying bad things, negative, personal things about each other. And the Dr. Walker had agreed to that, and that was part of the agreement. And I thought it was resolved. I thought it was completed that way. And I haven't given it much thought since then. So if Dr. Walker agreed to that, whether she did it or not, she made that agreement. We made that agreement. I think it was negative comments, personal comments about her, which we hadn't done, but we were having to make that agreement. I thought that was the resolution of it, and that issue was no longer at play.
When it comes to personal attacks versus critique of work, did you believe that this court order had any limitation as to you critiquing Dr. Walker's work?
Yes, we would have never agreed to that, especially then 22 years ago. Next to us trying to get as much work as possible from the courts and attorneys, we would have never agreed to that. So if we felt there was something wrong or difficult with us doing that, of course we wouldn't do it. But we didn't see that there was any issue or problem once the matter was resolved.
And since the resolution of that matter, have you on multiple occasions actually been on the adverse side of Dr. Walker professionally?
Yes, sir. And as a matter of fact, the attorney, the defense attorney in the West Palm Beach case, the Clenney case, was Joel Bushorn. And he actually came up to me before the hearing. He was the attorney of the opposite side. I was testifying for the state. He said, I want to make sure it's not being personal that goes on here. You have an agreement on saying personal about Dr. Walker. I said, of course not. I don't have any understanding, sir. Of course I wouldn't say anything personal. It's all about issues. And that's exactly how that trial went. There was no personal comments or commentary or attacks. I don't feel that way. I certainly wouldn't bring up the court if I did. So then that trial went along without any altercation or any accusations or anything improper, personal, unethical, nothing.
Concerning the multiple cases that you have worked as an adverse expert against Dr. Walker, at any point in time as a result of your involvement in that case, have you ever been reported to any board of ethics?
No, I'm really quite surprised to hear some of the testimony today. I didn't know there was a strong feeling still. We were in an adversarial process, and as part of that process, people bang heads sometimes. But I don't think those things tend to stay around, especially 20 years later.
And concerning this case, are you in agreement that you will abide by the order of that court 22 years ago to not make any personal attacks about Dr. Walker and her work in this case?
Well, if it's professional work, professional disagreements, reasonable experts to disagree. I certainly think Dr. Walker can talk about why anything she disagrees with, I do, and vice versa, in a respectful, ethical manner, being the experts that we have in the system for as long as we have it. I don't think that's personal, but I think it's about issues in the case. So we're both taking an objective approach to a case. We didn't disagree and put those matters before the jury, before the judge.
Judge, I have no further questions.
Cross-examination.
Thank you. Dr. Brandon, are you familiar with the amended complaint that was filed in your case?
So everything was in the court file.
Okay, perfect. And that amended complaint, it was obviously not drafted by you, it was drafted by your attorney, Joseph Flick, is that right?
Sure, it was never, yes.
But you are familiar with what is written in there. It's not, there's nothing that your attorney wrote that you disagree with. Would you agree with that?
Correct.
And so in that agreement, in that complaint, one of the allegations is that Dr. Walker said that you would do anything to win a case. Is that right?
So I don't remember that. That sounds familiar.
Okay, and now that's not a personal attack, right? That attacks your reputation as to what you do for a living, right?
Objection to speculation.
Overruled.
So I think that is personal. So if you say that, you're referring to the person is not operating in the way that he should be operating ethically in the case. So I think that is a personal one.
Okay, but it's more than just personal, right? It's also attacking your professionalism, correct?
Sure, my approach to a case, as opposed to my methodology, what I did or didn't do, or the tests I used or didn't use, that's a different kind of commentary. That's a personal commentary.
Right, so you would say if Dr. Walker were to testify she thinks you're unethical, let's say, that would be a personal attack? She wouldn't be allowed to give her opinion as to that?
Well, unless you establish it in terms of procedural errors or difficulties or pointing out bias. So if you do that professionally in terms of the work that we do, I don't think so, which is her pure opinion, that's one thing. That she's able to outline facts and data and evidence to support that, sure, I think that's fair game.
Now, you allege that her statements exposed you to hatred, ridicule, contempt, and or tended to injure you in your business reputation or occupation. Is that right?
Yes.
That as a result of her actions, you suffered shame, humiliation, mental anguish, and hurt feelings, and that would be experienced in the future. Is that right?
It's not an issue for me anymore. We resolved it the way that things are resolved in court, which is we each file lawsuits about this. So that's the way things are settled. So in terms of my personal feelings, I have no interest towards Dr. Walker at all.
Thank you. That wasn't my question, though. My question was that you said, as a result of her actions, you sustained injury to your reputation and or health, sustained shame, humiliation, mental anguish, and hurt feelings in the past and to be experienced in the future. Is that right?
So Judge, I'm going to object because he did answer it, and she's disagreeing with his explanation.
We'll see yes or no first, and then
That's what he can.
Okay, folks, remember that Amber, who can't take down everything everybody's saying at the same time. The objection is overruled. Go ahead and ask the question again.
Okay.
So I did feel that way then, based on what the students reported. I don't have those feelings now.
Okay. But you do agree that this civil case creates a conflict of interest inherently, right?
Objection, Judge, improper.
Sustained. You have ethical considerations that you must abide by?
Yes.
There's ethical principles of psychologists and a code of conduct, is that right?
Yes, ma'am, right.
And basically it says that you're supposed to refrain from taking on a role when personal or legal relationship could reasonably be expected to impair objectivity, is that right?
Yes, ma'am.
And I'm assuming your opinion is that it couldn't reasonably be expected to have impair your objectivity. Is that what you would say?
Yes, ma'am. I have no bias or feelings towards Dr. Walker in that way. I did then. It was resolved in 2006.
Have you advised any prosecutors that you were involved in a civil case? Let's be specific to say in this case. Did you let the prosecutors know when they went to hire you that, and you learned Dr. Walker was on the other side, did you advise them that you had a civil litigation against her from years ago?
Yes.
Okay. And in the Corbelon case, I think it might be the same prosecutor in that case, so did you inform Mr. Applehoff about that conflict?
Yes.
Okay. personally evaluated Ms. Clenney in this case, is that right?
Yes, that's correct.
You haven't reviewed any kind of testing data, underlying data for her evaluation?
Yes, sir, that's correct.
And so your involvement in the case so far has been limited to just some conversations you had with the prosecution, is that fair to say?
No, ma'am, I've reviewed some documents.
Okay, can you say how many documents, or let's just cut to the chase and say about approximately how much time have you spent in your review of this case so far?
Approximately 20 hours.
20 hours, then I would like to know what you reviewed.
I don't have in front of me, I reviewed information that was sent to me by the state attorney's office, it's voluminous, so I don't have those documents. I can rely on those, but I didn't come to this year and prepare to do that.
Can you at least name some of the documents that you reviewed?
Judge, I think his answer speaks for itself, and he doesn't know.
I mean, 20 hours is a long time.
It's sustained. Next question, please.
Have you, let's try that. Your understanding of the agreement is that it has to do with personal things. Personal things, though, you would agree, you know, a personal attack could be about the way a person dresses. That's a personal attack. Would you agree with me on that?
Sure, absolutely.
Okay. But you would say also if I attack your reputation, your credibility, your methodology, I will.
Oh, okay.
I will break it down. If I were to attack your methodology, you think that's not a personal attack on you?
It's not. No, that's fair.
If I attack your credibility, that's not a personal attack?
Well, look, it's based on evidence, it's based on data.
Okay, so your answer is no?
Well, my evidence is no, it's based on data. It's not, it's just a personal data, and that's a personal attack.
Okay, can I go on, Judge?
Of course. Oh, here.
Just a moment.
Sure.
Up to this point, we've reviewed everything that's been provided to you. And the only reason you haven't reviewed the testing materials or notes is because they have not been provided to you.
Yes, correct.
But I don't know.
All right, thank you, Dr. Brandon. Have a nice day. You're excused. All right, are you ready to proceed with the argument, Mr. Puglisi?
Yes, Your Honor.
Okay, you may proceed.
I don't think it matters whether it's confidentiality or not. At the end of the day, you know, it's what both parties. I think there is no dispute that both parties agree they were not allowed to say negative things about each other, right? That's what we can all agree on. And so the question really here is, what does that mean as far as personal attacks? Because the case that was filed against Dr. Brandon clearly wasn't about, you know, something she did to him when they were seen at the grocery store. It was an attack on his reputation, his credibility. And then you look to the ethical rules and, you know, it's a reasonable objectivity. It's not what that person thinks, it's what's reasonable. Is it reasonable to think that he still, it doesn't matter if it's been 20 years or not, that he still has some kind of bias? And, you know, putting aside the fact that, you know, honestly, candidly, there's a lot for cross-examination here, right? Like, the defense could cross-examine Dr. Brandon on all these things he filed in his complaint and whatnot. But that's not really the point. The point is fairness of the trial to Courtney Clenney. And we don't believe that
having this doctor testify would be fair, because what's going to happen is it's going to become a sideshow in this case, right? These two doctors had a lawsuit 20 years ago. It's going to be a, he said, she said, back and forth about that. And what it does is it takes away from what really is important, which is the battered spouse defense, which is a valid defense, and that, we are entitled to present. And we want to make sure, so at the end of the day, 403 analysis shows we want to make sure that Courtney gets a fair trial. Now, then the question is prejudice, because I know that the state has a right to have their expert of choice, just like we do, but you then have to balance that. And so in this case, okay, let's assume Dr. Brand has spent 20 hours. He hasn't evaluated Ms. Clenney. He hasn't reviewed the underlying data. At the end of the day, 20 hours is nothing in comparison to making sure that she is given a fair trial. There are plenty of other experts out there, and the state has the opportunity to be able to go and get another expert before this goes farther. Let me just make sure if I have any other notes here. I think what's important here is that we hired Dr. Walker first, and she clearly is uncomfortable. She says she believes it's unethical. She says that she would not be able, she does not feel like she'd be able to answer the questions properly without constantly thinking about whether there's an attack or not. And there's no question that he does agree that it doesn't matter if anything was filed. I think it's common knowledge that civil cases agreements are entered into and not filed with the court. That happens all the time. They're done confidentially, secretly. And again, so what the exact terms, we know that they both agree they can't make attacks against each other personally. In her mind, it's a fine line, right, between what is personal and what is professional. And it's very hard to distinguish. And she, to sit there while she's testifying and think, oh, is this going to be a personal attack or a professional attack on what he's saying? And so I think for all those reasons, Judge, I think under a 403 analysis, we would just ask the court to disqualify Judge Brand in this case and require the state to find an alternative expert.
Mr. Abraham?
Yes, so the defense brings up this idea that confidentiality doesn't matter. It matters a lot, because without there being a confidentiality agreement, there is no limitation, as they bring up in their motion, to cross-examine this witness to the full extent of this lawsuit. So again, a lot of the things the defense brings up is fodder for cross-examination. The issue here is that they're kind of conflating the fact that the expert feels uncomfortable being a part of the case, that there's nothing in this lawsuit that prohibits him from being on a case against her. If there was, it would be in one of these orders. It just isn't. When it comes to this constant overthinking, that's a personal issue. She's got to work through that. Dr. Brand has clearly said that he's going to work within the lines, and if it's not based on data and evidence and facts, it's not part of this. Your Honor has done a fantastic job with this case of trying to streamline us to trial. For us to get another expert at this point would delay this even further. The other part is Your Honor has the ability, once these witnesses are fully deposed, after they fully examine the witnesses, to be able to fashion some form of limitation, or not. If it's all fodder for cross-examination, then that's what it is. But Your Honor has done a good job of managing this, and I believe you can do the same now. The issue that the defense has, this uncomfortability of this, is not supported by her own actions throughout time. She's had multiple cases in 2009, 2018, where the ability, if there is an ethical issue, which is what the defense is raising today, she could have sent him and his actions of staying and remaining on these cases to some sort of review tool. Hasn't been done. We're just sort of walking through time where we're just raising our hands to the next defense attorney saying, I'm comfortable, and each of those defense attorneys are not raising conflicts because one doesn't exist. And that's why we're here, Judge. At this point, the defense has not shown that they're entitled to exclusion. They can't show that this court can't monitor this situation. They talk about this becoming a sideshow. It easily should not be a sideshow and can be limited to not be a sideshow, because this is, and battered spouse is a case of facts and evidence and support. Defense brings up, and this is my last point, that they hired their expert first. Now, in reality of this, the state is not raising defendants' defenses or potential defenses for them. So in every case that there's a murder, what defense is asking is that we hire Dr. Brand and other doctors alike to completely negate this first to the altar of hiring. And that's just not possible. It's not feasible to taxpayers to have to front those bills, and it's not how this all works. It's just, at the end of the day, this first come, first served is not how this all works. We're able and entitled to be able to hire an expert that we believe can adequately and professionally handle this case. There's no issues at this time to warrant exclusion of Dr. Brand.
Mr. Obumseli?
Judge, I will only just respond to direction by Dr. Walker to move forward in these 3 cases. Well, we know that he testified and she testified in the case in Palm Beach, Lake's case, and as a result of that, she understood what it was like. She felt that it was very uncomfortable and she was hampered, and as a result, she has made efforts to avoid that. Satoya Johnson, as soon as she saw that he was on, she withdrew. There is no need to direct to the ethics board because she's no longer part of that case. As far as the Corvalon case, it's still pending. She hasn't testified and he hasn't testified, so there's no reason to send that to an ethics board. And similar to this, I guess we'll wait to see, what happens, but those are not the times to do that. So I don't think that whether she directed him to ethics board is really the relevant issue. It's more about whether Courtney Clenney can get a fair trial if Dr. Brandon is allowed to be an expert.
All right, thank you. Time based on the testimony and the arguments of the attorneys, the defendant's motion to strike state's expert witness Michael Brannon is respectfully denied. The court finds that the requirement for disqualification must have a showing of prejudice or compromise to the judicial process. The court finds that does not exist in this case, and any issues of cross-examination will be appropriately limited by this court according to the rules of evidence. And now we're going to turn our attention to the amended motion to suppress illegal recordings pursuant to Florida Statute 934.03 and 934.06. Is the state ready to proceed?
We are, Judge.
Okay, defense, are you ready?
Yes.
Okay, very good. You may begin.
And briefly, Judge, before we begin, the state is moving in without objection 1A, which is a copy of the recordings that we are not stipulating to, and I'm going to announce at least to the court which ones we are already stipulating to for exclusion.
Okay, give me one quick moment here. I'm just reviewing my notes so that I can match up with what you're going to tell me next. Okay, so go ahead.
So from our motion, Judge, our response, we numbered them. And I'll read both our numbering and then actual what the filing is. We're stipulating to exclusion on 1 through 6, 10 through 13, and number 17. Number 1 in our motion is ING_3758. 2 is ING_3759.
3772, 38G_3775, 3776, and 3777, and 3778. That's 1 through 6. And then 10 through 13 is 3808, 3889, 3898, and 3917. And number 17 is 4003.
Can you go back? It was 3808 you said, and what was next?
3889, 3898, and 3917.
Got it. Okay. Everyone's on the same page with that, Mr. Prieto? Yes?
Yes, Judge, I was just inquiring whether the state mentioned it's number 17, 4003. That was also stipulated too?
Yeah, we heard about that.
Yeah.
Very correct, Judge, yes.
Okay. And the USB that you have presented into evidence is the items you are not stipulating to their exclusion?
Correct. It's 3782, 3794, 3797, 3997, 4001, 4002, 4005.
Okay. And for the record, the court has reviewed all of the items that are at issue, so however you wish to proceed in making arguments, you may. Yeah. Yes, ma'am, that's admitted. Is that marked as 1A for this?
1A will be states number 40.
Okay.
Oh, it's a separate hearing.
Oh, right. Sorry. 1A will be states 1. It's the motion to... No.
This is the motion to suppress. Yeah.
Yes.
Okay.
Sorry.
Judge?
Yes.
This is kind of the state and I were just kind of talking about this with regard to the admission of the recordings that we just did. Based on the language of the statute, it puts us in a very difficult position. Because by the plain language of 93406, which is clear in its directive, it says no part of the contents and the regular quote in Florida Statute 934.06, it talks about interception of oral communications. It says no part of the contents of such communication and no evidence derived therefrom may be received in evidence in any trial, hearing, or other proceeding in or before any court. So by us putting this in, I don't want to waive anything here is where I'm going.
Okay, you're not. And let me just cut to the chase on that. So this is for me to review the admissibility of it to become evidence. It's not evidence in the sense that this statute is discussing.
Right. It's just,
And I think the record can be very clear you're not waiving that because you're moving to suppress those. So
right. Again, we can't put the toothpaste back in the tube because these recordings have been subject to Chapter 119 requests from day one.
Okay.
So they're already kind of in the atmosphere. But my thought process was, it's still going to be out there.
Unless we seal part of the record that if the court agrees with the defense argument,
right,
let's say I agree with some and I don't agree with some, the ones that I agree with shall be sealed by the clerk of courts.
Right, and that, I guess we can address that at the appropriate time.
Perfect.
Okay. Sorry, I wanted to...
No, that's okay. I mean, listen, it's not a frivolous thing to say or think about, but I feel very strongly that, in the court's gatekeeping function, that I'm not receiving this in evidence in the sense that it would be able to be presented to a jury or even determined by if we would have a bench trial. This is an evidentiary admissibility issue at this point. So
sounds good.
Okay. Mr. Abihoff, do you have any? Yeah, no, I didn't know if you had anything else to say or.
I have no documents, Judge. I just am aware once, so, the defense keeps track of where public records requests come from. We obviously do under Chapter 119.
Yeah.
What happens in court may not protect them absent other orders under, pleading.
That'll be a separate litigation,
1000%.
probably in civil court. Maybe. It could be.
There could be a gag order at some point, Judge, here, but at the same time, they've already been requested it so many times.
Okay, Mr. Pietro, proceed.
Sure, Judge, you have our motion, the amended motion, the state's response, and the defense's reply, which I think both sides kind of lay out the applicable law, so we don't need to beat a dead horse with that. Your Honor, I'm sure has read everything. So we have here at issue the files that were already put on record by the government that they're not agreeing to, 3782, 3794, 3797, 3997, 4001, 4002, 4005. And I will go through them in a group, but also individually. Again, the law, the directive by the legislature is very clear that these recordings, these types of recordings, as contemplated by the legislature, again, may not be received as evidence in any trial, hearing, or other proceeding, in or before any court, grand jury, etc. So it's very clear. And so when we look at the history of the statute itself, going back, it's been amended a few times in the last 20, 30 years. The McCabe case is one of those that I think is very instructive about how the courts, the appellate courts, perceive rulings by the trial courts and what their function is in interpreting statute applying to recordings. In the McCabe case, which was prior to the amendment allowing for recordings of victims of sexual molestation and sexual battery. The McCabe case was a case where the victim, a child victim, I believe she was a teenager at the time of the recordings, in her bedroom recorded her abuser, who made admissions as to committing a sexual battery upon her. Eventually there was the arrest, and the court in McCabe, in the appellate case in McCabe, said the recording, as much as it pains them, that's not the appellate court's language, but they said the statute is very clear that the recording in a bedroom of where this occurred, I can't remember the house and apartment, but this young lady who recorded her abuser in her own room, or maybe it was in his room, but the court said you can't do that. The statute's clear.
Counsel, may I ask you for a second?
Yeah.
Is it McCabe?
I'm sorry,
McCabe. Yeah.
I think I'm developing dyslexia as well. So this was the McDade case. And
It's in the amended motion that was filed. The citation is going to be 154 Southern 3rd 292 Florida Supreme Court 2014.
Thank you, Judge.
Yes, go ahead, Mr.
Right, so in analyzing that, those recordings found to be inadmissible, despite what the court kind of evaluated expectation of privacy and whether society is prepared to recognize type of arguments. In that case, again, absent a directive by the legislature, the court said these recordings, no matter how altruistic the motives may have been, by lower courts wanting to admit these things, the directive is clear, right? The trial courts can't legislate, or even the appellate court can't legislate from their respective benches. So, what happened after McDade? The statute, and I don't know the year, but I know it was amended, and the legislature put in the exception. A victim of the sexual battery or sexual violence can, right, there's an exception for that. So, how does that kind of reasoning apply to what we're arguing here? So, let's just start by, and I would just mention, and it is in my reply, so the state in their response laid out a test. That test is not the law. I think it's instructive, but it is not the law that comes from a federal court opinion that is quoting a dissent. I forget which justice it was, but that was not the majority opinion in that appellate case. But the state goes through their analysis, and I want to just present, Mr. Adhoff's going to have a chance to present the state's position on this. So I'll state our position, their position, and rebut that. So let's, by starting with recording IMG 3782, that is, the state's argument is that there was no reasonable expectation of privacy. They base that argument upon the fact that this occurred in the One Paraiso condominium lobby area, where you could, I believe the video, and just for the record, these are video files, but the video files contain extremely short cuts of actual video. The majority of these are audio, mostly audio. But in 3782, that lobby video, we see, or it appears very clear that Mr. Obumseli had secreted his phone, walked away from Ms. Clenney, turns on his video device, which also captures audio, walks back over to a couch area, and has the phone positioned very, very close to Ms. Clenney. There's no indication that anybody was around them in earshot. You can hear some voices in the background, but again, we don't know how close these individuals were, and whether, and I would submit that the recording itself indicates it starts with Mr. Obumseli lowering his voice, almost in a whisper, to Ms. Clenney. Ms. Clenney lowers her volume in that particular video, and it's clear that they're both trying to keep their voices down. Why? Because they don't want anybody to hear the argument, and that would indicate a clear expectation of privacy, both subjective and objective. So, the state's argument that video, there's no expectation of privacy because it's in a lobby, fails. It's hard to tell from that video, but it's a very large lobby area. It's again, the audio portion of that, and actually the video portion, shows that the phone is exceptionally close to Ms. Clenney, and they both lowered their voices, indicating that they both had an Ms. Clenney would have had an expectation of privacy, as Mr. Obumseli is the only one that knows he's recording, since he walked away to turn his phone on, which is very common for him to do. So, under analysis of the statute and case law, this large lobby area, although it is a common area in the building, the expectation of privacy is clear in that both Mr. Obumseli and Ms. Clenney keep their voices down so as not to allow others to hear their conversation. So, under the statute, it would be admissible as she had a reasonable expectation of privacy in that conversation that she did not know was being recorded. So, second file is IMG 3794. The state concurs that this recording was made in her private residence, but sets forth that, and they get this from the dissenting opinion that they cited from the Federal Middle District that cited it, are not protected because of the nature, intent, manner, or purpose of the communication. The recording itself, there's no, so this is how the day comes into play here when we're looking at what the state's arguing. There's no, because they repeat this on several of the audio video files, that, oh, this is evidence of some type of verbal abuse or physical abuse of domestic violence. Under the intersection of oral communications statute, there's no exception, right, for a domestic, assuming that the state is correct in their assertion that these recordings somehow capture a domestic abuse relationship. There is zero statutory framework allowing for a domestic violence exception like the legislature did in the sexual battery or molestation exception that they incorporated in the statute after McDade. So the state's argument fails. Again, the courts cannot read into the statute things that are not, the legislature has not put in there. So, under a strict reading, which is what the court needs to do, of the 93406, the second recording, which is, again, 3794, when Your Honor's already looked at these, so it's abundantly clear in all of these, albeit one, the one in Colorado, we'll get to that these are all surreptitiously made. For all these recordings, the phone, you can see it's either in a pocket or in a hoodie or it's being hidden when it's being turned on. There's no question, and I don't think the state even argues this, but there's no question that these recordings were made without Ms. Clenney's knowledge. So, under the statute, the second recording, 3794, this is exactly what the statute's meant to not be admissible or even in any court hearings admitted into evidence. This is 3794 is an argument between two persons dating each other in a private home that is being secretly recorded by one of the other parties, which is illegal. It's a felony. So, IMG 3797, the state's argument is that, hey, this one took place, and again, I don't think it's clear from the audio and the video. I think you hear in the background there's a noise it sounds like a slider or a sliding glass door. I don't think it's clear, but for purposes of this argument, I think that the state's position that this occurred on the balcony is probably correct. But again, just because it took place on a private balcony, in a private apartment, in a private residential building that was quite honestly was a very exclusive type building.
Mr. Prieto, can I ask a factual question that I don't think maybe I should know this, but the way that the building is configured, some apartment buildings or hotels or whatever have a balcony where the next door neighbor, you could be like, hey, and you could see the person and they're very close to each other. What is the configuration of this building?
Judge, we went on inspections with this on this property in the civil proceedings. It is very private. You cannot see your neighbors
from the balcony.
From the balcony. It is walled off.
You'll have a chance to dispute it.
Just for this clarification,
okay.
So there's a barrier between every apartment.
Okay.
That barrier does not go all the way past the glass and does not go further than 4.5 to 5 feet. If someone who's standing over 6 feet tall, their eyes are going to look onto it. When it comes to her angle, she's on the corner unit. So if we're facing south on the corner side, there is no other balcony on that side, on that part of the building. Okay. On the east side is where this could happen. where there could be new neighbors, but that's for that.
Okay, go ahead, thank you.
Yeah, so I know I have floor plans, but again, you can't. If somebody's on a floor above or below, is there an opportunity for them to eavesdrop? Probably, but again, additional facts that people have about where or when this occurred. The private balcony area of a private residence in a private building, I believe, expectation of privacy on the part of Ms. Clenney. And again, this is an argument between two persons, boyfriend and girlfriend, one of which has. We don't know what happened before the recording started. All we know is that Mr. Obumseli secreted his phone on his person, or in some of these held it, but did not display that it was being recorded to Ms. Clenney. Again, these are secret recordings made in an area, in a private residence, albeit a balcony. It appears to be a balcony. Because you can hear some outside noise. But again, this is somewhere where an argument between a couple should be protected, and Ms. Clenney had a reasonable expectation of privacy. So the next one we can kind of group together. This is IMG 3997, 4001, 4002, and 4005. Again, I don't believe it is disputed by the state that these were all recordings made in the apartment, Ms. Clenney's apartment, in her residence, and the only people present were Courtney and Mr. Obumseli. These are, again, arguments, and again, these are not anyone's best moments when they're having arguments with a significant other, which is exactly why these are the types of communications that should be protected. When people are arguing, it is definitely not them in the best light, especially if there's alcohol or other substances involved. But the state, in arguing that 3997, 4001, 4002, and 4005 come in, is because somehow the society is not in a position to recognize these conversations as private, which is nonsense. These are, again, secret recordings made by one party without the knowledge of the other. These are arguments arguments taking place in a private apartment, in a private building, in a private setting. There is no such thing as a domestic, and the court likes to, the state wants to say these are the evidence that she's a primary abuser. But again, there is zero support, whether by case law or by statute or by analogy, that somehow these arguments are not subject to inadmissibility based on the statute. A plain reading of the statute, again, these are exactly the types of recordings that should not be made. So there's some case law that the state cited which talks about, there was a recording in an office where the person being recorded was trying to extort, I forget the exact nature of their relationship, but in that case, right, the court looks at whether the criminal conduct that was being recorded was an extortion, and anyway, these were business settings in business offices. The other exceptions were, I think, like a checkout counter. Some of the case law talked about a checkout counter that somebody was overheard speaking. These were recordings that took place in the apartment between two individuals, one of which had no idea she was being recorded. So again, absent some legislative directive, the court has no other option but to rule that these rulings are not admissible for any proceedings. Again, I know since this court, the court was other proceedings that we've had, and I can't remember if at our relitigating bond issue whether or not we introduced evidences. I can proffer to the court, and Mr. Adloff can disagree with me if he'd like, but this is a very private building. The only access, and this goes to the state saying in their response, hey, we have a recording of a security guard at the door of Ms. Clenney's residence that was able to hear what they were saying. So clearly, if the security guard could hear them, and she's screaming, she's got no reasonable expectation of privacy. Well, that's just nonsense. This building was very private. There was one key fob. Well, not one key fob, but there was in order to get to Ms. Clenney's apartment, you have to have a key fob that works for that particular unit. Not that floor. As soon as you come out of that elevator, you are in Ms. Clenney's foyer. There's no entrance to a neighbor. When you're coming out of the elevator to the right, there was a door that led to the outside, several feet away, that led out to an area where I believe there was an emergency stairwell and an area where they could put refuse out to the right. But you have to go through another locked door, of which no other residents have access to that door that goes into your foyer. To the left is the front door of the residence that could be locked. So you could basically get off the elevator and not have access to the apartment if that door was also locked. But it was obvious that they left it open. But the only people that can access that floor are either if Ms. Clenney or Mr. Obumseli gave somebody the fob to get into their apartment, or if it was a building staff member. And nobody, if they're having an argument, nobody's going to expect that either security or one of the other people is at their door. So these arguments that the state, not the arguments between Ms. Clenney and her boyfriend, but the state's argument that, oh, just because Asian was able to hear that through the door eviscerates her expectation of privacy, that's just nonsense. This is a very private building. Again, private arguments taking place in a private apartment where Ms. Clenney had in her home a clear expectation of privacy. So this is not like, a ghetto apartment that I live in where I can hear my neighbors through the paper door, through the paper walls. I've got 25 apartments per floor. You open up an elevator and, hey, good morning, how's everybody doing? No, this is a very private area, which is why a lot of people want to live there because of the privacy. Or privacy, as some would say from across the pond. So, again, all the factors that the state goes through, which they get from the dissenting opinion quoted by that federal case, those factors are instructed for this court. However, the clear language of the statute controls. There's no judicially created exceptions to the statute, which is what the state is asking Your Honor to do. Create some type of, as they term it, some primary domestic aggressor exception to the interception of her oral communications. Simply not supported by the law or the facts of this case. Thank you.
Thank you, Mr. Friedman. Mr. Adhoff?
Thank you, Judge. So the defense talks about us citing to a number of factors in a dissenting opinion. That opinion cites to Brugman, D.C. 117, Southern 3rd, 39, Florida 3rd, D.C. 2013, which also cites to in carry on. Cited 1272, 1985 for the Supreme Court. Case in Jatar, Leto, 7. Why are those cases different than the date?
There is no screening, there is no actions that someone not within that residence would have been able to hear what was going on in that room. Being that it was his residence, he already has a subjective expectation of privacy for midday. That's different than here. And going by each one, 3782, which is in that lobby, there is no expectation of privacy subjectively in the lobby, whether you're whispering or not. That is very, very specific and very different from midday. And so 3782 is the easiest one to discuss here because it is in a public place where every case cites to that you do not have a subjective expectation, let alone an objective expectation. 3794 is now I'm not mixing them up, Judge, and I do apologize. So
In the residence, I believe.
3782. 3782 is in the lobby.
Yeah.
3794 is the one that's upstairs. The first one happens upstairs.
Right.
So 3782 is the one I was just discussing.
Right.
The rest of them being 3794, 3797, 3997, 4001, 4002, 4005. We can see it's in the apartment. There's a subjective expectation of privacy just being that it is her residence. But that's why the content and her actions have to be evaluated. The only ones out of all of those that she is not screaming is 3794. And that alone, the content and the actions of it, where the victim is asking for assistance and that he's bleeding from his head, where she responds, I know the fucking shit on your head is serious, I really want to fucking kill you. That lacks the objective expectation of privacy. But that is the only recording that is close in time to McDade. The only one where you don't have some person outside of their apartment that's going to be able to hear the actions. And that's why the state provided to this court that recording from security. Because you get an understanding of from outside that apartment what you can hear, let alone the noise complaints that were continuous from Ms. Clenney, where all of them are explained as we're hearing screaming coming from that apartment. And that's 3797, 3997, 4001, 4002, 4005. Not only is the content, it would eliminate an objective or a objective and probably subjective expectation of privacy, but we get to this point where there is no, you're almost waiving your subjective expectation of privacy when you're screaming to where anybody can hear it. And we had complaints from reports that were filed with this court, at least 2 floors down, that are saying, hey, this is what we're hearing, someone needs to go up there. The security guards are not just showing up to her door just because. They're going because they're receiving these complaints on numerous occasions. So when we talk about McDade, at best, to the defense argument, may apply to 3794. I would still say that it does not. But it doesn't come close to 3797, 3997, 4001, 4002, and 4005 because of her actions specifically. She is specifically waiving that by letting the entire world know what's going on with their business. So that's the difference here. And it comes down to, I don't need to talk to the court much longer than this. The first one's in, and that's 3782, is in the lobby. No expectation of privacy, subjective or objective. The rest of them, there's a subjective expectation of privacy. She certainly waived it in 3797 and below. 3794 is up for debate, and that's really it.
What is your argument with reference to 3794?
The argument would be that when someone is coming to you to seek assistance, the fact that he's seeking help, asking for help, and her content is threatening in that way, it is to say that she is, it's the content. It's really just the content of it. That's the only argument I can make to that.
Okay. Mr. Prieto?
Yeah, Judge, the state's talking about complaints made by neighbors saying they're screaming, or that definitely occurred, right? There were complaints, noise complaints. But there was no noise complaint saying, hey, I hear Courtney Clenney saying blah, 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 X, Y, and Z. No, these are noise complaints saying, hey, I hear people arguing. That's very different from saying, I hear people arguing and hearing their exact words. Again, just raising your voice in a private apartment, in a private setting, during an argument with a significant other in that private residence does not waive, as the state would say, any reasonable expectation of privacy.
But if the court is looking at this from an objective perspective, and there are facts to suggest that people could, in fact, physically hear screaming out of this location. We've already determined, and everybody concedes, there's a subjective expectation of privacy. If it is a fact that screaming can physically be heard, and if Miss Clenney is screaming, that at that point she is waiving that expectation of privacy objectively. That if I start screaming here in the courtroom, I can't expect that the words that I'm saying might not be heard out in the hallway, and especially if Judge De La O comes out and says, you know, I can hear everything you're saying in the courtroom. So talk to me about that piece.
Judge, objectively, Ms. Clenney's not waiving anything by raising her voice. Again, this is within the four walls of her condominium where people complain of noise, but not, that doesn't mean that they can hear if the person speaking is waiving the content of their communication. The only thing that's making it through these walls of people that are complaining is a noise, a level of a decibel level of something, not the form and substance of the communication. And there's absolutely zero evidence, both in the recordings, that these particular recordings on these particular dates were overheard by anyone. By anyone. The recording that the state provided to the court of Miss, forget her name, the one of the security guards that had to go up to the door, place her phone up on the door, and she testified to this in the civil deposition. But she had to go in there and basically put her ear up or the phone up to the door. So, and that is not a recording that the state is seeking to introduce, like all the ones that are listed here and subject to this hearing. There's absolutely no evidence before this court that anybody overheard these recordings that the state is seeking to introduce. There's no question that these were surreptitiously made, so that the state has to concede those. But as far as somebody raising their voice in an apartment to make the leap that eliminates any expectation objectively, any expectation of the contents of their communication is just not right. Just because you can hear somebody maybe screaming doesn't mean that you, as a person who may be raising your voice, is waiving the actual form and substance of that communication. There's no case law to support that. But again, there's absolutely nothing before the court that says anybody overheard these conversations. There was any way anybody did hear them or not. So, but the state's saying, well, because somebody overheard them once, that forever, by raising your voice, you have objectively waived any reasonable expectation of privacy. That's like saying, if the police execute, it's all wrong. Let me try to, probably shouldn't come up with things on the fly, but I'm going to say this. Well, actually, I think this is in the state's original response, saying, well, Miss Clenney, if she knew that Obumseli was recording him once, then she should expect that he's always recording him. And so she has no expectation of privacy. That's a nonsense argument. That's what the state's trying to argue. That's like saying, if the police come and serve a warrant at your house, and the warrant was bad, well, you should know the cops could break your door down anytime after, so you have no expectation of privacy in your residence just because they did it before. So that argument that she knew Obumseli would record her on occasion, that's not a waiver. Just like it's not a waiver to raise your voice, again, and specifically these recordings, there's absolutely zero evidence that anybody heard the communication, right? The statute is interception of an oral communication or wire communication. That doesn't say, well, hearing a noise is that communication. The communication is the words, the message of the words, not, oh, I heard somebody arguing. So there's no waiver, objective or waiver of subjective privacy in this case.
Mr. Abiel, you look like you may want to respond. Okay, go ahead.
First off, Judge, we are seeking to have that recorded by the security guard, and that's just not part of their motion. They're not seeking to exclude that. So, yes, there are a number of recordings that we will seek to introduce. I'm not sure where McDade's defense believes that this idea of what they're saying is a law is a law. That's not what McDade says. McDade specifically lays out any oral communication uttered by a person exhibiting an expectation of privacy under the circumstances reasonably justifying such an expectation. That is the state of the law. It's not this, if you can make out every word that they're saying, that applies. That's not what the law is. So I get it. That's the best form for them to push forward their argument, but that's not the state of the law. And you can hear from that security guard that not only, from right there off the elevator, you can hear the exact parts of these conversations, but when you look at the complaints that are part of this file, and we provided the court with complaints from before. There are multiple complaints after this as well. And they go on until they actually get an eviction notice, and they're about to be evicted. So, there's a number of instances that puts her on notice that she is certainly screaming, and they've spoken to them on numerous occasions that everyone around their floor can hear this, to where there's we provide the court with 6 of them, up to a certain date, there's at least 10, if not more, of complaints saying that we're hearing muffling, we're hearing a very specific argument where a woman is screaming. And that's the point of it. So my argument to the defense statements, they're misstating the law of McDade, they're misstating the law of this, what this court is required to follow. And because of her actions, of how she's addressing these conversations, she is waiving her objective expectation of privacy.
Mr. Pietro, did you have anything else to say?
Judge, I would just say the case law that both the state and defense have cited to, where the courts have found a waiver, objective or subjective, may be are very fact specific. I would just encourage the court to read those again, because they are very specific of where they're finding either a waiver or some type of non-objective or a waiver of reasonable subjective expectation pricing. They're a lot different than here. These were arguments in the apartment. I don't want to beat that horse here, but again, raising your voice does not vitiate your expectation of privacy in your own home. And that's what we have here.
I'm just reviewing a few cases that I may have a question. Appreciate, based upon the court's review of the record, the pleadings that were filed by both sides, and I appreciate, probably say this a lot to you all because of the level of preparation, and of course it's
substantial, so I appreciate that very much. As to the defendant's amended motion to suppress illegal recordings pursuant to Florida Statute 934.03 and Florida Statute 934.06, the court rules as follows. The motion is respectfully denied as to 3782, which took place in the lobby, and 3793 that took place on the balcony, but granted as to 3794 and 3997 through 4005. The court finds that that Ms. Clenney did not waive her expectation of privacy, as the communication that originates within the home, of course, is significant, and the actual interception of the communication occurs where it originates, not where it is ultimately heard or recorded, as well as the fact that the record is devoid of any evidence to suggest that the actual communications at issue here were, in fact, overheard. Not to say that that would necessarily sway the argument or the ruling of the court, but I don't have that here. Now, the other motion, and I know we weren't planning to do this today, was the motion in limine on the CGI, but it sounded like there were some things that you were going to do and give the court, and where are we on that?
Yeah, Judge, I think it's premature to really address that. There's, let me just say, there's, at this stage, some contractual issues that need to be worked out.
Okay.
Concerning that, perhaps Ms. Puglisi.
I don't need to necessarily be briefed entirely on that. I just wanted to know if that was something that you were ready to do soon.
Well, we wanted to talk to the court about it, and haven't done this in so long, so I'm not sure for cause.
Okay.
We want to see if this claim could be declared as indigent for cause. She doesn't have the funds to be able to proceed in the way we do. So I'm not sure how that occurs, if by motion, if we can have her fill out a financial affidavit, or if the court can ask her questions. I haven't done it in a while, so maybe incorrect.
I think it would be appropriate to file a motion along with the indigency affidavit, and then the court will rule accordingly. It's not really, I don't really think the state has much of a dog in that fight, that we would need to necessarily litigate it in open court.
To be fair, and Jack needs to be noticed and copied on that.
Yeah.
Do we have any indigency forms here?
Yes.
Fill out now.
Darlene has that.
Just for clarification.
Yes.
I believe your Honor said 3793 for the balcony. I believe that's 3797.
If I said, I apologize, my notes reflect 3797 was the balcony.
Right.
And thank you for clarifying. Okay, so 3782 and 3797 are in. 3794 and 3997 through 4005 are out.
And just so the defense is clear on their position, we understand the court's ruling as far as admissibility in 934.03 and 06. We will reserve our right to challenge under 403 or other grounds at a later time prior to trial. For the ones that you've said are not violated for 934.
Understood. I think just what's pending is the 404, which we have some depositions and things to take before we file a response to it. And then that also, we're working on the reverse rule. And so there are a few things that we have to do. So I'm not sure if you want to set status before the trial, or how we want to do.
Oh yeah, for sure. 30 days? The trial is roughly in 60 days, or the sounding, that is, yeah. Okay, so that puts us at 320 for the next status. I'm going to put it as status for now. If you want Ms. Clenney to be brought to court, just let us know the day before. Okay, anything else from the state?
No, Judge.
Defense?
No.
All right, thank you all for running today.
Thank you for your time.
All right, so some of the recordings are in, some of them are out. So the ones that she allowed in was apparently the lobby and then the balcony. She allowed those two to be in. I don't know if we'll see those. I hope we do. I hope on Monday we'll see some some testimony, some evidence will be presented. Definitely victim impact statements.
Good morning, Mr. Patrick.
So, all right. So this is this one is from March 22nd. All right. So this is just a couple months ago, March 22nd. Then I have one more after this from April. All right. So this is March hearing. Let's see. March 22nd, 2026. Yeah, I don't know if it's going to be, I don't know if it's going to be as long as Colt Gray, where he was, 2 days or 3 days? 3 days. It was 3 days, right? 2.5 days, 3 days. I don't know if it's going to be that long or if it's just going to be a 1 day. It depends. I guess it all depends. It all depends. Court has to accept her plea. She wants to plea. She wants to enter a plea. She has accepted the state's plea. Now it's up to the judge to accept the plea. Chances are they will, only because the family is okay with this. The state is okay with this. I can't imagine the judge saying, nope, I'm not going to agree with this. I'm going to, toss it out. All right. So this will be interesting. Where do I put myself? I'm going to put myself maybe over here. Twink. I'm going to put myself right in the middle. Let's see where that goes. All right, so this is from March 22nd. I may move myself around.
Good morning, Your Honor. We're on page 11. It's under Courtney Clenney, but I'm here on behalf of him and Deborah Clenney, who are present on the platform. Ms. Sabrina Puglisi, who does represent Courtney Clenney on the...
Yes, but Sean Abu on behalf of the state.
Good morning, everyone.
So, Your Honor, we're here on the petitioner Kim and Deborah Clenney's motion for a protective order. Just point out housekeeping for the procedural matters. We had previously moved to intervene on the same issue. Judge Cruz had ruled against us. We took an appeal of that order. Judge Cruz's order was affirmed, PCA. The mandate was returned on Wednesday, so Your Honor is vested again with jurisdiction to address this current motion. We're seeking essentially what would be a similar remedy, but now under the rules of criminal procedure, which is 3.220 LNM. And specifically, and I know Your Honor read the motion and is pretty familiar with this. And one of the issues, or really the main issue, was that the original warrant issued for the iClouds of Courtney Clenney, Kim Clenney, and Deborah Clenney, in our argument, invaded Kim and Deborah Clenney's privacy right under Article 1, Section 23 of the Florida State Constitution. But under the rules of criminal procedure, Judge, essentially this is just all sensitive material that should not be disclosed to the state. Our issue has been not simply the breadth of the warrant. Specifically, Judge, the warrant allows the state to go through Kim and Deborah Clenney's iCloud data from November of 2020 to present is what's in the warrant, but that was November of 2023. So a 3-year period wherein the issue, the subject criminal offense, Courtney Clenney's homicide charge, occurred April 3rd of 2022. So we've asked the state to narrow or at least advise what exactly they are looking for and why they believe there would be evidence of a second-degree homicide 2 years prior or 2 years after on the iCloud data of the defendant's parents who weren't even in the state at the time it occurred. By the state's own theory of prosecution, this was a heat-of-the-moment incident that occurred and resulted in the death of Mr. Obumseli. So what we're asking for, Your Honor, is to restrict the disclosure to the state entirely, because I don't believe that they have sufficiently established grounds to invade Kim and Deborah Clenney's privacy to this degree. I understand and we can see that the state has an interest in prosecuting criminal offenses and has, pretty wide authority to do so and many tools at their disposal, such as a search warrant. But but that's not unchecked. I'll also remind the court, and I think Your Honor knows, so the warrant at issue, this court has jurisdiction over, but also coincidentally, Your Honor signed the renewal warrant. Originally went in front of Judge Cabarga. She executed it. It was presented to Your Honor that had gone stale and you needed to re-sign it. So I think Your Honor also has wide discretion to act sua sponte on limiting that warrant now because you still have jurisdiction over it. Either way, what we're seeking is to prevent the state from invading our client's privacy. The court does have a secondary remedy available to it, which is to review the materials in camera and determine what, if anything, may be relevant and is worthy of being disclosed to the state. And the last point, Judge, is when the state sought this search warrant, the reason being that they could not access the defendant Courtney Clenney's iCloud or phone. They had requested the password. That was declined by Ms. Clenney's counsel. That issue has now since been remedied. So there's really no reason whatsoever for the state to have access to the defendant's parents' very private data.
Mr. Aguilar?
Yes, Judge. And before I begin, may I just request from the defense the items specifically that they believe would be protected under some privacy interests?
Well, Judge, we're talking about iCloud data. So I think that's been well established in Riley v. California that the data that we keep on our phones and our personal computers and now in a cloud storage, we're talking about medical records, financial records, spousal communications. It's a digital vault that they are traipsing through.
And the accounts that are at issue, I'm assuming, are the KDC ones and the DEB.
Correct.
Right. The CTC is Ms. Clem.
Yes. Right. And just in response again to Mr. Abuhoff, it's not this private citizen with a privacy interest job to tell you this is what I don't want you looking at. It's the state's burden to say, I need to look at this because it is relevant to this prosecution.
Mr. Aguilar.
So, Judge, the issue here, and I will agree with the defense that they have standing under these specific statutes solely for the purpose to limit that disclosure. A lot of the case law that comes about happens once it's already in the state's possession, and the third-party public record request comes about for these items in that disclosure. I don't want to necessarily go that far, but where we are here is this is a search warrant that this court signed that issued and agreed that there was probable cause for this, for the obtaining to attempt to locate items relevant to this investigation. So at this time, that standing that the defense may have to limit possible disclosure does not call into question, cannot call into question because they don't have standing to challenge the warrant itself. If they were granted the ability to intervene, we're in a different ballgame. That's not where we are. So they're talking now about what already exists and limiting its disclosure. Now that it's already there and it's already what would be in the state's possession, we're in a world where they're limiting, I believe their sole ability is to limit its disclosure to the public. So first off, when it comes...
I do not agree with that, Judge. I don't read the rule. I think it is far more broad than that. And it's important to note, Your Honor, that the decedent, Mr. Obumseli, his counsel filed a similar motion for materials related to Mr. Obumseli. So
I think that's also irrelevant to this argument per se, because whether or not it was granted a defense and the state were in agreement to limit some of the more sexually explicit conversations or things that the court deemed were obtained illegally, that's what the purpose of that protective order was. But that being said, Judge, if you look at the rule itself, outside of the first sentence, all of it talks about depositions and limiting what would come about. For this is Section L. When it comes to the disclosure, the state can be limited in asking these questions for a witness to have to answer these questions. None of it pertains to items that are already in the possession of the state itself. These items itself, the court took possession of it after the fact and held on to it for the purpose of the appeal and whether or not they could intervene. And I believe the court's intention then was, okay, if they could intervene, we could talk about the breadth of this warrant they would have standing to. Now they don't. That the third DCA, the court said they did not. The third DCA approved and affirmed that they did not. And so what we're here now is talking about items that are already effectively in the state's possession, although the court has it. And now the question would be limiting it and basically its use in trial or disclosure to third parties. So where we are here, and when it comes to this item, these items, when the defense talks about financial records, that's very relevant to this case in and of itself. When it comes to Kim Clenney's financial records, it was clear in the Arthur hearing that Ms. Clenney, the defendant, sent all of her money to the defendant in the months leading after, even 1 or 2 months leading or preceding the murder itself. So we do have an interest in obtaining these items, finding the value within that, and seeing how it fits into our case for actions taken after the facts, as well as communications with Deborah Clenney that happened in the moment of this murder and homicide. So
that I get, but what we're talking about 18 months prior to the homicide itself.
Right. So, and Judge, the issue comes is that all of these, I understand Your Honor is separating each account, and rightfully so. But when it comes down to it, all of them share one iCloud account. So when we do a return for this iCloud, all of this comes, and you can now attribute to each person their separate phone numbers. So they share. That's the first part of that. The second part is that what Your Honor has just done is what the defense would like is to attack the warrant for being overbroad, for calling into question the amount of time in which we are being able to look at certain information. And they don't have standing to do that. And that's the problem here, is that they can't question what Your Honor found probable cause for in our investigation in trying to obtain certain information. That's why, they do have standing to question what could be turned over, or in a deposition of Deborah or Kim Clenney, what could be asked. But when it comes to what's already in the state's possession that Your Honor found probable cause, they can't question that and they can't challenge that.
So they being the Clenneys. So in other words,
not the Clenneys, Kim and Deborah.
Right, that's what I mean. Not
yes.
Courtney.
Right. I can address that as well, Your Honor.
Okay, so let me just make sure. Were you finished, Mr. Agarhoff, or? So in your argument, if the motion to intervene had been granted, then we would rightly be in this discussion that we're having. But because it wasn't, and it was affirmed on appeal, it's as simple as a threshold standing issue.
Correct. That's not correct.
Okay.
Because standing would say whether or not they could even bring this motion altogether. The rules allow for them because they do have a privacy interest in the records themselves, but the question the answer is the state has a competing interest in still reviewing and obtaining and ascertaining value to some of these items.
If I were to say that the privacy interests of Mr. Kim and Deborah Clenney outweighs the state's interest in prosecuting this case, what type of limitation would be appropriate?
What I would say, Judge, would be that Your Honor, prior to any sort of public record request for these items, and this is obviously a very media-driven case where there's a lot of attention to it. Anytime that a public record request is done or requested for specifically these iCloud returns, that it could come before the court and we could be able to ascertain in camera or even just off record of, hey, these are the items that you are not allowed to turn over to the public, because that's where their public or their privacy interest now trumps the investigation, or I'm not finding the value. State, explain to me now why the public needs to, or you should have been able to ascertain or obtain these items.
So your position in that regard is this is not right?
To be fair, Your Honor, I've never seen the returns. I've never seen what's on these returns, and my involvement in this case when the returns came back, it was not as a first chair prosecutor. So I would love to say, Judge, this is everything that's on. But I'm not allowed to have communication with who was previously the first chair.
Right.
So I would say yes, but legally speaking, it could be right.
Okay.
Because in theory, there are people in our office that would have that information, just not any that we could discuss further.
What I mean by right is that the actual public record request has not heard yet in this regard.
In that regard, then yes.
Maybe it has. Obviously, I don't know the answer to that.
If there are any public record requests for the iCloud warrant, we have not been able to answer to them because they've been in possession of them.
Okay.
So let me just address the issue of the public records request, because I think that's a red herring.
It might be, because it's separate and apart from discovery.
I agree, Judge. And I also need to point out that we're discussing a privacy interest. So for my clients, the state going through their private data is the same invasion as if it was requested. It's somebody who should not be looking at what is private and being allowed to do so. I also want to address, Mr. Abuoff talked about under subsection L of the rule we cited to and said notwithstanding the first sentence, but the first sentence is particularly important because it is what gives us this standing on a showing it could cause the court shall at any time order specified disclosures be restricted, which is what we're asking happen today. Judge, it's also important to note on the issue of the motion to intervene, and this is particularly problematic because I don't think even the state is arguing that my clients don't have an interest in their own data. The third gave us no opinion, so I'm not gonna, speculate as to what they think, but they did deny the motion to intervene, which puts us in a very interesting position because the state has sought very private data over a long period of time of two people who just happen to be related to a criminal defendant. And now is essentially arguing that we don't have any remedy before Your Honor. And that is a really, really steep and slippery slope for us to be on because that subjects everybody who may know someone prosecuted by this state attorney's office to have their very private data reviewed. It's also, Judge, essentially a moot point because they have Courtney Clenney's data on the other side. So anything related to her, who is the defendant they are prosecuting, that may involve my clients, they have it through that back door. So there's no reason for them to be looking to private citizens' very private data on the other side of it. So, and again, I've yet to hear in all of the arguments, what are we looking for? With regard to the financial issue, that
sounded to me like if it went more toward the motions that not you, but that Ms. Puglisi and Mr. Praetor raised with respect to her release.
Say that again.
Well, financial records and whether or not money has been provided with money for her to flee the jurisdiction.
It's a very interesting. Yes, Judge, because Mr. Clenney did testify at the Arthur hearing. Mr. Abuoff's predecessor, who was removed from the case, put in one of his response pleadings that the warrant was sought for this information for exactly that reason, because they believed this was a movement of money, which was indicative of flight. The warrant was sought after the pretrial detention order was entered. So that's just a disingenuous argument to make. The idea that transfer of money for somebody who's now been in custody going on 4 years was not just a sound financial decision. It does not establish anything related to the elements of a second-degree homicide. And there's no issue of flight because she is detained. So that argument, I don't think has much merit, Your Honor.
Can I ask, if I agree in part with your argument, what limitation would you suggest? I realize for the record that you're objecting to everything and this, in its entirety, but I think that some of this could be.
Sure. We offered in the initial motion to allow for a limited release of the phone calls or communications between Deborah Clenney and Courtney within the time period of the homicide. I can even concede that that would be relevant and important to the state's investigation, but to have 3 years of private data for a very limited window of time, I don't see the state offering the court anything compelling. As far as our standing to challenge the warrant, I'll concede that point that Mr. Abuoff made, but that does not prevent the court having reviewed the warrant, from acting sua sponte with your jurisdiction over it, to limit it and say, okay, well, what are you looking for, state? Give me more specifics.
What is the earliest date of, because my notes are in my office, the earliest date of some of the interactions that we litigated, I don't know, a month ago or whatever, prior to the homicide?
So, and Judge, that's the problem. We turned over for the Arthur hearing. There's the specific incident between Ms. Clenney and her parents when she's about, and I'm guessing right now it's either 12 or 14. It's sometime in that range. So that's many years before. And this idea of...
Yeah, I don't care about that. I'm talking about...
I understand, Judge.
Defendant and the alleged rape.
And I understand that. So their relationship is about 3 years, or about just under 3 years prior to the murder. It's on and off. There's multiple conversations, but that's the problem here is I believe that date coincides with when that relationship began. And it's seeking, and a lot of the conversations and knowledge of the Clenneys, they were quite aware of what was taking place between their daughter and Mr. Obumseli, to the point where the week before the homicide, Deborah Clenney is coming to the apartment to now address any sort of issues as to what is going on between them. So there's knowledge between the parents and their daughter and their daughter's relationship. And I believe that is why the date was what it was. I wish I could give Your Honor more information as to that, but that is, at least it coincides with when we believe his relationship with her began.
So, Your Honor, I'll allow Ms. Puglisi to make the relevancy objection to all of that when it's appropriate.
Yeah.
I mean, that's a bridge too far.
I know. I just was trying to get a sense of, because I signed this 3 years ago or something.
Yes, ma'am.
So I obviously can't recall what was in my mind or anything at the time. So
And I'm sorry.
It does seem overbroad.
I apologize, Your Honor, for interrupting. But the question of whether it's relevant doesn't necessarily mean that it's overbroad. You know, the idea is their relationship starts at a certain date. It is certainly relevant. The question of whether or not it's relevant to the trial and whether Your Honor will allow us to go into it as to some Williams rule component, that's separate and apart from PC relevant in this case. And I believe that's why, although Your Honor now is looking back and saying it might be overbroad, it's relevant to their relationship. And so it's not a fishing expedition for things. It's seeking information of knowledge between very pertinent and important witnesses, especially Deborah Clenney, who is on the phone at the time of the homicide and even potentially after the homicide, or at least we know for sure after the homicide, and Kim Clenney, who's on the phone, or not on the phone, but in discussions with their daughter, moving her out after the homicide and financial actions after the homicide, but also their communications beforehand with their daughter.
Harkening back to what I said a few moments ago, in that I do believe that to some extent, Mr. and Mrs. Clenney's privacy interests outweigh the state's interest in prosecuting the case. If I were to grant the protective order from November of 2021 to 2023, April of 2021 to November of 2023, how would that harm the state's ability to prosecute this case? And that would call into question the fact that I do believe to some extent that their privacy interests outweigh the prosecution.
So the problem here, Judge, is that when defense comes here and asks for the entirety of these ICBOs, the problem is that there are specific items that would be relevant. So Deborah and Kim could be Williams rule witnesses. I won't know until I get to review these ICBO warrants, which have been in the court's possession for the last couple of years. Right now, we have a pending Williams rule motion, but we can only litigate it so much so until we figure out their knowledge and their witnesses to what exactly. I don't know. So the date range that Your Honor is suggesting, I believe that you're cutting the state out by its legs when it doesn't necessarily have to. At the end of the day, the protection, the privacy interests that they are seeking, I think is covered by limiting who is able to see it after. So if the public cannot receive it, And the question is still, it may be relevant to prosecution and what the state may be able to use.
But how are we 4 years in and you don't know the answer to that question?
Because Your Honor has had the iCloud warrants or the returns for the last 2.5, 3 years. The only person who reviewed those prior to is no longer on this case, and I can't speak to him.
So Judge, the point Mr. Abelov just made is very telling. They may be Williams Rule witnesses, but we don't know. So we want to go fishing through their data to maybe explore a 404 motion. That's putting the cart before the horse. The state needs to have some reasonable belief that these witnesses have relevant information, so much so that they're going to be allowed to be called separate and apart from the facts of the trial and put up as Williams Rule witnesses. But the answer keeps coming back. What are you looking for? I don't know because I haven't looked yet.
That's not my understanding.
Well, you don't know because well, partially, but you can't speak to the other prosecutor as well.
So, and this is the problem, Judge. So, we specifically were looking for communications, financial data. They can't be separated out. When iCloud receives these warrants, they're not picking and choosing. They're not the ones who go and say, hey, here's exactly what you requested. They are taking the entirety of it. They're sending it to us. At that point, we end up sending it over to the defense, and the proper way of handling this is having a taint team be able to review it. And, hey, defense, we're not looking at it. It's in possession of the taint team. Tell us what you believe is something that should be excised out of it, which can still be done here because anyone who does have knowledge of this is not on this case anymore. So what can be done, what should be done is this is given to the taint team that the court has approved.
Which now can happen since the appeal has come back.
Correct. And so now that these items are here, they can be taken by the taint team. The defense who received copies of this at the time that they came in and part of discovery should be able already to know what's on this rather than the state, because anybody who had knowledge does not. If there's anything that they want excised off, then they should be able to bring that to the taint team that they can take it off. If there's a question truly of, does the state have a competing interest in this, then we bring it to the court and say, Judge, we're not in agreement. But it's something that should be taken off, outside the presence of the court. We can handle this together in theory until we can't. That's why it's not. The defense should be able to lay out exactly, even broadly, to the taint team, hey, all of these items should be taken off. We should be able to say, hey, we're in agreement completely. And then it's not an issue. If there's an issue, now we bring it to the court, and Your Honor can now look at it and make sure.
Are we premature?
No, not at all, Judge, because the state's conflating an issue here. The taint team is applicable to Mr. Puglisi and Mr. Prieto as the defense. I'm not the defense here, Judge. I am protecting my client's privacy interests, which frankly applies when members of the government, the state attorney's office, is reviewing their private data. It's a constitutional amendment in Florida's Constitution that creates a robust privacy interest. That argument pertains to whether privileged communications will be reviewed and is more applicable to Courtney Clenney and her defense team. Our position is, you're the government. You don't get to look through private citizens' data just on a hunch because you think there may be something in there. And that's why we argued the warrant was overly broad. They didn't identify anything that they're really looking for and still cannot tell this court. And this is probably the 4th or 5th hearing we've had. Nobody's been able to say exactly what they're looking for. So we're just going to open up a digital vault and let them peruse it at their leisure and look through very private material while trying to find something that may be relevant that they don't even know if it exists.
What is your position as to a possible limitation that I suggested previously?
So I think that's actually a fair compromise, Your Honor, but I would suggest this. I think the date would be limited from April of 2021 to when Ms. Courtney Clenney went into custody, because their argument was that they want these communications. Any communication she had with her parents while in jail, they have ready access to through jail calls. So I think if we limit it to around the time of the homicide to when she's taken into custody, the state's interest is preserved. It respects the very robust privacy interests of my clients, and hopefully this case can proceed to trial as scheduled. April 2022, thank you.
Judge, specifically to that April 2022 date, now that cuts out anything beforehand. So you're eliminating any sort of Williams rule information that these parents may have.
All right, the motion for protective order as to April 1st of 2021 to August 26th of 2022 is granted.
Thank you, Your Honor. I'll draw a motion. Oh, wait. It's April 2022, Your Honor, is when the homicide occurred.
That's not what my order is. It's 2021. I'm allowing it the year before.
And Judge, forgive me, but let me inquire of the court, if you don't mind, what's the rationale for the year prior?
The continued, well, you know what, now that you say it, it's the communications that I think would be appropriate, but that's part of Ms. Clenney's.
And they have access of that through Ms. Clenney's material. Also, Judge, the argument that she may have discussed her relationship with Mr. Obumseli with her parents, and therefore the state should be allowed to see that, again, creates a very slippery slope, because you're allowing private data of parents who are having communications with their child about their relationship to be looked at because they may indicate their feelings one way or the other. There's this homicide is being prosecuted as a heat of the moment second-degree murder. So any discussions that Courtney Clenney had with her parents about her relationship is trying to shoehorn in something that's not going to ultimately be relevant or admissible.
Which is, again, not your purview necessarily.
Fair enough, Judge, but while I'm trying to protect my client's privacy interests, I'm addressing the state's argument to say, hey, they might have talked about the relationship, so we should be allowed to look at that.
I'll give you one last comment on that.
So, Judge, specifically to that point, defense says that there's a privacy interest between conversations with themselves and their daughter. That's just not true. That's not protected by Florida state law, not protected by federal law. And specifically now you're bringing in a party to this dispute. Marital spouse, if we want to talk about those communications, that is the only protection that could pertain here. But once Courtney's a part of it, that is waived when it's brought to another person. So the discussion that they want, the question here is relevance, and that's what they want to argue. And that's really the only thing they can argue. It can be completely relevant, which is why when that relationship is going on, which is why the beginning of the warrant was the date that it was. So yes, that's what every search warrant is. If we knew that every conversation was in there, then yeah, that's great. But realistically, you're saying, hey, we have probable cause, a crime was committed. This is the parent. These are communications that were had after the fact. We want to ascertain their communications before the fact. So this is very normal in the sense of all search warrants ascertain a specific amount of data for specific purposes. These communications now, even limited by the court, I think may go too far. We respect the court's ruling and we'll abide by those. But at the same time, it is relevant.
I'm going to stand by the 2021 date. So if you could draw up the order.
I will, Your Honor.
And, the bottom line is, as to Courtney Clenney's iCloud, it's all still fair game with the dates that are in the search warrant itself.
I understand that, Judge. And that's...
Yeah, and Judge, are you allowing the state to look through everything or just communications? And just very briefly, Your Honor, I was not making a privilege argument. I was making I was making a privacy argument.
Right.
But again, I guess my question to the court for purposes of this order, the state's arguing that they need these communications.
It's limited to communication.
Okay. All right.
Judge, I would argue that financial records matter as well. I mean, there's an argument here, Judge, that specifically Mr. Obumseli was, for lack of a better term, leeching off Ms. Clenney throughout their relationship. She's getting money from her parents.
Turn into a telenovela. Okay, so that's the issue.
So,
let me just say this. If during the course of your investigation, now that you're able to go through everything, that we're back to where you're able to do that you need to revisit something that's part of the court's ruling, then you'll do it. But as we sit here today, it's communications.
So, Judge, and that's why what I'm talking about now is during that argument hearing, throughout that entire transcript, the defense argued that Mr. Obumseli was leeching off, which is why he's back at that apartment. we need to be able to ascertain, because she's not making the money that she's making at the time of the homicide for the year before. So that's why financial records are going to say, hey, Kim is sending money to their daughter for those during those purposes. So financial records are relevant for this purpose. And that's why, this is, defense is asking for everything that, other than conversation, but other things that are inside of this iCloud are pertinent to this, including medical records. They may be in receipt of medical records. Courtney Clenney, who actually claims that she's been a battered spouse. So this is important. And to limit us to be able to obtain these items that could be there is a problem. So, Your Honor, we'd ask for the date range with everything. Defense has it. They should be able to tell the court, hey, Your Honor, this is here. They shouldn't be able to look at that.
But I think Mr. Pontrodomo's argument was that, private citizens should not have to tell the government what they can and cannot look through when you're not a party to a case.
Right, and that's why we come here, Your Honor, and it talks about specific disclosure of those items. So they have it, and that's why they have possession of it. They should be able to tell the court, you shouldn't be able to look through this because this in fact exists, and we have an interest in this. Then we'd be able to actually have an intelligent argument with the court to say, Judge, this is why this is relevant to us. To now blanketly just say, medical records. That's not what this statute is meant for. And that's the problem that we're here now, is that they're blanketly asking the court to cut out everything for that date range. So, Your Honor, the date range itself, we'd ask for everything in there. We're happy to provide a copy to Mr. Pontrodomo. If he's arguing that we don't have an interest or their privacy interest trumps something, again, that's why the team is here. So this is something that I think, again, it's putting the cart before the horse. It's something that can be handled throughout this process. And now to sort of blanketly say, state you can't look at anything but messages, now cuts out potential evidence that is more than relevant and may come into this trial.
So essentially, Mr. Abuhoff, you would suggest that the court rule that the date range that I know you're not in agreement with the date range, but it is what it is. That all of the property that is contained in pages 2 and 3 of the affidavit in support of the search warrant be allowed, notwithstanding whether it has to do with communications.
Correct.
Mr. Pontrodomo, any last word? I actually think I'm revisiting that at this point.
Well, Judge, if you're revisiting it, then yes, absolutely. I think the state's argument is essentially shifting the burden onto private citizens to prove that they have a privacy interest in the data that they want to look through. That's just not how the constitutional amendment works. It was very much designed to create in private citizens a robust privacy interest. To say that we think there may be something of relevance in here, and I frankly admit, I said this with all due respect, Mr. Abuhoff, I think the financial argument's a bit tenuous at best. It was originally raised as, like Your Honor pointed out, as an issue of whether Ms. Clenney was a risk of flight. So going through private financial records for which my client's interests are protected doesn't have any relevance to a second-degree homicide trial, and trying to shift the burden onto us to tell the state what we think is private in our private material is not the right calculus for this court. They should be able to tell Your Honor, this is why we think this, and point to, with some specificity, I get that they need to review evidence and items that they receive from a search warrant before they can decide if it's going to be relevant to the trial. But there needs to be at least a certain amount of specificity. Your Honor saw this warrant. It simply listed everything that's included in iCloud data. So I think asking us to then tell them what they shouldn't be looking at is shifting the burden onto us and making private citizens responsible for telling the government, here's what you can't see.
And I think I would agree with you 100% if the taint team was not in place in this case. I think that is the safeguard at this moment in time. So
may I respond to that?
Yeah, go ahead.
So again, I have to bring this point up because, and Your Honor, the Article 1, Section 23 states every natural person has the right to be let alone and free from governmental intrusion into the person's private life. The taint team are members of the state attorney's office. They are the government intruding into my client's private life, who are not charged with a crime. They were, but that was folly and dismissed. So partly because they invaded privilege. So there's all sorts of problems here. They have a right to be free from governmental intrusion. The issue of the taint team is more for the trial against Ms. Clenney. Kim and Deborah have a right to not have random members of the state government look at their private data. That's what the amendment is for.
I'm going to rule that from 4/1/21 to 8/26/22, the protective order is granted. It will solely be as to communications at this point for that period of time. In the course of your investigation, if you wish for the court to revisit that, then you may do so. But at this point, it is limited to communications.
Judge, may I ask for clarification on the communications? Is it between my clients and their daughter or any communication with anyone? Yes. Doctors, lawyers?
Yes.
Okay.
Judge, so just so that I'm clear, so as it pertains to your warrant that you signed initially, is Your Honor ruling that it was overbroad? As it pertained to
Kim and Deborah Clenney.
And then when it comes to the items that are sought, is it Your Honor's purview that the standard for obtaining a warrant is what the defense has said that it is here? Whereas, in reality, the question just comes whether there's probable cause to believe that relevant evidence should be discovered during these searches. Because
now we're 4 years later. We recognize where we are procedurally, and as it comes to the two private citizens that are at issue, it's a very different calculus than it was back in November of 2023.
But it's not though, Judge. The only difference is what we're effectively here for is now a motion to suppress because the items have already been obtained. So the question would be whether or not those items, and that's why they can limit the discovery of it in some respect, but we have our own interest in our own property. So those iClouds that the court has maintained possession of is the state's property in and of itself when we obtain those items. So that at that point, we're no longer in this world of 3.220 as it pertains to a protective order for the state because it already has it. Where we are now, and that's where the argument is that it goes to the public disclosure of it. The question of whether or not we can now look at it goes to a motion to suppress. And now that's why this is the standing issue in and of itself of whether they can raise this under this statute. So with that in mind, we have to ask the court at least to lay out its argument here that this is not the avenue where it is, just with whether it's on record or in a written order, because this slippery slope now allows for any defendant to say that someone that's not arrested can now say, you can't look at my records other than communications with this person.
But that's when there's a reasonable suspicion to believe that a crime has been committed. That doesn't apply to Mr. and Mrs. Clenney.
But it does as it pertains to evidence of a crime. And that's the issue, is when we're talking and discussing the nature of a relationship, a lot of things become pertinent. And that's the problem here. That's why I have no issue with the court limiting the dates. And perhaps that's something we could have done before, but limiting the dates to what Your Honor did, but then to limit the evidence within those dates, that's, Your Honor is effectively saying we don't have probable cause to believe that any of that could lead to evidence of a crime. And I just think that's a slippery slope.
I can't think of a reason right now why that would, because you're prosecuting this as a heat of passion crime. So,
No, Judge, we're calling this a second-degree murder, where specifically she is reacting as nature, as part of their relationship over time, over the 18 months of this that boils over. So what the state would argue, she now stabs him in the chest. Defense now wants to call it a heat of passion crime, but this is a buildup throughout it. And there's
so Mr. and Mrs. Clenney's medical records would have something to do with that?
And I'm not saying that that specifically wouldn't, but your order, Your Honor, cuts out everything else, including the medical records. But that's why I can't even tell you if it's on there, and that's the problem. The problem is right now, if Your Honor wanted to look at the iCloud dumps itself and lay out specific items, fine. The only person who has knowledge of what's on those iClouds is the defense. And they haven't put anything in front of the court to say, by the way, there are medical records on them. They said the likelihood of it.
I put that on the record. I'll put that on the record.
Okay.
Yeah, it's an iCloud account.
Everything's there.
Everything's on it.
That doesn't, no, that's not how this works.
I'd say,
But this is,
I've got a packed courtroom full of people who are waiting. It's now 9:52. If we need to litigate more, we can at the end. But I thought I had ruled. And I think new issues are now coming up.
Yeah, and Judge, what I'll do is I'll draw up an order in accordance with Your Honor's ruling. I would suggest if the state finds something in those communications that allows them or leads them to believe that there's additional information out there, that's how an investigation should progress. And then we can readdress it with the court.
But Judge, so I would ask that we recall this case at the end of the calendar.
Continue to argue?
Yes, I would ask that this be brought up at the end of the calendar. There's still more.
I am restricted in my time, Judge, and I understand the court has ruled.
Yeah, I think
just as Your Honor was rethinking your ruling, and then they had a final conversation, I have now asked Your Honor, and Your Honor, now there's more topics to be discussed. This is a slippery slope, and this is a big problem, Judge, because at the end of the day, Your Honor granted probable cause for an entire range. Your Honor read through that warrant, found that there could be evidence to suggest of a crime to support that crime, and now Your Honor is rethinking, saying it was overbroad. Fine, but the idea to limit what the defense says could be on there, the idea is that that's not our burden to show. The idea is to say that there could be evidence of a crime. If they want to come before the court and say, Judge, this specific item is here, we'd ask that that now not be allowed. That's different than what is happening.
I don't agree with that.
Okay.
So here's what we're going to do. He's going to draft an order. He's going to show it to you. If it comports with what I've said right now, fine, I'll sign it and execute it, and you can move for a rehearing.
Thank you.
All right, we're back.
Thank you.
4/16, but I wouldn't mind having a date before that.
That's a sounding date, Judge.
Yeah.
Can we do please don't do a status
Yes.
date for that in maybe early April? We have some depositions coming up end of March, beginning of April, but there's a lot still to do, and I think it would be helpful for us to do a status.
How about 4/1?
Can we do after, because we have depositions through 4/3, so can we do it after 4/3? Because that'll give us an idea to tell the court who showed up, who didn't, and
the problem is that's going to put us on
that's right.
Yeah. So it would end up being like 4/10.
No, I understand. 4/1 was good, Judge.
Okay, 4/1.
4/1 is that amount?
It's a
Wednesday.
Yes.
Your that was at 1, so we're
all right. Thank you. Have a nice day.
All right, so you heard the judge 4/1. That's April 1st. So let's get to that one. All right, this will be the last. This is the last hearing. This is literally, as far as I know, the last hearing before she took a plea. So it's plea is going to be Monday, and we're going to go on at 8:45 Eastern, 8:45 a.m. Eastern. So we'll be going on a little bit before to talk about this. All right, so this is the last one of the night. I'm going to play a brief news clip after this. So if you haven't had a chance yet, please hit the like button. We are at 315 likes. So if you are out there and you're not in chat, just take a moment and hit the like button. We also have a poll going. What will Courtney's sentencing be on Monday? We have judge rejects the plea, which would be 16 to life. That's for second degree, minimum of 16 and a half years. I have a 1 to 5, 6 to 10, and 10 to 15. Involuntary manslaughter, which would be the one next down, that's up to 15 years. So, and don't forget, she also has 4 years time served. So I don't know if you're going to include that in your calculations or not, but those are the choices that we have for our poll. All right, this is from April 1st. This is the last, as far as I know, this is the last pre-trial hearing before she decided to take a plea deal. All right. So this is from April 1st, 2026.
The state is not ready, Your Honor. The civilians witness unavailable.
Is this on the further, Darlene? I didn't sign it yet. Did this defendant AC for a long time or impeach?
He was on loan, Your Honor.
Say it again?
He was on loan.
On loan. Okay, are you ready, Mr. DeCoste?
Your Honor, my client doesn't want to resolve the matter. Is Your Honor no longer doing calendar tomorrow?
No, I am.
Would it be possible to have him set to be transported tomorrow? He called me early this morning and said he wasn't transported today.
Plea 4-2, and we'll determine if we're going to roll it for trial that day. Defendant should be brought tomorrow.
His previous offer was 2 years state prison. He does have a considerable amount of time, about 19 months in custody, and he is wanting to resolve.
Okay, very good. We'll see that one tomorrow. Andrew Brinson on 32. State, will you be ready for 20?
The state is not ready, Your Honor. Both officers have reached the end of their service and we're looking.
Okay, Mr. DeCoste?
Admittedly, Your Honor, I had this on for sounding up at 9. Did we collapse another sounding today?
Yes.
I don't have the notes on it, so I can say that I'm not ready. It is a random one.
Okay. Joint continuance, no further continuances for either side, 521-61.
Your Honor, could I ask for this not be put on the no further? I've just taken over this case.
It doesn't seem to be all that complicated, and I'm giving it an almost 2-month reset.
Understood.
Okay.
And for the record, back on page 30, it was a no further on the various federal.
Okay, hopefully he's going to take the plea tomorrow. Yeah, thank you. Page 33, Jonte Jonas. State?
The state is ready, Your Honor.
Defense?
Defense is not. Client is in New York. Client doesn't want to accept the plea. He's not able to travel down for his court setting. He's hoping for the end of the month of April, to travel down and take the plea.
Okay, very good. Defense continuance. Can I have a plea date at the end of April?
Yes, Judge. 4/29.
Does that work for you, Mr. DeCoste?
If we do the 30th, that would be better.
4:30 for plea. Page 41, Suyin Sanchez. Will the state be ready for trial 420?
State's ready, Your Honor.
Defense?
Not ready.
That's a defense continuance, 521-61. 42, multiple cases, Glian Cotilla. State?
State is ready on both, Your Honor. I would note for the court that...
More than a couple minutes? No. Okay, because I was going to say I was going to take a quick restroom break, but I can wait. Page 6, Courtney Clenney.
Yes, Judge. Sean Abbott on behalf of the state.
Good morning.
Freedom of Lee.
Good morning, Your Honor. Frank Plea on behalf of Ms. Clenney.
Good morning, everyone, and Ms. Clenney is present. All right, I'll hear from the state.
Yes, sir. So we've had, I want to say closer to 15 or 16 depositions scheduled throughout this week. We had, frankly, so far none of them appear yesterday. Today we anticipate at least one of the group coming. And then throughout the week, maybe a couple more. But at least for the first round, these are all Williams Rule witnesses and trying to make them available. That obviously is important as we're moving forward and making sure that this case can be tried by both sides. So at this point, from the state side, because I haven't been able to avail all of these witnesses for the defense, I'm asking for at least a state continuance. If the defense would like to join in making it a joint continuance, that would be fine.
Okay, Mr. Prieto or Ms. Puglisi?
Judge, we clearly, based on the failure of these witnesses to appear and the work we have remaining, we would join in the continuance. It would be disingenuous for us to say we're not ready.
Let me just ask, I mean, if we're in this same position the next time we come back and these witnesses are just not appearing, I mean, there's going to have to come a time when it's fish or cut bait, right? Like you can't go forward with the Williams Rule witnesses that you would like then, right?
Then there are certain things in our motion that we either will have to withdraw or make sure that the witnesses are here.
Okay.
And Judge, I think it's fair to say that we're asking for a joint continuance and like a trial date, but I do think it's good for us to do the status updates like we've been doing, just to stay on top of everything, which we've been trying. There's a lot to get done. We also need their expert to meet with Ms. Clenney, so we're working diligently to try to get it all done. But
can we set it for status 5-1, 30 days from today? Does that work?
That's great, Judge. And a trial date, when we were talking it out, we were thinking August.
Okay.
I know it's tough with June and July and vacations and summer and everything like that, so I don't know what the court schedule is.
Come sidebar real quick. All right, so back on Courtney Clenney, page 6, it will be a joint continuance. I think I said it previously, but you know, this really has to be a final continuance, and we're going to work toward probably something I would say maybe in the third week of August, something like that, but I need a little bit more time to go through the court's calendar, so 5-1 for status. Anything else, Mr. Abuhoff? Mr. Prieto or Ms. Puglisi?
Judge, thank you.
Don't you show on for mandate today yet?
For what?
The return of mandate for the appeal was already that was taken by Mr. Pagidomo was handled regarding the parents' personal information.
Right.
So I think the mandate return.
What's a firm?
Yeah, I thought it.
It was PCA.
Yeah, but did I ever sign the order on that?
It was never provided to Your Honor yet. I think he's still working on it.
Okay, yeah, that's why I thought that mandate had already came. Yeah, so that, don't put mandate anymore on that. 5-1 status, thank you.
Thank you.
Mr. Gababell, were you able to take a look at that unavailability of Brianna Sands, page 9?
Yes, Your Honor, I was. It seems like it is filed from 4/6 to 4/17.
Okay.
He indicates in his notice that he's not going to be available anytime proceeding from 4/6 trial, so that would be why he's not here today.
421 for status.
Judge, I apologize. I know it's not that I have to recall Mr. Allen. We can just put the second copy. Okay, great. Thank you, Judge.
All right, so that was just basically about a bunch of depositions. So that was an error, and that was really not much of a hearing. Aaron reminded me that there were definitely more hearings, but they were like via Zoom, or they weren't streamed, or they weren't uploaded to YouTube. So I tried to find all the ones that I could find. I'm sure there's maybe one or two out there that I wasn't able to find, but I thought that I was able to grab as many as far as I could tell. I grabbed them all, but I'm sure there's one or two out there that slipped through, or maybe not. Maybe I did get them all. All right, so finally, our final video of the night. Then that will conclude our 2-day deep dive into this. So, Dottie Forgotti, welcome in. Love your handle. All right, there is no trial. She's going straight to the plea. Yes. So all of this, the last 4 years, she got arrested back in August 10th. August 10th, she's arrested, and then her sentencing, or her plea, possible sentencing, well, she will be sentenced, is August 10th. So literally 4 years to the day she was arrested. And all of these pretrial hearings, all this stuff, and she decided to plead out, and now the judge has to accept her plea. So we're not quite sure. We know there's definitely going to be victim impact statements tomorrow on both sides, I'm sure. I'm just not sure how much evidence and testimony is going to come in. I personally would love to see the medical examiner, or hear from the medical examiner, maybe a couple law enforcement, first responders. That's who I would like to hear from. Jennifer, can the judge reject the plea? As far as I know, they can. The judge can say, yeah, no. I think the judge can reject it. Probably not likely, because the family is on board, and that's what I'm going to play next. I put in our description, if you guys are new to us, I see a lot of you are new to our channel. We spend a lot of time on our graphics and on our description. So if you have any questions, always go to our description. So in there was a statement from the family's attorney, and that's what I'm going to play next, is a news clip on, I think it's this. But they say, basically, on behalf of the Obumseli family, I am pleased to announce that Defendant Courtney Clenney, the state, and the Obumseli family have reached a resolution that would avoid an unnecessary trial. That resolution will be made public at a sentencing hearing on August 10th at 10 a.m. They say 10 a.m., the docket says 9. We're going to go on at 8:45, so we'll see. So we don't know what this plea was, so that's why it's going to be made public. So pleading guilty and accepting full responsibility will begin the process of bringing closure to a very tragic, life-changing event for the Obumseli family. So she's charged with second degree. It doesn't make sense to plead to second degree, because then if I was me, I would just go to trial and roll the dice and hope that I got a lesser included, or I was found not guilty. So to me, that's why I think she went down to involuntary manslaughter, which would be the next one down. As far as I can tell, it's first degree, second degree involuntary manslaughter, which from what I could see is up to 15 years. So that's why I'm leaning towards involuntary manslaughter, because she didn't mean it. I think you could argue both ways. I know a lot of you think she did. Some of you think she didn't. She already has 4 years time served. So whatever her sentencing is, knock off 4 years. So, if she does get that involuntary manslaughter, it's up to 15 years. This is her first time offense. Well, actually, she has been arrested for DUI. Well, she's never been charged with a felony. Let's put it that way. So they might start her off at like 10 years and then time served. And then, but apparently the Obumselis are okay with this. So as much as I'm like, ugh, she could literally walk out of there with like time served, not spend any more time. She could walk out free. That's a possibility. As crazy as that sounds. Again, I'm not a lawyer. I'm just speculating, but it could possibly happen. All right, let's get to this is the Obumseli. This is a news on the Obumselis and this plea.
Family of Christian Obumseli is speaking out one day after his girlfriend, OnlyFans model Courtney Clenney, announced she will take a plea deal in his killing. Clenney is accused of stabbing Obumseli to death inside their Miami apartment. CBS News Miami's Nakaya Carrero is your reporter in Miami, as the model will soon learn her fate.
The family of Christian Obumseli have been grieving their son's death since April 2022. Through their attorney, they released a statement about Clenney's decision to take a plea deal in the courthouse behind me. In less than 2 weeks, Courtney Clenney is scheduled to sit inside a courtroom to learn how much time she will have to serve for the death of her on-again, off-again boyfriend, 27-year-old Christian Obumseli. His family's attorney released a statement Saturday that says, "I am pleased to announce the defendant Courtney Clenney, the state, and the Obumseli family has reached a resolution that would avoid an unnecessary trial." It goes on to say, the resolution will be made public at a sentencing hearing on August 10th at 10 a.m. Pleading guilty and accepting full responsibility will begin the process of bringing closure to a very tragic, life-changing event for the Obumseli family. This comes one day after Clenney's attorney made the announcement that the OnlyFans model would not be going to trial as planned. Her attorney said in a statement Friday, the terms of the agreement are not final until accepted by the court. Ms. Clenney, 30, has been in custody since August 2022 in connection with the April 3rd, 2022 death of Christian Obumseli at the Miami apartment she rented. We will reserve further comment on the specific terms until they are placed on the record before the court. Clenney is charged with second-degree murder after she allegedly stabbed Obumseli inside an Edgewater condo on April 3rd, 2022. This video shows an alleged confrontation in an elevator between the pair 2 months before Obumseli's death. Evidence released since Clenney's arrest has painted a troubling relationship between the couple. I reached out to the Miami-Dade State Attorney's Office after the news broke about the plea negotiations. They could not comment due to this being an open, ongoing case. In Miami, Nakaya Carrero, CBS News, Miami.
All right. So there you have it. There you have it. Nobody knows. Well, they know, but none of the outside public knows what this plea deal is going to be or what the terms are of the plea. So we will all have to tune in and find out on Monday. So, Debbie, thank you so much. I hope you have a nice, relaxing weekend as well. I will be doing some yard work on Sunday and hopefully getting my car AC fixed on Saturday. So those are my plans. Deb in Indiana says Courtney definitely made the right decision. Horse welfare, yes. Everybody saying good night. Definitely be well, and thank you guys for joining us today. Jamie, yeah, she can walk out on a GPS. There will probably be probation. Yeah, she'll probably be put on probation too. I mean, there is a scenario where she could walk out. There is a scenario. Not sure if that will happen, but there is a scenario. So, all right. Thank you. All right, Kaylee. Thank you, Shannon. Have a great evening. Thank you guys so much. Horse welfare. The similarities and the parallels of Johnny Depp and Amber Heard are just absolutely frightening. Absolutely frightening. Very toxic, both of them. You know, they were drinkers. I'm not sure. We know Amber and, you know, Johnny definitely did more than just drinking. I don't know what was going on with Courtney and Christian, but we know that they definitely, alcohol was involved. They were taking videos of each other in the middle of, you know, of these incidences and fighting and all this stuff. So Johnny's lucky. I told Aaron that a couple times. I mean, he is so lucky to have gotten out of there without any more damage, and unfortunately Christian was not so lucky. So all right, you guys, thank you guys so much. All right, I'm gonna let you guys go. Thank you again for joining us. As always, we give you Super Ball here to say goodbye. Hi, Super Ball. Come say goodbye. Come say goodbye to everybody. Yeah, good girl. Okay. Yeah. Good girl. All right. That's our little Super Ball here. Here, look over here. Here. Yeah. Good girl. Oh, and then there's Roger over there. And we got Paulie back here. Everybody's getting in on it. Poor Roger. All right. Good girl. All right, you guys. Again, thank you so much for joining us. Really appreciate you spending your day with us. We've spent the last 2 days looking back at Courtney Clenney and Christian Obumseli and how we got from there to here on Monday. And really appreciate you guys joining us for those past 2 days. And please join us. Monday we'll go on at 8:45. And whenever the hearing starts, we'll be ready. We'll be ready. So take care of yourselves. Thank you to our mods for keeping our space nice and respectful and courteous. And thank you to Erin for the graphics and videos and all that she does. So with that, I will let you guys go. Enjoy your weekend. Make sure you do something positive for yourselves, and we will see you on Monday. Take care, guys. Bye.